ಕೋರ್ಟ್ ಆಫೀಸರ್ ಕೋರ್ಟ್ ಆಫೀಸರ್ ಬನ್ನಿ. ಹಾ, ಕೇಳಿಸ್ತಾ ಇದೆಯಾ? ಕೇಳಿಸ್ತಾ ಇದೆಯಾ? ಹಾ, ಥ್ಯಾಂಕ್ ಯು ವೆರಿ ಮಚ್. ಈ ವಿಡಿಯೋನು ಬಂತಮ್ಮ, ಥ್ಯಾಂಕ್ ಯು.
Appeal the memos. Well, its appellant has deposited the amount, my lords. Matter may kindly be taken up for release of amount, my lords. We've also filed application for release of the amount.
How many times will you leave the message? Missing, they will send it.
The lordships kindly, my lords.
Only we have said, final hearing, new matters, we cannot take up.
Fresh matter, my lords. Filed it on my lords 15th. Conviction appeal, my lords 302. Circumstantial. Fresh matter, my lords. Since 15th, my lords, it has not been, my lords. Scrutiny is also not.
Not correct.
Please.
Permission. One MC matter, parties are ready to, my instructions are there, ready to compromise. Maybe listed tomorrow.
Your compromise petition is ready.
It's of 23 final hearing matter.
Huh?
MC matter.
If they are settling, okay. But settlement, because we are seeing in some cases, we listed for settlement, they do not turn up. Where is your compromise petition? Show us. Then our compromise petition tankotaga list ಮಾಡ್ಸಿ ಅದನ್ನ.
RFA 380.
Yes, you file the compromise. You show us the compromise draft, then we will list it.
My lord, this court had directed both the parties to be present before the other.
They have filed the compromise petition.
Compromise petition.
But you said they are settling the matter.
They are settling, my lord. In fact, this court had directed earlier, previous bench had directed both the parties to be present.
Huh.
One or the other reason.
And then
my lord,
first you said they have settled the matter.
Yes, ma'am.
Then you file the compromise petition, list it ಅಂತ ಹೇಳಿದ್ವಿ. ಈಗ now you say that court had directed to appear. Final hearing will not list them. If you file the compromise petition, we'll list them.
Lordship,
Show us the draft.
My lords, the child is a 4 years old child, my lord. And after the appellant has filed divorce petition,
Matter means new matters in the final hearing. Yes.
the respondent is not allowing the appellant to meet the child, my lord. And it's only a 4-year-old child, my lord. So it may be taken up tomorrow.
What is the order of the trial court?
It's dismissed on the ground that the evidence produced by the appellant was not sufficient.
Petition was filed by whom?
By the appellant, my lord.
Who is he? Father or mother?
Mother, my lord.
Huh?
And
Mother.
Mother, yes, ma'am.
No visitation is also.
No, my
given?
lord, nothing.
Okay.
And tomorrow, my lord.
Lordship, RSA 380/223 as special assignment ಇದೇ ಕೋರ್ಟ್ಗೆ IA number 1 stay order ಇದೇ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಆರ್ಡರ್ ಆಯ್ತು.
ಬರೆದು ಕಳಿಸಿ ನೀವು subject to compliance ಅಂತ.
Subject to compliance.
File ಆಗಿದೆ ಅಂತ ಹೇಳ್ತಾರೆ.
My lady, this is a case from 2019. Ex-parte, monogamy thing has been dismissed, ex-parte, and she is indigent. And, I'm representing her. Yes, MFA.
MFA, which matter? Matrimonial case?
Yeah,
It is dismissed by the trial court.
beg your pardon?
It is dismissed by the trial court.
A trial court, yeah.
It
No,
is-
trial court, the husband has filed saying that it is monogamy. And, she has been cheated in the sense, through,
But you have participated in the proceedings.
no, it is ex-parte because she is in
She-
Bombay.
ತಗೊಂಡ್ ಕಳಿಸ್ಕೊಡಿ.
And if this can be considered.
Lordship, RFA special assignment matter, Lordship. This honorable court interim order. The respond appellant file modification in the interim order, Your Lordship. Last time ಬಂದಿತ್ತು January after at least 2 weeks ಅಂತ ಆರ್ಡರ್ ಆಯ್ತು. Please.
RFA 23.
23 ಅದೇನೋ modification ಅಂತ ಹೇಳಿ.
ಅಲ್ಲ ಇವ್ರ ಮುಂದೆನೆ ಬರ್ಬೇಕು ಅಂತ ಆರ್ಡರ್ ಇತ್ತು. ತೋರಿಸಿ ಮಾಡಿ.
Special order ಇದೆ ಅಂತ
Special
ಹೇಳ್ತಾರೆ.
assignment matter.
It pertains to case.
ಬಂದು.
Adjournments.
ಸೋಮಶೇಖರ ಸರ್.
You, everyone wants us, you to hear, to be heard on memos only.
Husband was placed expert in trial court as well, even notice was issued and he has not represented him.
Hmm.
Trial court will not, even in spite of holding the two issues.
Not arguing on the merits.
No.
Her petition is dismissed by the trial court.
No. The trial court has held cruelty and the adultery count as effort.
Please simply say, is it wife's appeal, husband's appeal? She was
Expert dismissed.
right. Well, now it is for final hearing. For which year? It's of which year?
24 only.
ತಗೊಂಡು in the order of seniority ಅಂತ ಬರೆದು ಕಳಿಸಿ.
Adjournments. Page wise. Page 1.
ಯಾವುದು 2020? ಅದನ್ನು ಅಷ್ಟೇ ಆರ್ಡರ್ ಆಫ್ ಸೀನಿಯರಿಟಿ ಅಂತ ಬರೆದು ಕಳಿಸಿ.
Adjournments. Page wise. Page 1, seal number 1 to 3. Page 2, seal number 4 to 6. Page 3, seal number 7 to 10. Page 4, seal number 11 to 14.
Number 13, my lord. You have to reach time.
Serial number 13, that is the last serial
Page
number.
4.
We were in page 4 now. Serial number 13, furnishing PF, etc.
Each time is granted. Second time is. First time is order.
13, at request 2 weeks time is granted to the needs. Yes.
Page 5, cell number 15 to 17.
Serial number 17, my lords. Lords, the respondent number 2 is dead. I want to file it, the parents of the respondent number 2 want to file application to implement themselves as the LRs of the respondent number 2, my lords. Kindly a week time may be granted.
Where is the application?
And the claimant that is the father of the deceased, right?
No, application is pending.
That deceased person not to
No, it appears application is not listed.
No, I have to file application, my lords. It is
You
ready.
have to file application.
I have to file application. It is ready, my lords. I'll
You
file it.
also represent the parent, heirs, wife and who are the claimants?
Claimants are parents
Hmm.
and one
Sister, you are,
I am the legal heirs of the respondent number 2, who is the claimant, a father of the deceased.
other, he's respondent number 2's father.
The father of the deceased died,
Hmm.
and they are the parents of that person. That they want to come.
Father of the deceased died and grandparents want to come and record. There. You have not filed, yet file application.
I have to file, my lords.
As requested. Then even without filing the application, what right of audience you have?
My lords, I am filing it today, my lords, because
Correct, what right of, you have the application ready?
yes, my lords, I have.
Show us the application.
I have to file it in the counter, my lords. I kept everything.
As requested, list down. And in there, so and so, Srimati so and so.
Sandhya D.
Submits that respondent number 2 died and she is filing application on behalf of his legal representatives to come on record during the course of the day. List on.
Next.
We followed, madam. Respondent number 2 is dead and the head tare or bartare anta nodu.
1-4.
Serial number 54, my lord.
Sir, page wise. 1-4. Page 6, cell number 18 to 20. Page 7, cell number 21 to 25. Page 8, cell number 26 to 32.
My lord, serial number 30, my lord. Place for a short. 30.
You are for the claimants, no?
My lords, appellants. 30, my lords. 30 both. Criminal appeal.
30.
Please, for suspension of sentence.
That is criminal appeal, okay.
Please.
Adjourn at the request of, don't move again then. Adjourn at the request of the appearance counsel. Yes.
Page 9, cell number 33 to 38.
Lord, you have 34, my lord. Insurance company has sent the wakalat.
Yes,
My lord, you have 34. Insurance company has sent the wakalat. It has not reached my hands. Probably in a day or two, I will get it. I will file the
Correct.
wakalat.
see if TCRs are received. Admit
Yes,
ಮಾಡಿ
ma'am.
list ಮಾಡೋಣ ಬಿಡಿ. We'll admit
ಆಯ್ತು.
it and then list it for
Yes,
final.
ನಂದು ಸ್ವಲ್ಪ ಇನ್ಕನ್ವೀನಿಯನ್ಸ್ ಇದೆ ಶಾರ್ಟ್
ಆಯ್ತು,
ಅಕಾಮಡಿ
ನೀವು ಇರ್ಲಿಲ್ಲ ಅಂದ್ರೂ ಮಾಡ್ತೀವಿ. It is between us and the appellant. Yes.
ಬೇಡಿ ಸ್ವಾಮಿ ನನ್ನ ಎದುರುಗಡೆ ಆಗ್ಬೇಕು.
Page 10.
You file it, it is for admission.
ಎಸ್ ಎಸ್ ಕ್ವೈಟ್ ಟ್ರೂ. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಹಾಕೊಳ್ಳಿ.
ಆಯ್ತು.
Page 10, cell number 39 to 44. Page 11, cell number 45 to 48.
Serial number 49, your lordship. Counsel for the petitioner, your
Page
lordship.
12, cell number 49 to 51.
Which matter?
Serial number 49, your lordship. Counsel for the petitioner. The senior's brother-in-law has passed away, your lordship. If the matter could kindly be taken up next week, your lordship.
As requested by the appellant's counsel, list in the next week. Yes.
Much obliged, your lordship.
Page 13, cell number 52 and 53. Page 14, cell number 54 and 55.
Serial number 54, my lord. Raise time, my lord. 2 weeks time may be granted. My senior is not keeping well.
Whom do you refer?
For the appellant, Chandan, appellant.
ಯಾರಾದ್ರೂ ಅರ್ಜೆಂಟ್ ಅಂತ ಏನಾದ್ರು ಹೇಳಿದ್ರ? It's for
By
final
order
hearing.
dated 28, appellant.
Have you
present.
informed the other side?
Oh, my lord. No,
You inform and come back, we'll adjourn it.
please.
Fraudus, cell number 1, Maruti Prasad essay.
Memo dated,
Srimati Sujata ji.
memo dated 1/3/2025 is filed by the counsel for the appellant along with the copy of paper publication. Not ಮಾಡಿದಾರ. ಅವ್ರು ಕೊಡ್ತಾರೆ. Along with the copy of the paper publication regarding notice having taken by substitute service in one edition of Vijayawani, Mysore edition, dated 13/2/2025. Same is taken on record. Remarks
Srimati Sujata ji.
called out absent. Service insufficient.
PCRs are also received. Now, sufficient. Finally.
Please.
Cell number 2, SV Hegde Mulkan, 80.
My lord, I appear for the appellate, my lord. Appeal of the insurance company on the question of quantum and negligence. And my lord, I have taken up notice to the respondent number 2. My lord, the notice is awaited, my lord.
My lord,
And trial court records were also received. My lord, may kindly after a service of notice,
Notice of R2. ಯಾವಾಗ issue ಮಾಡಿದ್ದಾರೆ notice?
owner of the vehicle, my lord.
Correct. We'll see when the notice was issued.
20th March.
let us pay for the respondent. One humble submission, my lords. They have deposited 80 lakhs, out of which your lordship was pleased to release 40 lakhs, my lords. The boy is suffering on 23/3/23. Lordship may please to order for release of the balance amount, my lords. It's nearly 2 years.
And already part of it.
Yes, my lord.
Then
No, my lord, the boy is suffering, is 24 years. He's one of the 17 people in India who's afflicted with such kind of a disease after the accident.
52 lakhs. You must have taken substantial amount now.
40 lakhs we have taken, my lord. The other 40 lakhs is there. Your lordship may please to release, my lords. Because of 1.6 crores is the award.
What is the disease suffering?
1.6 crores is the award, my lord.
What is he suffering from?
He met with an accident.
What is he suffering from, sir?
Accident.
Several
Case of
diseases.
They come here.
Yes, my lord. He is with the diffuse axonal injury, grade 2, my lords. It is something, only 17 people in India are afflicted with
Correct.
this.
What is the effect of that? What is the difficulty?
He is totally bedridden. He cannot move about. He is on the wheelchair. He has to be given so many injections every 2 months, 3 months.
What happened to the amount already released?
It is already spent, my lords.
Already spent?
Yes, my lord.
When was it taken?
It was taken 2 years ago.
2 years. This 40 lakhs will also
Yes,
go 2
yes, my
years.
lords. It's.
What will you do thereafter?
That's what, my lords, I am before your lordships, that the other 40 lakhs may be released.
You need to give the details as to what is the requirement.
Yes,
how
my
to
lords.
spend. Give
Your
the
lordship may
details.
kindly have it next week, my lords. I'll give a detailed.
Name of the boy, there is a chances of money being misused by others.
No, no, my lords. I'll.
Give us the detail, give the doctor certificate. Let
Yes,
us see
my
what is the
lords.
requirement
Yes.
of the boy.
Lordship may kindly have it next week, my lords.
Yes. List
My
after.
lord, may I make one submission, my lord, with the kind permission of this honorable court.
Yes.
My lord, notice is awaited. After service of notice, my lord, any date matter can be
Yes,
taken
yes,
up
sir.
for.
Direct-
List after service.
List after service of notice.
Regarding.
Next
yes.
week, my lords, I'll produce the
Date for it.
7/4.
7 for much.
Obliged.
Cell number 3, Sirajuddin Ahmad, SPP.
Lordship, kindly pass for the matter, Lordship.
What is the office objection? Why the second set IA?
Recalling the order it is.
Senior is not available. Kindly pass for the matter.
It's your job to do, not your senior's job to do. Serve the copy, show the provision of law. Why do you want senior for this?
You have the file or not?
No, no.
We have to change that. You don't have file with you?
No, no.
Then we'll dismiss this.
Who is your senior?
Sirajuddin, Lordship.
ಅವ್ರಿಗೆ ಬರಕ್ ಹೇಳಿ. Ask him to come.
Sure, sure.
Passed over. Cell number 4. Ravish Penny.
Appellant, please.
Yes.
Our appellant, please. They have filed an application.
I have filed an application, but what happened, my lord, subsequent to passing of the judgment and award, claimant is died due to the injuries. Claimant was died, expired, due to the injuries sustained in the accident. Judgment is passed on 19/7/2024.
Hmm.
Sorry,
Memo for
on
dispensation.
15th September 2023, the judgment has been passed.
Request filed the memo for dispensation of
Who
R2.
is R2 here?
Memo filed by.
R2 is owner of the vehicle. it
Owner of the
says.
vehicle.
So one is dispensation of notice to R2. And what is IA3 of 24 for
That
delay?
is filed by me for impleading the LRs of.
Including his LRs.
Yes.
LRs themselves have come forward.
Yes. They have already filed an
What's the
application.
office objection on that?
ಅದು
Delay application. ಅದರಲ್ಲಿ ನೀವು prayer ಹೇಳಿದ್ರೆ ಪರವಾಗಿಲ್ಲ. We can accept that.
ಅಲ್ಲ, so far as
IA3 of 24.
impleading application is concerned,
Is it IA3 of 24? Order 1 rule 10 ಅಲ್ಲಿ.
ಆರ್ಡರ್ ಒಳಗೆ ಡ್ಯೂಟಿಗೆ ಬರೋದಿಲ್ಲ sir.
ನೀವೇ ಕೊಡಿದಿರಲ್ಲ.
ಅಲ್ಲ, ಬೇರೆ ದಾರಿ ಇರ್ಲಿಲ್ಲ ಅದಕ್ಕೋಸ್ಕರ
ಅಲ್ಲ, they can come on record even under order 22 rule 4. ಅವ್ರು ಹಾಕೋಬಹುದು.
that is they have to file an application.
Anybody ಅಲ್ಲಿ ನೋಡಿ ಆರ್ಡರ್ 22 ರೂಲ್ 4 ಓದಿ ಯಾರೇ ಇಂಥವ್ರೆ ಹಾಕ್ಬೇಕು ಅಂತ ಇದೆ ಅದ್ರಲ್ಲಿ ಅಂತ.
That can be filed by both. Yes.
Anybody can file that. It can be. ಇದೇ ಒಂದೇನ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಇಲ್ಲ.
That is the only office objection.
Proposed respondent has filed IA3. When he passed away, ranking of the parties to be correctly shown ಅಂತಾನೂ ಇದೆ ಅಲ್ಲ. ಹೌದು, ಈಗ ನೀವು 1, 2, 3 ಅಂತ ಹಾಕೋ ಹಾಗಿಲ್ಲ ಅವ್ರನ್ನ. They have to come on record as ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 1A, B, C ಹಾಗೆಲ್ಲ ಮಾಡ್ಬೇಕಾಗತ್ತೆ. ಅದನ್ನ ನೀವು ಕರೆಕ್ಟ್ ಮಾಡಿಲ್ಲ.
ಅದು ಮಾಡ್ತೀವಿ. ಅಲ್ಲ, since the application is filed under order 1 rule 10, therefore I have made them as respond number 1 and 2 and 3.
ಅವರು ಒಂದ್ಸಲ ಏನಾರ ಮಾಡ್ಬೇಕಲ್ಲ, ಬಿಕಾಸ್ ಈಸ್ ನಾಟ್ ಟೂ ಯಂಗ್. ಜೂನಿಯರ್ ಅಡ್ವೊಕೇಟ್, ಅದು ರ್ಯಾಂಕ್ ಕರೆಕ್ಟ್ ಮಾಡ್ಕೊಳ್ಳಿ ಅದನ್ನ. ಬಿಕಾಸ್ ಹಿ ಹ್ಯಾಸ್ ಟು ಅಮೆಂಡ್ ದ ಕಾಸ್ಟ್ ರೇಟಲ್ ಆಫ್ ದ ಅಪೀಲ್. ನೀವು ಯು ಕರೆಕ್ಟ್ ಇನ್ ದ ಅಪ್ಲಿಕೇಶನ್ ವಿತ್ ಪಾಸ್ ಆರ್ಡರ್.
Please, I'll mark.
We shall correct it in the application ಅಂತ ಮಾಡಿ.
Application.
ಇನ್ನೆರಡು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕ್ಬೇಕು ಅಂತ ಆಫೀಸ್ ರೈಸ್ ಮಾಡಿದ್ದಾರೆ. ಸೊ
See, it was your job to do that. He has filed under order 1 rule 10, not under order 22 rule 4. Instead of standing by formalities, we can allow the application. It was your job, otherwise your appeal against him is abated.
ಅಲ್ಲ, ಅವರು ತೀರ್ ಹೋಗಿದ್ದೆ 10/10/2023 ಇಸ್ವಿಲಿ ಬರಲ್ಲ. ಆಫ್ಟರ್ ಫೈಲಿಂಗ್ ಆಫ್ ದಿ ಜಜ್ಮೆಂಟ್, ಆಫ್ಟರ್ when appeal is pending.
Correct, ಅವಾಗ you are the appellant, no?
ನಮ್ಗೆ ಗೊತ್ತು, ಇವತ್ತು ಅವ್ರು ಅಪ್ಲಿಕೇಶನ್ ಕೊಟ್ಮೇಲೆ ನಮ್ಗೆ ಗೊತ್ತಾಗಿದ್ರಿ.
Application ಇವತ್ತು ಹಾಕಿಲ್ಲ.
ಅಲ್ಲ, ಮೊನ್ನೆ ಅವಾಗ ಕೊಟ್ಟಾರ್ರಿ, ಡೇಟ್ ಹಾಕಿಲ್ಲ. ಅಪೀಲ್ ಐ ಹ್ಯಾವ್ ರಿಸೀವ್ಡ್ ದ ಅಪ್ಲಿಕೇಶನ್
2024 ಅಲ್ಲಿ ಫೈಲ್ ಮಾಡಿದ್ದಾರೆ.
ಅಲ್ಲ, ನನ್ಗೆ ಐ ಹ್ಯಾವ್ ರಿಸೀವ್ಡ್ ದ ಅಪ್ಲಿಕೇಶನ್, ಪ್ಲೀಸ್ ಮೇಡಮ್.
Correct, even now appeal abatement is automatic. If you do not file necessary application, it stands abated. You want this to be prolonged again for this reason?
They have filed an application before the trial court. The trial court already amended the cost title after death of the.
File the application.
ಅವ್ರು ಫೈಲ್ ಮಾಡಿ ಅಲ್ಲೇ
Appeal against him.
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಅಮೆಂಡ್ಮೆಂಟ್ ಆಗಿದ್ರಿ. ಅದು
Correct, why did you file the trial court judgment ಅಲ್ಲಿ ತೋರಿಸ್ತಾ ಇಲ್ಲ ಅದು ಹಾಗೆ.
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಇಲ್ಲ, ಅಮೆಂಡ್ಮೆಂಟ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ದಾರೆ ಸರ್.
Presented by wife guardian ಅಂತ ಅಷ್ಟೇ ಇದೆ.
Now they have given to me that amended petition copy ಕೊಟ್ಟಿದ್ದಾರೆ ಟ್ರಯಲ್ ಕೋರ್ಟ್.
Subsequent to passing of the judgment and award,
19/7/2024 ಇಸ್ವಿಲಿ ಅಮೆಂಡ್ ಆಗಿದೆ.
ಫೈಲ್ ಮಾಡಿಸ್ಕೊಂಡಿರ್ತಾರೆ.
ಅದಕ್ಕೆ ನಾವು ಪಾರ್ಟಿ ಮಾಡಿ
ಅಲ್ಲಿ ನಿಮ್ ಕೌಂಟರ್ ಮೇಲೆ ಪಾರ್ಟ್ ಮೇಲೆ ಆ ಕಾಪಿ ಸರ್ವ್ ಆಗಿರುತ್ತೆ ಬಿಫೋರ್ ದ ಟ್ರಯಲ್ ಕೋರ್ಟ್.
ಅವರಿಗೆಲ್ಲ ಕೊಟ್ಬಿಟ್ಟೆ ಮಾಡಿಸ್ಕೊಂಡಿರೋ ಸರ್. ಅವ್ರಿಗೆ ಹೇಳಿದ್ದೀನಿ ನಾನು, ಅವ್ರು ಟೈಮ್ ಆಫ್ ಫೈಲಿಂಗ್ ಇಟ್ ಸೆಲ್ಫ್ ಐ ಹ್ಯಾವ್ ಟೋಲ್ಡ್ ಹಿಮ್.
The applicants are, orders number ಎಷ್ಟಿದೆ? 3 of 2024. Applicants are legal representatives of respondent number is 1, no? 1 was the claimant before the trial court, tribunal. as per the death certificate produced, he died on 28/12/2023, na?
10/10.
These are 10/10/2023. Therefore, his LRSO filed the above application under Order 1 Rule 10 CPC to come on record, to come on, to get themselves included. It was for the appellant to bring the LRS of respond number 1 on records. Therefore, the have filed the, I'm sorry, due to the default of the appellant, the above application is filed. Therefore, office objection with regard to the delay, etc., is delay and abatement of the not filing the application to set aside the abatement is overruled. Applicant's counsel shall correct the ranks of the parties in the application. Considering the the applicants represent the estate of the deceased, respond number 1. Therefore, the application is allowed. They are permitted to come on record as respond number 1A to
1D.
1E. Appellant's the application is disposed of accordingly. Appellant's counsel amend the cause title of the appeal memo and furnish the copy of the amended appeal memo.
Dispensation.
Dispensation on the yeah, we are only on the point of quantum.
Please, Bernard. Quantum. I will file the amendment application. Amendment appeal memo.
Memo for dispensation. Then 2/2024 ಅಲ್ಲಿ ಹಾಕಿದ್ದಿದೆ ಆರ್ಡರ್ ಆಗಿರ್ಲಿಲ್ವಾ ಇದ್ರ ಮೇಲೆ? 22/2024 it was listed before the court. Issue emergent notice to respondents. The appellant's counsel has filed a memo for dispensation of notice to respond number 2. On the ground that the challenge in the appeal is only regarding quantum of compensation. You have mentioned that.
Please.
Considering the same, notice to respond number 2 is dispensed with as per. List of the 2 weeks. Yes.
Still number 5.
I have also filed an application for withdrawal of the amount. Right.
Still number 5. Manjula L. Caretaker.
I'm Suman, I'm applicant for.
Modify inter-model 10/7. Yes. Who has filed application for vacating?
No, your last may kindly say the last date of order, because the application for a vacating stay is filed on the pretext of the order dated 10/7/2024, which has been clarified, your lordships, on the last occasion.
Yes, therefore there is no bar for the response.
Yes.
To execute the decree.
Yes. Now it has been admitted and awaiting for TCR. There was no deposit is made, either no single penny has been paid to the two children's.
Where is the,
Is
you
the,
had filed application for vacating. stay.
Lala, what?
Yeah, I have made the application for forwarding the memo. So the first reason, can I talk?
Just a minute. What is IA 1 of 2025? Vacating or modifying the order? This
But
was filed by you, Ravi Shankar.
On
Now,
10
now according to in the light of this order, this IA does not
does
survive.
not survive,
His application IA 1 of 2024 is still pending.
pending for stay.
What I have filed the application, now what memo, name move madidini, it is basically, I have an issue with my lawyer. So because one case, actually in family courting case,
ಫಸ್ಟ್ ಇದು ಮಂಗಳೂರಲ್ಲಿ ಸ್ಟಾರ್ಟ್ ಆಗಿದ್ದು ಅಂಡ್ ನಾನು ಯಾವ ಲಾಯರ್ ನ ಎಂಗೇಜ್ ಮಾಡಿದ್ದೆ ದಟ್ ಇಸ್ ಮಿಸಸ್ ಮಂಜುಳಾ ಅವರು.
Have you appeared before the party-in-person committee?
Sir?
Have you appeared before the party-in-person committee?
ಕಮಿಟಿ ಮುಂದೆ ಹೋಗಿದ್ದೀರೇನ್ರಿ?
ತಮ್ಮ ವಕೀಲರು ಎಲ್ಲಿದ್ದಾರೆ?
ಕಮಿಟಿ ಮುಂದೆ
Where's your lawyer?
ಲೈಕ್
Appeal is filed.
ನಾನು ಲಾಯರ್ ನ ಚೇಂಜ್ ಮಾಡೋಕೆ ಅಂತಾನೆ I have forwarded a memo, sir.
Where is it? That is, it's not necessary. If any advocate appears, we can consider that.
What the problem is, ನಾನು ಎಲ್ಲ ಪ್ರಾಬ್ಲಮ್ಸ್ ಅಲ್ಲಿ ಇದ್ದೀನಿ and because I am actually fighting with my lawyer rather than fighting the case. ಅವರು ಅಪಿಯರ್ ಆಗ್ತಿಲ್ಲ and for the high court also.
Correct, mister. If you want to engage another counsel, you engage another counsel.
Ma'am, actually for that we need that NOC. ಅದು ಕೂಡ ನನಗೆ
ಆಯ್ತು, NOC ಇಲ್ಲದೆ ನೀವು ಪಾರ್ಟಿ ಪ್ರೆಸೆಂಟ್ ಇದ್ರೆ ಪರ್ಮಿಟ್ ಮಾಡ್ತೀವಿ. ಮೊದಲು ಅಪಿಯರ್ ವಕಾಲತ್ ಹಾಕ್ಸಿ.
NOC ಬೇಕು ಅಂತ ಹೇಳಿದ್ರು, ಅದಕ್ಕೆ ಹಾಗಾಗಿ ನಾನು
ನೀವು ಯಾರಿಗಾದ್ರೂ ಅಡ್ವೊಕೇಟ್ ವಕಾಲತ್ ಹಾಕ್ಸಿ ನೋಡೋಣ. ಇದನ್ನೇ ವಿ ಕ್ಯಾನ್ ಫೈಲ್ ಎ ಮೆಮೊ NOC ತಗೊಳಕ್ ಆಗಿಲ್ಲ ಅಂತ ಹೇಳಿ.
Sure, ma'am. I'll do that. So on 1st of April, can I file the wakalat?
Party is present, appellant is present in person. He submit that despite his request.
Where is your ID proof? ನೀವು ಐಡೆಂಟಿಫೈ ಮಾಡ್ತೀರಾ?
I am not the counsel there.
Is my alarm.
Suman MLC.
I am Suman MLC.
What is Aadhar card?
Appellant and he has furnished copy of his Aadhar card
ಒಂದು ಕಾಪಿ ಕೊಟ್ಟೋಗಿದ್ದಾರೆ.
regarding his identity. He submits despite his request, his counsel Ms. Manjula L is declining to give no objection wakalat. Full stop. He seeks weeks accommodation to engage services of some other counsel. So, yavag tortira.
1st of April, I am ready.
Is this matter on 1/4?
ಸರ್ ಅದು ಸೈನ್ ಮಾಡ್ಬೇಕು ತೊಗೊಂಬನ್ನಿ. Seal number 6, Ravi S. Samprati, Jwala Kumar for R1.
Lord, I appear for the appellant. Lord, I filed a memo for dispensation of notice to second respondent.
Memo for dispensation of notice to order.
Dispensation of R to appeal on quantum, my lord.
Release of amount.
Release, I have
That,
for the claimant.
we have deposited the appeal on quantum.
So 7,95,500 is awarded.
Well, plus bonus and
$22,000. $22,000 is awarded towards loss of bonus. And some 14,000 rupees towards bonus, $14,000 and $22,000 towards loss of income during later period. This is awarded without any proof, without any basis.
How much you have deposited?
Well, at 20 lakhs is deposited. I have no objection to release 10 lakhs, my lord.
10 lakhs.
10 lakhs.
15 lakhs maybe.
Ille.
Medical expenses not.
Yes.
No, my lord, medical expenses, the doctor says that he has to incur another 60,
You are agreeable for 10 lakhs.
10 lakhs.
He is okay with that.
Please, please,
15 lakhs maybe.
It can be heard on merit.
please.
Memo dated 15/7/2024 is filed by the counsel for the appellant seeking dispensation of service of notice respond number 2. Same is taken on record. Notice respond number 2 is dispensed at the request and risk of the appellant. IA 1 of 2025 is filed by respond number 1 seeking direction to release the amount deposited by the appellant before this court in favor of the respondent number 1. Full stop.
Who want to do this?
On 1 year, 2 years.
No, he has mentioned in his application in respond number 2.
Claimant for respond number 2. They are respond number 2 na 1.
Point number 1.
1.
Respond number
ಮತ್ತೆ
1.
ನಿಮ್ಮ ಅಪ್ಲಿಕೇಶನ್ ಕರೆಕ್ಟ್ ಮಾಡ್ಕೊಳ್ಳಿ. ಅಡ್ವೊಕೇಟ್ ಫಾರ್ ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 1 ಅಂತ ಬರ್ದಿದ್ದೀರಾ, ಬಟ್ ಅಮೌಂಟ್ ಟು ದ ಕ್ಲೇಮೆಂಟ್ / ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 2 ಅಂತ ಬರ್ದಿದ್ದೀರಾ.
Missed.
The appellant has deposited a sum of rupees 20,29,045 on 12/9/2024 before the ACT Bengaluru, wide RO number 6317. Which accounts for the appellant, submit that appellant has no objection in releasing 50% of the said amount. 10 lakhs.
10 lakhs.
Has no objection to release 10 lakhs out of the amount deposited as above. Submission taken on record. Application is allowed, partly allowed. Respondent number 1 be released with a sum of rupees.
Tribunal ಅಲ್ಲಿ ಇದೆಯಾ?
Tribunal.
Tribunal shall release a sum of rupees 10 lakhs digitally in favor of claimant on subject to satisfaction of identity of the claimant. Much.
TCRs ಇಲ್ಲೇ ಇದೆಯಾ? ಇಲ್ಲಲ್ಲ?
ರಿಸೀವ್ಡ್ ಅಂತ ಇದೆ.
ಇದೆ.
ಹಾ ಮೇಡಮ್, TCR ರಿಸೀವ್ಡ್.
ರಿಟರ್ನ್ ಮಾಡ್ಬೇಕಲ್ಲ ಅದನ್ನ. 2039 ಅಲ್ಲ? ಸಾರಿ.
Registry to ಹಾಕಿದಾರಾ?
ಇಲ್ಲ ಹಾಕಿದೆ. TCRs received ಅಂತ ಇದೆ.
Registry to return the TCR for the limited purpose of enabling ACT to release the amount as directed above. Soon thereafter, records be called for. Much.
Submitted.
Cell number 7, Guru Prasad BR.
That's
Patil.
respond number 1 to 4 and 7. My lords, response number 1 to 4 and 7 have been served, my lords. And for R6, I have personally served the copy on him. And 5, I will take once again steps for the second time.
Filing of acknowledgement for.
I have received the copy.
Yes, he's a
Counsel for the petition submit that the
respond number 6 submits.
respond number 6 submits that the IA tav
He
hakiroda
has received the copies.
has received the copy of his objection, therefore complied.
For 5, I will take steps once again. My lords.
Issue notice to R5 if the requisites are furnished within 1 week.
Achha.
Date ಕೊಡೋದು. ಕೊಡೋದು. ಕೊಡೋದು.
And date fix ಮಾಡಿ.
16/6. Cell number 8, Vasant Kumar KM.
For the appellant one, I paid the processor 19.2 mil. What happened when insurance company also preferred an appeal challenging the liability against same judgment. I think
Who has preferred that?
insurance company, I think Ravi.
Advocate who has.
Ravi Shankar Samprati igiದ್ರು ಅವರು. ಅವರೇ.
ಇಲ್ಲ ಇದ್ರಲ್ಲ.
ಇಲ್ಲ ಇದು ಹೋದ್ರೆ I will serve copy on him.
ಲಿಸ್ಟ್ ಮಾಡಕ್ಕೆ ಆರ್ಡರ್ ಮಾಡೋದು. Respond number 2.
I think it
ಅದ್ಯಾವ್ದು ಇನ್ನೊಂದು
50 ಅದು ಲಿಸ್ಟ್ ಆಗಿಲ್ಲ. It has to be connected appeal number 1521 of 24 MF. I will read it. I think it is before single judge, my lord. I think I will.
Ravi Shankar Samprati.
It is before single judge, my lord, because
It's directed notice for respond number 2. He is permitted to file wakalat in the registry within 2 weeks. His name shall be in the shown in the published accordingly. Appellant's counsel shall serve the copies and it is submitted that this matter is connected to MF number so and so. ಅದರಲ್ಲಿ ನೋಟಿಸ್ ಆಗಿದೆಯಾ?
ಆಗಿದೆ ನಾನು ಅಪೇರ್ I filed ವಕಾಲತಿನ.
You have filed.
Please.
What about notice to respond number 1?
It dispense ಆಗಿದೆ. Is the owner. The owner of the vehicle.
List both the matters together after 2 weeks.
Cell number 9, AGA. AGA.
MFA 52
AGA.
ACA. Government vehicle. Directed ACA. Notice to R1 to 7 for first time non-filing deposit ಮಾಡಿರೋದೇ ಇಲ್ಲ ಅವರು. ಯಾಕೆ ನಮ್ಗೆ ಯಾರು ಅಸೈನ್ಡ್ AC ಇಲ್ಲ? ಯಾರು ಬರೋದೇ ಇಲ್ಲ ಇವತ್ತು. No representation in the further finally 2 weeks.
None appears for respondent number petitioner. Appellant issue notice to respond 1 to 7 if the requisites are furnished within 1 week.
16/6. Cell number 10, Sanat Kumar KM, Ashok N Patil, for R2.
Respond in this case.
None appears for the appellant.
No, waiting ಅಂತ ಇದೆ.
Awaits post after service of notice to respond 1 date for him.
It's done.
16/4. Cell number 11, T. A. Karumbaya, Padmaya
appear-
Tuttu for R4.
I appear for the appellant, my lord.
I request for 2 weeks' time.
R1 to 3 have to take, she appears for R4.
I represent my lords, respond number 4 in this case.
The notice to R1 to 3, the requisites are furnished within 1 week.
You furnish in the register,
Yes,
PF. 8.
16:6. Cell number 12, Renuka Devi AS. Consignment details.
Consignment details not found under the file.
None of this with the appellant.
ಯಾವಾಗ issue ಆಗಿತ್ತು ಇದು?
11:2.
ಎಷ್ಟು ಇರ್ತದೆ?
Issue notice to respond number. ಯಾರದು respondent?
Sole-
ಇಬ್ರೇನಾ?
sole
Second
respondent,
respondent.
family.
Sole respondent. Is the requisite.
11 ಅಲ್ಲಿ ಹೋಗಿದೆ ಮೇಡಮ್ 11/11/24.
So you have to issue fresh on this.
Yes.
Next.
Cell number 13 adjourned. Hearing on IS. Cell number 14, Pradeep Kesi, SPP.
You are withdrawing for that another application. You could have simply said, made a submission for suspension of sentence withdraw ಮಾಡ್ತಾ ಇದ್ದಾರೆ. Why Pradeep, two applications? One is for
Why?
suspension and other one is for withdrawal.
Why is it has been dismissed?
Huh?
Why is it has been dismissed? Earlier
Yes,
IS.
it was dismissed.
Earlier IS.
The appellant files a memo seeking withdrawal of IA 1 of 2024.
Right.
Memo dated 31/1/2025 seeking withdrawal of IA 1 of 2024. Memo taken on record, IA rejected as withdrawn.
Cell number 15, Bharti M. B. Latif, SPP.
For the appellant number 3, bro.
Yes, the accused has been convicted for the punishable allocation, regular section.
Both of you have filed? Both of you have filed. IA 1 of 2025 is by whom?
Lord. The third successive applications filed back in our 1 to 3 minutes.
Let's see. Advocate for appellant ಅಂತ ಹಾಕಿದಿರಿ. ಯಾವ appellant?
IA number 1/25 is by A3, my lord.
A3.
IA number 2/25 is by A1 and 2.
Division of labor.
Please, Lord.
Division of labor.
Earlier it is one advocate filed with for all 3, my lord. Subsequently, my lord, I had to NOC. The case of the prosecution is that, my lord. Shall I narrate the facts?
Please.
Accused number 1, mother Chandramma, is currently in this case. The fact of the case is that she has gone to Chennai and she has developed one patient. This allegation that she had developed a illicit relation with the disease, and she came back to the Davangere. And she stayed there itself, she never went back. So the disease that came in search of her, and matter, that time the incident has happened. That is the perspective of the case. But the PW 17 has completely denied who is he in her statements, my lord. My lord, in this case, based on two theory, last seen theory, relying on that only the trial judge has been convicted. Lastly seen the accused number 1, that is appellant number 1 in this case, my lord. In the ATM CCTV video recording was recorded. Dismissed and accused number 1 were in ATM. Relying on that one scenario, the trial judge has been convicted. But my lord, here my humble prayer is, the accused number 1 and 2 are very young. They are just 24 and 25 years old, young mans, my lord. Right now, his sister's marriage is being fixed. On 3rd of April, his sister marriage is there. His mother has met an injury where she can't walk. She fell in the house, my lord. She has a severe pain in her back. She can't walk. There is no one to look after the mother, my lord. The entire family, after her marriage, the mother will be left alone, my lord. No one are looking after, and financially they are very weak too, my lord, to take care of the sister's wedding. The same contention I made in the previous submission, but that was not content of my IA. So I have just brought all this note before this IA and I filed it, my lord. Right now, the condition of the family is in a very bad condition. No one is supporting them financially. Past 6 years, they are in imprisonment. The day of conviction, they are 5 years, they are in imprisonment. my lord.
So during trial, bail was not granted.
Bail was there, my lord. At the time of trial, they were in the basement.
They were on bail.
They were on bail. I will bring the bail application number also. This Honorable High Court has granted them the bail, my lord, in
There is a reference in the order. Trial court judgment that is referred.
Oh. This para 4.
Para 4 of
A3 was released on bail. Later, A1 to 3.
A1 and 2 ಆಗ್ಬೇಕು.
But you said earlier twice the applications were rejected.
Yes, madam.
How did?
My lords, first application came to be rejected on 22/12/2020.
22-12.
Yes, ma'am. Second application came to be rejected, dismissed. My lords, on 24/21/1/2025. That is just 1.5 months earlier, my lords. So,
That is 8, 1 and 2.
ಹೌದು.
ನಮ್ದಲ್ಲ.
ನಿಮ್ದು ಹೇಳ್ತೀನಿ ನಾನು.
And this direction.
She herself turned hostile. PW 17.
ಹೌದು.
Lords, on
Sole
merit,
eyewitness.
lords, on merits. my
No,
lords,
Lord. Eyewitness is PW. Shall I narrate the facts, Lord?
Mother.
As per the prosecution is eyewitness to the alleged incident is PW 19. The case of the prosecution is,
So
Lord,
he supported here.
he has turned hostile, but his 164 statement was recorded. As per 164 statement, he narrates the facts that the deceased and PW 17 had a illicit relationship. That too came to know to the accused number 1 was the son. He came to know about the relationship. And accused number 2 is the close relative of A1. They conspired together to commit murder. And accused number deceased and the PW 17 were there at railway station at Davangere. Accused number 2 had informed them where they accused number 1, 3 and PW 19 were sitting at some nearby a ground. A2 informed that your mother and the deceased were at the railway station. Please come immediately. Then, Lord, the accused number 1, PW 19 and accused number 3 were all 3 of them traveled to the railway station where they met accused number 2 and the deceased and the mother. Then they had a lunch there. They sent the PW 17 to the house back. Then, Lord, the case of the prosecution is that accused number 3 and PW 19 were sitting in the front seat of the auto rickshaw. Deceased 1 and 2 are sitting in the back seat. A1 directed them, the auto driver, the A3, to take him to some canal, that is Nagannuru canal, near to the Nagannuru canal. There, my lord, there was a scuffle between the accused number 1 and 2 are assaulted to the deceased. That time, PW 19 and accused number 3 said, don't assault, we'll leave him. Then, my lord, they assaulted, pulled him down the floor. Then there is an averment in 164 statement that ನಾವು ನಿಧಾನವಾಗಿ ಆಟೋವನ್ನು ಓಡಿಸಕ್ಕೆ ಪ್ರಾರಂಭಿಸಿದಾಗ A1 and 2 are laid on they joined with the auto and they came back. Then they threatened, accused number 1 and 2 threatened the accused number, the PW 19 and the accused number 3 not to disclose the matter to anyone. Now, my lord, interestingly, they made accused PW 19 as a witness and accused number, the auto driver is made as an accused. I am the better footing than a PW 19. 164 statement, 161 statement clearly narrates, we are pacified, don't assault him, the deceased. That was the averments in the 164 statement. In spite of that, made me as an accused and convicted for 302. The circumstance what they are relying is.
PW 15 was asking the culprits not to assault.
How?
Charge sheet ಅಲ್ಲಿ. Not the auto driver.
Auto driver, ಅವ್ರದ್ದು PW 15 164 ಸ್ಟೇಟ್ಮೆಂಟ್ ಮಾಡಿದ್ದಾರೆ, 161 ಮಾಡಿದ್ದಾರೆ. ಅದ್ರ ಪ್ರಕಾರನು ನಾನು ಹೇಳ್ತಾ ಇರ್ತೀನಿ, ನಾನು ಆಟೋದಲ್ಲಿ ಅವನ ಜೊತೆಗೆ ಇರ್ತೀನಿ, ನಾನು ಹೋಗಲ್ಲ ಹೊಡಿಯಕ್ಕೆ, ನಾನು ಹೇಳ್ತೀನಿ ಹೊಡಿಬೇಡ ಅಂತ. ಪ್ಲೀಸ್ A3.
Accused number 3.
All these arguments have been advanced, my lord.
Still answer accused number 1 and 2.
1 and 2. PW 19 is
Drawing the amount for 8.
that is by A1 and the deceased the CCTV footage as per the prosecution. I have nothing to do with it. Even they consumed the alcohol in the bar. There also the witness speaks that there are 4 persons came and consumed the alcohol. They not identified who are all came. Admittedly, all these accused number 1, 2, 3 and PW 19 are the friends.
Accused number 3 is also friend of 1 and 2.
1 and 2. 19 also friend. 19 and witness ಮಾಡಿ ನನ್ನನ್ನು accuse ಮಾಡಿದ.
This application is rejected on merits. On merits.
Initially all together I filed in the 2020. Then 2021 my application was rejected.
That accused number 1, 2, 3.
First application.
First application.
May I make submission, my lord?
All the accused together had filed.
Lord's first application came to rejected in respect of all the accused, accused number 1 to 3. Thereafter, my lords, accused number 3 has filed a separate application that came to, my lords, rejected on 12/4/2021.
1 second.
Thereafter I didn't
And
file
thereafter,
anything.
one more application came to filed on health grounds. My lords, this.
That is only to direction, Lord, to give a medical treatment.
And then, my lords,
That is on 6/1/25. He was suffering from some diseases, my Lord, to direct the jail authority to provide medical treatment. I'll read 164 statement of the PW
all
19.
the grounds which have been urged by my learned friend has been urged, my lords, at the time of my lords.
What is the other application date? 12/4/2020.
Yes, my lords. That is in respect of accused number 3, second application, which came to be rejected.
A3.
Yes, my lords.
12/4/2021.
4/2021.
So last seen and withdrawal of this amount from ATM CCTV.
Recovery, my
That
lords,
is A1.
bloodstained clause,
Recovery of
bloodstain clause at the accused number 1 and 2. And my lords, seeing my lords together, my lords, accused number 1, 2 and 3, along with the deceased.
That is PW 19 is also
No, my lords, on
present.
merits, my lords, this have been considered and dismissed.
all the 3 accused were earlier rejected on merits. Now, where is the scope for us to look into the evidence? Now, if it ain't changed circumstances there, what are the changed circumstances? Her age, that mother's age.
That has been, my lords, even that has been argued on the earlier occasion, my lords.
Seems ಅದ್ರ ಬಗ್ಗೆ ಏನು ಮೆನ್ಷನ್ ಆರ್ಡರ್ ನಲ್ಲಿ ಬರೀ ಮೆರಿಟ್ಸ್ ಬಗ್ಗೆನೇ ಡಿಸ್ಕಸ್ ಮಾಡಿದ್ರು.
That is, my lords, 21/1.
ಅಪ್ಲಿಕೇಶನ್ ಅಲ್ಲಿ earlier application was suppressed ಅಂತ ಹೇಳ್ತಾರೆ. Aforesaid aspect has been suppressed in the present application.
21/1/2025, there is an order, my lords, passed by the Assembly.
Why did they suppress in the second?
Cannot disclose, my lords, filing of earlier application.
Madam, may I make one submission, madam?
This appeal is of the year 2020, no?
Yes, my lords. Paper book is ready, my lords.
Custody since when?
Lord, conviction in the year 2020,
Since then they are in custody.
custody, 5 years.
One submission.
Now paper book is ready. Why don't
Ready,
you
my lord.
argue the main matter itself?
Please.
One.
Madam, see, twice your applications are rejected on merits. Now we don't have scope to go into the merits.
Previous application, I was present and I had made the submission. In the IA, I didn't stated the grounds why I need the suspension of sentence. Here, the mother is also very much unwell, my lord. She's been hospitalized. I have given doctor certificate and wedding invitation also, my lord, along with the
Invitation?
wedding invitation of the accused number 1 sisters, my lord. I can
ಅದಕ್ಕೆ ನೀವು ಪೆರೋಲ್ ತಗೋಬಹುದು ಅಥವಾ ಅವರೇ ಇಂಟೀರಿಯಂ ಬೇಲ್ ಆಗ್ಬಹುದು ಅಷ್ಟೇ.
support for the family. If she goes out.
ಸೇಲ್ ಅಲ್ಲಿನೂ ವರ್ಕ್ ಮಾಡಿದ್ರೆ ಕೊಡ್ತಾರೆ. ಇವ್ರು ಮಾಡದೆ ಬರೀ ಟಿವಿ ನೋಡ್ಕೊಂಡು ಕುತ್ಕೊಂಡ್ರೆ ಕೊಡೋದಿಲ್ಲ ಅವರು.
Now, ಅದು mother alone ಇರ್ತಾರೆ. This was the grounds which I have submitted. These grounds were not taken in my IA, my lord. It's not only for attending marriage, my lord.
On the previous application, my lord, the previous order, is direction to seek parole, my lords.
ಏನಿದೆ? What is her age? 35 that I have examined patient by name so and so, aged 54 years. ಇದು old age ಅಲ್ಲ, 54 years.
But she can't, my lord.
ಅದೇನು ಸ್ಲಿಪ್ ಡಿಸ್ಕ್ ಇದೆ ಅಂತ ಟೆಂಡರ್ನೆಸ್ ಏನು ಬರ್ದಿದ್ದಾರೆ?
ಅವ್ರು treatment ಮಾಡಕ್ಕೆ ಅವ್ರು ಆಚೆ
Mild
ಇರ್ಬೇಕು,
posterior
ಬೇರೆ
disc prolapse. Now she is staying with her daughter.
ಡಾಟರ್ಸ್ ಮದ್ವೆ ಫಿಕ್ಸ್ ಆಗಿದೆ. ಈಗ ಅವ್ರು ಮದ್ವೆ ಮಾಡ್ಕೊಂಡು ಮನೆಯಿಂದ ಆಚೆ ಹೋಗ್ತಾರೆ. They are not habituals well.
ಅಂದ್ರೆ ಯಾರು ಇಬ್ಬರ ಹೆಸರು ತೋರಿಸಿದಾರಲ್ಲ ವೆಡ್ಡಿಂಗ್ ಇನ್ವಿಟೇಷನ್ ಅಲ್ಲಿ, ಚಂದ್ರಕಲಾ ಶ್ರೀಬಾಬು.
That is PW18. Marriage has been fixed.
ಮದರ್ಸ್ ನೇಮ್ ಇಸ್
ಲಕ್ಷ್ಮಮ್ಮ. Sorry, ಚಂದ್ರಮ್ಮ.
ಚಂದ್ರಕಲಾ ಅಂತ ಇದೆ ಅಲ್ಲ, ಅವರೇನಾ?
ಅವ್ರೇ.
ಮ್ಯಾರೇಜ್ ಇನ್ವಿಟೇಷನ್
Marriage, my lord.
ಮೇಡಮ್, ನಾವ್ ಹೇಳಿದ್ ಗೊತ್ತಾಯ್ತಾ? He can work in the jail and earn.
But
ಮತ್ತೆ
who
ಅದನ್ನ
look after the mother, my lord? She has to be taken to hospital and all, my lord. No one are there to support the family. He can work in the jail. He can come for the marriage in Parole also, my lord.
ಯಾವತ್ತಿದೆ ಮದುವೆ?
3rd of April.
ಮುಗಿದೋಯ್ತಲ್ಲ.
April, my lord.
ಲಾಸ್ಟ್ ಇದರಲ್ಲಿ ಪೆರೋಲ್ ಅಪ್ಲೈ ಮಾಡಿ ಅಂತ ಡೈರೆಕ್ಷನ್ ಇದೆ PS ಆರ್ಡರ್.
Next time parole apply.
ಟು ಸೀಕ್ ಪೆರೋಲ್ ಅಂತ ಅಬ್ಸರ್ವೇಷನ್ ಇದೆ.
On the same ground.
ಟು ಸೀಕ್ ಪೆರೋಲ್ ಅಂತಾನೆ ಇದೆ ಇಫ್ ಐ ಆಮ್ ರೈಟ್ ಮಿಲರ್ಸ್ ಆನ್ ದ
What did it?
21/1/2025.
21/1/25.
25, just 1.5 months earlier.
I took marriage as a contention, my lord.
Then this application was not filed or?
But these grounds have been asked, madam. These grounds have been asked, madam, because application.
Application is seeking oh, another application that I.
Lord, since 2022 it was pending, it was disposed of on 21/1/2025.
Application is pending since 2022 ಅಂತ ಮಾಡಿ.
All these grounds have been argued, my lords, at that particular point
First
of time.
application was rejected on 22/12. Second application was rejected on 12/4/2021.
25, my lords. This is.
ಅಲ್ಲ, ಇದು ಅಲ್ಲೇ ಆರ್ಡರ್ ಅಲ್ಲೇ ಇದೆ ನೋಡಿ. First application was rejected on 22/12/2020. Second application was rejected on 12/4/2021. In the present application, no change circumstance. How many times? This is 4th application.
Yes.
My lord, recently I came into record, my lord. I argued on.
No, that cannot be the change. That cannot be the changed
The
circumstances.
grounds are not in the application. I made the same submission. Lordship rejected my application only. The grounds are not taken in my application.
Third application was also filed, all the 3 accused?
No,
No.
by only one accused.
One and 2 months.
One and two.
Mine is 2021 is the last.
Hello, yes.
You had filed one application.
Two applications.
Two applications.
Both of you had filed 2 applications. Third application was by accused number 1 and 2 alone.
My application may be deferred, my lord, because I am ready for final hearing.
You argue on the main matter itself. We'll fix the date for that.
Please.
IA,
So far as A1 into 4 applications are rejected.
IA 1 of 2025 is filed by accused number 3. While I number 2 of 2025 is filed by accused number 1 and 2. Accused number 1 to 3 had filed common applications on earlier occasions. Full stop. By orders, by detailed order dated.
Lord, instead of passing on merits in my application, maybe my application were deferred and posted for final hearing. I am ready with the final.
Again, ಮತ್ತೊಂದು bench change ಆದಾಗ ಇದೆಲ್ಲ ಹೇಳೋದಿಲ್ಲ.
ಅಲ್ಲ, Lordship may fix the date for hearing.
We have
I'll
waited
ready.
for such a long time. It is unjust to say that now defer it. Yes.
This court, detailed order dated 22/12/2020, 12/4/2021, rejected the applications, common application filed by accused number 1 to 3 for suspension of sentence and for bail. Full stop. The third application was filed by accused number 1 and 2. The said application came to be dismissed
21/1.
on 21/1/2025. This is the 4th round of application. This is the 4th application filed by accused number 1 and 2, and the third application filed by the accused number 3. Full stop. stop. The circumstances sought to be canvassed by the appellant, accused number 1 and 2 does not evince the credibility requiring suspension of sentence at this juncture. Similar is the reason for this third application. Full stop. Third accused. Third accused. Applications are accordingly rejected. List this matter for final hearing on date.
9-4.
We can argue in the main matters.
Bill number 16, Gopal Krishnayan, N. Krishnaswamy, Paratu.
Yes, my lord. Some delay of 18 days may be condoned.
Days delay.
Yes, my lord.
Avradರಲ್ಲಿ ಕೃಷ್ಣಸ್ವಾಮಿ ಅವರದು
Paper publication.
ನಾನ್ ಟೇಕಿಂಗ್ ಔಟ್ ಪೇಪರ್ ಪಬ್ಲಿಕೇಶನ್ ಫಾರ್ R6. ಲಾಸ್ಟ್ ಟೈಮ್ ಏನು ಯಾವಾಗ ಆರ್ಡರ್ ಆಗಿದೆ 4/2/2025 ನಲ್ಲಿ.
Yes, ma'am. Last time also, they told they'll be.
Driving license aspect is involved. He remained ex parte before the mediation. Still, I'll take one more.
Order was passed on 4/2/2025. ಮತ್ತೆ ಡೇಟ್ ತಗೊಂಡಿಲ್ಲ. They have not.
I have not taken it.
Last time also same thing was made.
ನಾವೇ ಬೇರೆ ಯಾರು ಅವ್ರ ಕನ್ಸ್ಯೂಮರ್ಸ್ ಒಂದು ಸ್ವಲ್ಪ ಪ್ರೀಮಿಯಂ ಕೊಡ್ಲಿಲ್ಲ ಒಂದ್ ದಿವಸ ಒಂದು 1 hour ಲೇಟ್ ಆದ್ರೆ ಎಲ್ಲಾನು ರೆಪಿಡಿಯೇಟ್ ಮಾಡ್ತಾರೆ.
ಹೌದೌದು. But lapse on my part, I agree. I should have collected it.
Accepting the reasons designed in the affidavit of the application in IA 1 of 2021, delay of 18 days condoned, IA allowed.
ಅಡ್ಮಿಟ್ ಮಾಡಿದ್ರು ಅಡ್ಮಿಟೆಡ್ ಅಂತ ನೋಡಿ ಡಿಲೇ ಕಂಡೋನ್ ಆಗಿರಲಿಲ್ಲ.
Yes, though
Only a date may be fixed.
though we order dated
4/2/2025.
4/2/2025, appellant in second matter was permitted to take out notice to the respondent number 6 in Sayukta Karnataka Kannada daily newspaper to be published on or before 4/3/2023, the same is stated to not have been taken. 2 weeks time granted to do the needful with the honor before date publication to be a notice to publish in honor before
16-4.
with the date of the appearance as
After June 2/6.
yes.
Failing which failing which
Yes.
act against respondent number 6 shall stand.
And this
Please, ma'am.
He was ex parte there.
Yes, my lord.
Placed ex parte.
It is at
My
his
lord,
risk alva.
Interesting point is international driving license, whether that could be utilized in India, whether provisions of it.
Right.
Okay,
At his risk, he was ex parte before the trial court. Order 41 rule 14, he could have sought dispensation.
Because when case was dismissed against him, now pay and recovery na agಬಹುದು. Therefore, change of
Much obliged.
2021 appeal ಅಲ್ಲ ಇವ್ರೆ ಮಾಡ್ಬೇಕು ಅವರು. Your appeal is of 2020.
Even on last occasion, same submission was made, madam.
Bill number 17 adjourned. Bill number 18, Shivakumar, Fayasab BG.
My lord, I appear for the appellant in this case, my lord.
Respondents counsel Fayasab PC not there.
My lord, during the last date of hearing, respondent was directed to
IA disposed.
for IA number 1 and 2, my lord.
What is that? What is?
My lord, IA 1 is for,
No, what is to
My
be
lord.
stayed here? What is the order under challenge?
my lord, order
2022.
please, my lord. It was a dismissal order passed by the senior civil judge, Pavgada.
In MC number 53, 27/10/2022. ಏನ್ ಮಾಡಿದ್ದಾರೆ ಅವರು? ಸ್ಟೇ ಮಾಡಿದ್ದಾರೆ. ಡಿಸ್ಮಿಸ್ ಆಗಿದ್ರೆ ಸ್ಟೇ ಮಾಡಿದ್ದಾರೆ. Correct. What is there to stay? Your petition is dismissed.
My lord, my petition is dismissed and the,
Why have you filed stay application?
my lord, the other side is proceeding against us under section 498A, my lord.
Oh,
giving
For
complaint
that
against my.
purpose, we cannot stay.
IA, okay, IA one of
2023.
2023 is filed by the appellant husband seeking stay of the proceedings, stay of proceedings, sir.
No, ಅದು clear ಆಗ್ಬಿಡ್ತು.
Stay of proceedings in OS number 172/2019. Present appeal is filed agreed by the order dated 27/10/2022
In MC number 50.
in MC.
My lord, there is a suit filed by the wife, my lord,
Which was
claiming
a petition filed by the husbands under section 13 bracket 1 close the bracket IA close the bracket seeking dissolution of marriage, dissolution of his marriage with the respondent, full stop. The said application has been dismissed by the impugned order. In that view of the matter, ಯಾವುದು stake ಇರ್ತದೆ ಅವು suit
my lord, there is a suit filed by the wife, my lord.
ಅದು ಹೇಗೆ ಬರ್ತದೆ stay ಮಾಡ್ಲಿಕ್ಕೆ?
My lord, based on
Section
this,
10 ಅಪ್ಲೈ ಆಗೋದಿಲ್ಲ ಇಲ್ಲಿ. Section 10
My
of Civil Procedure Code.
based on this dismissal, my lord, they are pursuing that suit, my lord. That is the reason.
Appellant submits that based on the dismissal of the petition in MC
Filed
number
in
53 of
2019. This is in 2022.
the respondent is proceeding in a suit in OS number 172/2019, full stop,
For maintenance.
for which is filed by her against the appellant herein seeking relief
For
of
maintenance. Yes, my lord.
no justification for maintaining the application. Same is dismissed.
My lord,
Even
IA,
when the matter was pending before the trial court, you had not filed any application under Section 10.
my lord, it has been filed before the. My lord, IA number 2 can be allowed, my lord. It is a continuation of delay of 2 days.
Record said to be called. Admit call for.
IA 2 is allowed.
Please, my lord.
Dismissed.
IA 2 continuation of delay.
ಅದು ಅಲೋ ಆಗಿದೆ ಅಲ್ಲ.
ಅದೇ.
ರೆಕಾರ್ಡ್ಸ್ ಕಾಲ್ ಫಾರ್ ಮಾಡಿರ್ಲಿಲ್ವಾ?
ಇಲ್ಲ,
ಮಾಡಿದೆ.
madam. ಇಲ್ಲ, my lord.
Admit ಅಲ್ಲ appeal.
Yet to be called ಅಂತ ಇದೆಯಲ್ಲ.
ಇಲ್ಲ, appeal is yet to be admitted, my lord.
Appeal admitted,
Call for this.
call for trial court records.
Seal number 19, Ashok and Patil, S.U. Prakash for R1 to R3.
This
Ramesh sir.
matter, my lord, I appear for respondent 1 to 3 claimants. Claimants have made an application seeking for withdrawal of the amount deposited by the insurance company. My lord, at the time of granting the stay, my lord, this honorable court, my lord, directed.
Correct. ಅವ್ರು ಏನ್ ಹೇಳ್ತಾರೆ ಕೇಳೋಣ ಏನು?
Please.
Challenges on what ground?
Yes, we have challenged on the ground that driver of the offending vehicle is implicated. Is implicated.
Licensed person was subsequently
yes,
posted on
yes,
this.
yes.
Our ಹೇಳೋದು, my lord, there is no
Charge
dispute.
sheet was filed against him only.
Oh, my lord,
Yes.
him only, my lord, they have not
May-
challenged the charge sheet. And also, my lord,
ಅವ್ರೇನ್ ಚಾಲೆಂಜ್ ಮಾಡಕ್ ಬರುತ್ತೆ ಅದನ್ನ? How can the insurance company challenge the charge sheet?
ಒಂದು.
The
My
accident,
lord, there is no dispute with regard to the accident, occurrence of the accident.
Correct. Their contention is that
Only driver ಅಂತ,
Even-
but it,
one ಇನ್ಶೂರೆನ್ಸ್ ಪಾಲಿಸಿ ಡ್ರೈವಿಂಗ್ ಲೈಸೆನ್ಸ್ ಇಲ್ಲದೆ ಇರೋ ಡ್ರೈವರ್ನೇ ಡ್ರೈವ್ ಮಾಡಿದ್ದ ಅಂದ್ರೂ
Yes.
ಸ್ಟಿಲ್ ಹ್ಯಾವ್ ಟು ಪೇ ಅಂಡ್ ರಿಕವರ್ ಅಲ್ವಾ?
there is one judgment of the division bench, my lord, Justice N. Kumar, where they say, my lords, if all the parties have colluded, my lord, therefore the owner alone should be liable. Yes, ma'am.
Fraud
Fraud
vitiates.
vitiates the entire money.
ಆ ಕೇಸಲ್ಲಿ ವಿ ನೋ ದಟ್ ವೀರಪ್ಪ ಏನೋ
Yeah, yes, yes.
ಅದರಲ್ಲಿ ವಾಸ್ ಇಟ್ ಎ ಕೇಸ್ ಆಫ್ ಪ್ಲಾಂಟಿಂಗ್ ದ ಡ್ರೈವರ್?
Yes, my lords, it was a case of planting a driver. Yes, yes. They knowingly do it, my lord.
ಇಲ್ಲ ಅಲ್ಲ ಅದಿದೆ ಕೊಡಿ ನೋಡೋಣ ಜಡ್ಜ್ಮೆಂಟ್ ಇಲ್ಲಿ.
What evidence in this case regarding planting the driver?
Please, my lords.
What is the evidence in this?
My lords,
They
the
conducted
FIR, the FIR,
You had conducted any internal investigation?
my lords, the complaint and FIR, my lords, is against the Anand. The
Different persons.
the charge sheet is laid against, my lords, the Anant Kumar.
Anant Kumar is RW1, ಅವ್ರೇನಾ?
Anant Kumar is RW. Yes, ma'am.
driver and
Charge sheeted driver.
Charge sheeted driver.
driver and owner, my lord, driver come owner.
Because, my lords, may narrate the facts. My lords, 5 persons would be traveling, my lords, on 6/8/2019 to get, my lords, Ganesha idol. RWT is our official. My lords, one,
Why his evidence?
One
was
of the
not
inmate,
accepted?
my lords, informs the father of the deceased, and father of the deceased, my lords, files a complaint on the next day, stating, my lord, the name of Anand. But subsequent to, my lords, investigation, Anand Kumar, my lords, is charged sheeted.
So initially complaint was filed against one Anand.
Anand.
So your contention is that Anand was not holding the
Yes,
driving
yes,
license.
yes.
Even assuming
But
that.
even
that is-
assuming, my lords,
Even if we hold that you have proved it.
yes.
Then also you have to pay and recover.
That's
no?
my, my lords, that proposition of law, my lords, I would not,
Judgment.
yes, yes.
ಇದೇ facts ಸಿದ್ಧಾಂತ. ನೀವು ತಂದಿದ್ದೀರಾ judgment?
But I have not got it, my lords, today.
You have that judgment?
No, no. I'm sorry, my
ಇದೆ
lords.
ನಾವಿಲ್ಲ ಆಫ್ ಕೋರ್ಟೆಡ್ judgment. ಪಾಸ್ ಓವರ್ ಮಾಡ್ತೀವಿ ತಂದು ತೋರಿಸಿ.
Please, my lords, I will get.
Whether the
Yes,
is it a case of planting?
I will get.
Passed over. Seal number 20, Krishna Kishore S. Raghu R for R1.
Respond. I filed the application for withdrawal the amount, my lord. That quoted the 24 lakh 7,379 before the MSCT, my lord.
50% release ಮಾಡಿದ್ರಾ? Suffering 2 lakhs ಕೊಟ್ಟಿದ್ದಾರಾ?
Amputation of the left hand, my lord.
Amputation.
Amputation case. She is a 19 years lady.
75 ಹೇಳಿದ್ರು functional disability.
Functional disability.
What was the claimant?
Claimant is a 19 years girl, my lord. She is tailoring work and studying BCom.
Studying BCom.
So tailoring work, my lord. Thank you.
So loss of income, medical 3,49,000.
Amputation of the left hand.
Income 35,15,400. Notional income ತಗೊಂಡಿದ್ದಾರೆ.
Yes, my lord. National income.
ಎಷ್ಟು ತಗೊಂಡಿದ್ದಾರೆ?
50,500.
ಎಷ್ಟು 50,000?
1,500. National income.
Accident is
22, my lord. 2022.
ಅಲ್ಲ ನೀವೇ ಅದ್ರ 50% ಕೊಟ್ರೆ ನಿಮ್ಗೇನು ಇರೋದ್ರಲ್ಲಿ 50% ಕೊಡ್ಬೋದಲ್ಲ. Now you have deposited
24 lakhs.
24 lakhs. ಅದ್ರಲ್ಲಿ 50% ಕೊಡೋದು.
IA 1 of 2025 is filed by the respondent number 1. A release seeking permission to withdraw.
Deposited here or before trial?
MSCT.
Amount deposited by the appellant insurance company. Full stop. The sum of appeals
24 lakhs.
24 lakhs 7,379 has been deposited by the appellant before the MACT. Full stop. Counsel for the appellant has no objection in releasing 50% of the amount so deposited. Submission taken on record. IA 1 of 2025 is allowed. MACT is directed to release 50% of
Amount in deposit.
amount in deposit digitally in favor of the respondent number 1 or claimant, subject to satisfaction of the identity. So TCR idea,
TCR ಇದೆ.
registry to send the TCR for the aforesaid purpose and shall resubmit the same thereafter.
Seal number 21. P. Gonsalves, B. Pradeep for R3.
168 days. Hold on.
Delay.
Petition of delay of 168 days. There is no insurance for the vehicle? HDFC ಇರ್ಬೋದು. Pradeep notice ತಗೊಂಡಿದ್ದೀನಿ. Okay. 168 days delay, what do you say?
I will condone by denying interest.
Interest. ಅಂದ್ರೆ ಸಬ್ಜೆಕ್ಟ್ ಓನರ್ ಅವ್ರಿಗೆ ಅಂತ ಮೈನರ್ಸ್ ಟೋಟಲ್ ಡಿಸಬಿಲಿಟಿ.
What is the reason?
What is the disability? Or
16% disability of the right hand,
right hand?
permanent partial disability.
Claim petition has been dismissed.
ಕೈ ಅದೆಲ್ಲ ಇದ್ದಾರೆ.
Accepting the cost should the affidavit recommend the application.
Financial distress ಹೇಳಿದ್ದಾರೆ, that we can take because 90.
Yes, delay of 168 days condoned, IA disclosure.
Bill number 22, KT Gurudev Prasad, BC
Records
Shivane.
ಬರ್ಬೇಕಾ ಇದ್ರಲ್ಲಿ? Records ಬರ್ಬೇಕಾ?
Meet call for TCS.
Meet call for TCS.
Appeal is already there. Appeal admit ಆಗಿದೆ, delay ಖಂಡನ ಆಗಿಲ್ವಾ? ಖಂಡನ ಮಾಡ್ಬೋದು ಯಾಕಂದ್ರೆ EC ಅಲ್ಲ.
Yes, accepting the cost should the.
ಯಾವಾಗ admit ಆಗಿದೆ appeal? ನಾವು issue notice ಅಂತ.
The appeal not admitted, madam.
Not at.
Delay ಖಂಡ.
Get disposed of. Admit.
ಯಾರು ಶಿವನ್ನೇಗೌಡ ಅಲ್ಲ, admit ಅಂದ್ರೆ substantial question ಮಾಡಬೇಕು. There is no relationship. Oh, relationship of employer and employee is not proved ಅಂತಿದೆ. Bar to grant merely because no records have been maintained by the employer in the light of. ಅದು first question ಅಲ್ಲೇ cover ಆಗಿದೆ ಅಲ್ಲ. So one substantial question applies sufficient. Appeal admitted to consider this.
Appeal admit consider question number one.
Question number. ಅನ್ನಿದೆಲ್ಲ appeal.
Call for records.
Bill number 23, Ravish Benny, Jaikar Shetty.
Call for.
Liability, act policy, liability only policy. Amount cannot be withdrawn.
The 50% amount.
ಅಂದ್ರೆ they were traveling reward ಅಂತ.
Please, madam. Liability, please.
Oh,
Is
yeah.
inmates of the vehicle and act policy.
I had one submission in this matter.
Yes.
Counsel for R3 in the first appeal, my lord, SN Prashant Chandra. He has filed one more appeal, my lord. MFA 7470 of 2024.
7470
2024, my lord.
2024.
He requests for clubbing of that matter along with these matters, my lord. 7470 of 24.
What is award here? ಏನ್ ರಿಕವರ್ ಮಾಡಿದಾರ ಏನಿಲ್ಲ, liabilities against the insurance.
Liability, please. Act policy.
Policy.
Liability only policy.
ಆಯ್ತು ಹಾಗಾದ್ರೆ ಲಿಸ್ಟ್ ಆಗಿದೆ.
50% matter along with MFA number 6.
It is submitted that this matter is connected to the
3-4.
3-4.
Bill number
Obliged.
24, B Pradeep, Rangegoda NR.
One submission. Let them furnish the appeal memo so that I can collect the wakala from the concern or office, please.
Who has?
Please,
Prashant Chand is the owner of the vehicle.
I'll convey.
Correct. Or copies furnish ಮಾಡಿ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ.
Please.
Right, sir. Furnish.
I can collect the wakala and ready for disposal next day. TCR already received, please.
All.
Right, sir. Convey matter.
Bill number 24, apply.
We appear for respondents.
51 lakh has been deposited, my lord. 25 lakh may be permitted to withdraw.
Release ಮಾಡಬಹುದು. Case of death,
Please,
Yes, my lord.
they have deposited.
finance. Deposit ಮಾಡಿದ್ರಲ್ಲಿ ಎಷ್ಟು 20 lakhs?
Not 51 lakhs, 21,553.
25 lakhs to be released.
50% of the deposited amount.
ಇಲ್ಲಿ ಇಪ್ಪತ್ತು ಮಾಡ್ಬೇಕಾಗತ್ತೆ, ಉಳಿದವ್ರಿಗೆ ಇನ್ವೆಸ್ಟ್ ಮಾಡ್ಬೇಕಾಗತ್ತೆ. 50% deposit.
26, 25, 55.
ಇಲ್ಲ, share wife ಜಾಸ್ತಿ ಇರ್ಬೇಕು. Wife has 50% share. Petitioner number 1.
2 and 3 are minors.
4 major,
Please.
minors ಅವರು.
Minors are there. 2 and 3.
ಅವ್ರ ಶೇರ್ ಬಿಟ್ಟು ಇವ್ರಿಗೆ
Please, please.
4 ಮದರ್ಗೆ ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ? ಮದರ್ ಅಲ್ವಾ ಅವರು? ಅವ್ರಿಗೆ
Please.
50%.
petitioner
Okay, 50%.
order to be released to petitioner number 1. Next page ಅಲ್ಲಿ
50% with the proper interest.
40, 20, 20, 20 ಮಾಡಿದ್ರು.
ಅಲ್ಲ, ಅದು ಫಸ್ಟ್ ಪಿಟಿಷನರ್ಗೆ 50% ಕೊಟ್ಟಿದ್ದಾರೆ. ಶೇರ್ಸ್ ಅಲಾಟ್ಮೆಂಟ್ ಹೆಂಗ್ ಮಾಡಿದ್ದಾರೆ?
Not the
ಪಿಟಿಷನರ್ ನಂಬರ್ 4 is
40, 20, 20 ಮಾಡಿದ್ದಾರೆ. Each
40,
40% wife ಗೆ ಮತ್ತೆ ಮದರ್ ಮತ್ತೆ ಚಿಲ್ಡ್ರನ್ಸ್ ಗೆ 20, 20.
ಈಗ 51 lakhs ಅಲ್ಲಿ ಅವ್ರಿಬ್ರು ಶೇರ್ ಕೊಟ್ರೆ ಅಷ್ಟೇ ಬರುತ್ತೆ ಅಲ್ವಾ? 40 plus 20.
Please.
60 ಆಗುತ್ತೆ.
No, my lord, we are challenging negligence, my lord.
Kindly see exhibit P5, sketch, my lord.
50% ಏನಿರುತ್ತೆ ಅದನ್ನ invest ಮಾಡಿ.
Investment ಅಂತ investment any case ಇದ್ರೂ invest ಆಗಿರ್ತದೆ.
ಇಲ್ಲಿ ಮಾಡಿಲ್ಲ, ಎಲ್ಲಿ ಡೆಪಾಸಿಟ್ ಮಾಡಿದಿರಿ?
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ.
Or MSIT.
ಅಲ್ಲಿ ಟ್ರಯಲ್ ಕೋರ್ಟಲ್ಲಿ ಅಲ್ಲಿಗೆ ಇನ್ವೆಸ್ಟ್ ಮಾಡ್ತಾ ಇದಾರ? ನಾವು ಮತ್ತೊಂದು ಆರ್ಡರ್ ಮಾಡಿದ್ವಿ ಅದ್ರ
ಮಾಡ್ತಾರೆ.
ಸೋಮೋಟೋ
In terms of the award,
ಮಾಡ್ತಾರೆ.
please.
ಈಗ ಬ್ಯಾಲೆನ್ಸ್ ಅಮೌಂಟ್ ಇದ್ದದೆಲ್ಲ ಮೊದಲು ಇನ್ವೆಸ್ಟ್ ಮಾಡ್ತಿಲ್ಲ, ಎಫ್ ಡಿ
ಮಾಡ್ತಿದ್ದಾರೆ.
ಅದೇ ಇದ್ರದ್ದೆಲ್ಲ 3 ಶೇರ್, ತಾಯಿದು ಒಂದು ಶೇರ್ ಇದೆ ಅಲ್ಲ, ಪ್ರಾಪರ್ಟಿ.
They're directly liable to the credit. So it makes no sense to release her and again to deposit.
ಅಸಲು ಇದೆ ಏನ್ 50% ಅಲ್ಲಿ 40% ಅಲ್ಲ, ಈಕೆ 40%, ಈಕೆಗೆ ಎಷ್ಟು ಬರುತ್ತೆ? 20%, 60%. ನಾನು ಹೇಳಿದ್ದು ಔಟ್ ಆಫ್ ದ ಅಮೌಂಟ್ ಇನ್ ಡೆಪಾಸಿಟ್ ಇವ್ರು 20 ಕೊಟ್ಬಿಟ್ರೆ ಉಳಿದಿದ್ದು 50% ಡೆಪಾಸಿಟ್ ಆಗಿರುತ್ತಲ್ಲ, ಮುಂದೆ ಏನಾದ್ರು ವೇರಿಯೇಷನ್ ಇದ್ರೆ ದಟ್ ಮೇಕ್ಸ್
51 lakhs. 25 lakhs.
50%.
ಎಷ್ಟಾಗುತ್ತೆ ಅವಾಗ 40% of 25 lakhs? ನೋಡಿ ಮಾ
51 lakhs.
ಅಷ್ಟಾಗಲ್ಲ.
ಅಮೌಂಟ್ ತಮ್ದು
ಈಗ 51 lakhs ಇದೆ. 10 lakhs.
Please.
35 lakhs 40%, 10 lakhs ಮತ್ತೆ ಇನ್ನು 20% ಎಷ್ಟಾಗುತ್ತೆ? 25 lakhs.
ಹಿಂಗ ಹಾಕೊಳ್ಳಿ ಮಾ, ಇದನ್ನ ಕರೆಕ್ಟ್ ಫಿಗರ್ ತಗೊಳ್ಳಿ. 51, 21, 553. 21, 553. ಇದ್ರದ್ದು 40%, ಇದ್ರದ್ದು 50% ಮಾಡಿ. 51, 21, 553.
ಇಲ್ಲ ಬರುತ್ತಲ್ಲ.
ಇದು
25 lakhs, 26.
25 lakhs, 60,776.5.
ಇದ್ರದ್ದು 40% ತಗೊಳ್ಳಿ.
10 lakhs, 10.6.
10.6. ಇನ್ನೊಂದು 20% ತಗೊಳ್ಳಿ. ಅದರದನೆ ಇದಲ್ಲ
25 lakhs, 60,000, 20%. 60,776 ಅದಕ್ಕೆ 20%.
5,12,155.
ಇದರಲ್ಲಿ ಒಂದು ಸರ್ಟನ್ ಸಮ್ ಹೇಳಿದೆ ಅವ್ರಿಗೆ ಅಷ್ಟು ಕೊಡಬೇಕು
ಇಷ್ಟ ಕೊಡ್ಬೇಕಾಗಿರೋದು.
ಅಲ್ಲ, ಇವರಿಗೆ 10 lakhs, ಇವ್ರಿಗೆ 5 lakhs ಮಾಡಿ ಇವ್ರಿಗೆ ಇನ್ವೆಸ್ಟ್ ಮಾಡಿ.
ಎಸ್,
ಆದ್ರೆ ಬೇಕಂದ್ರೆ ಮೊದಲು ಜಾಸ್ತಿ ಕೊಡ್ತೀರಲ್ಲ, 6 lakhs ಕೊಡ್ತೀರ. ಅಲ್ಲ, ಅದಕ್ಕೆ ಇನ್ನೂ ಬರೋದಿದೆ. She is late with 73 years. ಆ ವಯಸ್ಸಲ್ಲಿ ಬೇಕಾಗುತ್ತೆ. Later adjust ಮಾಡಬೇಕು ಅಷ್ಟೇ.
ಬರ್ಕೊಳ್ಳಿ. Application in one of 2025 is filed. Is filed by the respondents 1 to 4, who are the claimants, seeking direction to release, seeking permission to withdraw the amount deposited by the appellant insurance company, full stop, by check dated 9/12/2024, the appellant insurance company has deposited a sum of rupees 51,21,553 in compliance with the interim order granted by this court. The tribunal has awarded the compensation to be apportioned amongst the respondents or claimants, the ratio of 40:20:20:20. Counts for the petition, appellant or insurance company submit, he has no objection in releasing 50% of the amount in deposit as sought for. In view of the order passed with the tribunal to apportion the amount as stated above, this court is of the view that the petitioner number 1, being the wife of the deceased, be permitted to withdraw a sum of rupees 10 lakhs. Petition number 4, being the mother of the deceased, who is presently aged about 76 years, be permitted to withdraw a sum of rupees 6 lakhs. The remaining amount shall be kept in the deposit amount as directed to tribunal.
Registration.
My lord,
Yes,
trial court's records may be sent back, my lord.
3 years as directed. Stop. The trial court record be sent by the registry for the aforesaid purpose and thereafter be summoned.
Much obliged.
IA disposed of accordingly.
May I dispose of the-
Cell number 25, Samarth Prakash.
Appear for appelling this matter, my lord.
You have not deposited the amount.
My lord, I verified, my lord, they told the deposit tomorrow, my lord.
See, unless you show us the proof of deposit, will not condone the delay.
Please, my lord,
That's
maybe
all.
post it, 3 days later, my lord. After
Yeah,
3 days time,
moreover,
I'll.
Amongst them, 3 are minors. Their mother has not turned up. You have to seek appointment of guardian for them.
Please, my lord.
Wait. Vinod, Sunday's daughter of Vinod. Oh, so respond number, who is the mother of respondents 3 to 5? They have to file application.
Please, my lord.
He told it out, respondent 3 to 5 are minors. Stated to be represented by their mother, a natural guardian. Respondent number 2.
ಅಲ್ಲ ಆಕಿನ ಡಾಟರ್ ಅಂತಾನೆ ಇದೆ.
Well, you know this petitioner,
Sonali,
father.
Sonali, and these are shown as
Father.
father.
Respondent number 1, my lord.
Father, respondent number 1. Petitioner, appellant to file necessary application for appointment of court guardian to the minor respondents 3 to 5. Is this matter on?
9-4.
My lord, interim order may be extended, my lord.
Don't deposit the amount, you don't even produce the proof.
Nane deposit ಮಾಡಿ.
Please, my lord, please, my lord. I will.
We are extended to next matter.
Cell number 26, Ashwin Kumar Shetty.
Lord, my request, the interim order may be extended to me to subject to me depositing the amount, my lord.
No, extended ಅಂತ ಹೇಳಿದೀವಿ till next year.
Please, my apologies.
But,
Please, my lord.
with your good offices, you see that is deposited.
I will ensure, my lord. Yes, my lord. Yes, my lord. Much obliged, my lord.
Cell number 26.
That is the insurance company, 127 days to list. Branch manager, Rayal Sundaram. Rayal Sundaram, ಯಾರಿದ್ದಾರೆ? ಇವನ್ನೇ ನೋಡಿದ್ದಾರೆ.
PB Raju, CR Ravishankar, HS Singraj, Ravi S. Sampati, K. Suryanarayan Rao, O. Manish.
ಮೊದಲು ಹೇಳಿದ್ರಲ್ಲ
CR Ravishankar, Ravi S. Sampati.
PB ರಾಜು ಒಂದು ಮಾಡಿ. PB ರಾಜು.
So that to take notice respond number 2. Issue notice respond number 1.
6. Cell number 27, Kavita HC, Padma S.
My lord,
Karatu.
I appear for the claimant appellants in this matter, my lord. This is an appeal regarding quantum delay, my lord, of 160 days.
Case of injury, death.
It's a case of death, my lord.
Name of the deceased is Sunil Kumar.
My lord, yes, my lord. Sunil.
Active in the cash.
160 days delay, my lord. It may be condoned.
Delay upon 6 days condoned. Admit. Call for records.
ಏನಿದು ಲೋಕ ಅದಾಲತ್ನಲ್ಲಿ ಸೆಟ್ಲ್ ಆಗುತ್ತೆ?
My lord, yes, my lord, yes.
Referred
My
to
lord,
ಲೋಕ ಅದಾಲತ್.
May be referred.
it may be referred or, my lord, it may be disposed of by your lordships.
No, no,
Very
you
short
see,
point for
Why
consent.
we should, what is the short point?
Please, only with regard to income, my lord.
Income.
Yes.
Notional income?
Yes, my lord.
Case of
No.
notional income.
Yes, my lord. Only 15,000 ought to have been taken, my lord, as per the Lokadalat charge. But 13,200 is taken.
Then you go and settle it in loka adalat.
Please, please, please. Yes,
Yes, obliged.
28, Kavita HC.
my lord, appeal by the claimants, my lord, case of death. Appeal challenging the quantum delay of 13 days in file.
Which insurance company is it? SBI General Insurance.
SBI General Insurance.
SBI, Ravi S. Sampati, B. Pradeep, Sharanappa Gowda, Malipati.
ಯಾರು ಡಿ ಪ್ರದೀಪ್ ಇಲ್ಲ ಸಂಪ್ರತಿ ಇಲ್ಲ ರವಿ ಸಂಪ್ರತಿ ಕೊಡಿ.
So and so that I take notice respond number 2. Should notice respond number 1.
Number 1.
My lord, notice to R1 may please be dispensed with, my lord.
You
Even-
yeah, send the memo
Please, my lord, I will. Even in the previous matter.
to sir Samprati.
Sorry,
Then we
madam.
condone delay because he is not here.
Yes, my lord, yes.
Seal number 29, Anandishwara DR.
This it there. Who is the insurance company? Notice sir ಒಂದು ಹೇಗೆ ಕಂಡೋನ್ ಮಾಡೋದು? ರಾಯಲ್ ಸುಂದರಂ. ಯಾರಿದೆ ರಾಯಲ್ ಸುಂದರಂಗೆ?
Royal Singh.
ಏನ್ ಮೆಮೊ ಕೊಡ್ತಾ ಇದ್ದಾರೆ ಅವರು?
Dispensation, Kavita Hits. PB Raju, CR Ravishankar, Ravi Sankati, HS Raj, O Mahesh.
So also that I take respond number 1. Respond number 3.
CR Ravishankar. CR Ravishankar. For R3. What about R1 and 2? You are filing memos?
Memo is filed seeking dispensation to notice respond number 1 and 3 is dispensed with the risk and request of the appellant. 1 and 2, yes.
What is the point involved? Okay, it's a case of injury, na? ಅವರಿಲ್ಲ ಇದ್ರೆ ಡಿಲೇ ಕಂಡೋನ್ ಮಾಡಬಹುದಿತ್ತು. We'll have it after 2 weeks. You serve the copies on him. 304 days ಇದಾಗಿದೆ, 72. Sir, the copy on him. After 2 weeks. Please.
Seal number 30, adjourned. Seal number 31, Chetan B, SPP.
ಅವರೆಲ್ಲ ಲೋಕದಾಲ ಶುರುವಾಗಿದೆ ಕನ್ನಡ. Otherwise, they used to be here.
Here for the appellant.
320.
Seal number 31.
31. 30 is adjourned.
30.
Yes.
Lord, the appellant is convicted for the offense under section 302.
302, 307.
Yes, my lord.
Elder brother of the deceased.
Lord, during the course of the trial, my lord, he was enlarged on bail. And this honorable court, my lord, earlier granted bail on the ground that, my lord, all the material witnesses, my lord, who were examined have turned hostile. Lord,
Eyewitness also has not supported this
No.
injured witness.
no, my lord, he is the father. My lord,
Oh,
court,
he's the father.
father. My
That
lord,
is,
my lord, court says that, my lord, since he is the father,
certificates say he came with a history of assault or no? 164 statement is there. Whose 164 statement is this? Exhibit P6?
for 164 statement.
ಯಾರ್ದದು? 56 final opinion of the records ಬಂದಿದೆ. Yes, SPP, what are the
Notes. The trial court has taken,
discriminating evidence?
the trial court has taken into consideration, my lords, evidence of Peter Loan, father of the deceased.
Father of the deceased.
Yes, my lords, though he has turned partly hostile to the case of prosecution, they have supported him, my lords, in the cross-examination of the prosecutor, my lords, he has admitted all the facts. My lords, thereafter, my lords,
Cross-examination he admitted.
yes, my lord, that is what the observation made with the trial court, my lords.
PW9.
Page number 12 of the judgment, my lords.
Then,
And has taken into consideration evidence of PW 2 and 3.
father was examined as PW?
One, my lords. And evidence of PW 2 and 3, my lords. 3 has seen, my lords, the accused going from the house, my lords, on the motorcycle.
Cross-examination. Oh, one of the witness was an advocate.
The accused, who happens to be brother of the deceased, my lords, and PW is father of accused, my lords.
Name of the accused is?
Mohan, my lord.
Mohan. Sir, who are these doctors? PW9 and PW13 ಒಬ್ರು postmortem ಮಾಡಿದವ್ರು ಇರ್ಬೇಕು.
13 Millards is the Dr. Millards has conducted postmortem, but EM report has been marked with consent.
PW9?
Dr. Millards who has examined PW1 injured Millards who has issued one certificate. Before whom history has been given Millards
That's what we are asking.
and recoveries.
One is
Millards,
ಮಲ್ಲಪ್ಪ ಅವರ ಮಗಳು ಮಮತಾಗೆ ಹಲ್ಲೆ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಚಿಕಿತ್ಸೆಗಾಗಿ ಬಂದಿರುತ್ತಾರೆ. What is the defense theory about cause of death of his brother?
My lord, Lord, the accused defense before the trial court was, Lord, he was not in the spot, my lord,
Yeah,
when
fine.
the.
Correct. Death
Yes.
is homicidal.
Yes,
That he has not
yes,
disputed.
Yes, yes,
According to him, what is the cause of death of his brother? Why he did not file any complaint?
my lord, he was.
His brother died of.
he has taken plea of alibi Millards.
ಇರ್ಲಿಲ್ಲ ಅದ್ರ ತನ್ನ ಬ್ರದರ್ ತೀರೋಗಿದ್ದಾರೆ ಅಂತ ಗೊತ್ತಾದ್ರೆ why should he? What is the profession of this accused?
My lord, he was working, my lord, as a coolie and some.
Coolie.
Yes,
What was deceased? What was his?
he was also an agriculture, my lord, they were all agricultural background, my lord.
But your father was taken to the hospital with history of assault. Which is that exhibit documented?
P20 Millards.
P20. History of assault on 12 midnight by his son named Mohan, the first point of time in evidence, who was strangulated by his son, not a case of chronic diabetes related to HDL, hypertension.
My lord,
So, at the earliest point of time, your father was taken to the hospital with a history of assault by you. Son Mohan.
no, my lord, I have not taken, my lord.
Neevalla. When this father was taken to the hospital, he was taken there with a history of assault by son Mohan. That
Yes.
is accused.
Yes, my lord. Lord, the appellant, my lord, is an HIV patient, my lord. And that was all.
Recovery of blood-stained clothes are there, Millards. He has been apprehended after one. Millards, 20 days.
Family members. ಗಲಾಟೆ ಮಾಡುವಾಗ ಈ ಕೇಸಿನ ಮೊತ್ತ ಉಮೇಶ್ ಸಾಕ್ಷಿ ಮಾಡಿ ಜಗಳವನ್ನು ಬಿಡಿಸುತ್ತಿದ್ದರಿಂದ ಮೋಹನ್ ಸಾಕ್ಷಿ ಮಲ್ಲಪ್ಪ ಈ ಕೇಸಿನ ಬೆಳೆಸುತ್ತಿದ್ದು He was younger brother or elder brother? Umesh.
My lord, younger brother.
During the trial, he was in custody.
No, my lord, he was on bail, my lord. This honorable court granted bail, my lord, in criminal petition 7503/2023, on the ground that, my lord, all the material witnesses have turned hostile.
During that, after trial commencement, he was given.
Yes, my lord. My lord, 7 witnesses were examined when the bail was granted by this honorable court. My lord.
7 witnesses were all material witnesses.
Material witnesses.
But PW9 was not examined.
No, Millards, that time he was not again.
Where is the material to show that he's HIV infected?
That ground is also,
You have taken that ground in your application.
Lord, I have not mentioned in my grounds of,
Consider in the application.
Lord?
Nothing about in the application.
Na ಏನು?
Lord, I may permitted to produce that document. Lord, there are document.
Ground ಮಾಡ್ದೇನೆ. Learned counsel. Case is based on circumstantial evidence as well as the evidence of eyewitness, but none else but the father injured. Though he partly
My Lord, you
turned
can't ask.
hostile, before the doctor has given the history implicating this person, does not seem to be a case for suspension.
My Lord, I'll produce the medical record, my Lord, to show that he
You
is.
can seek, hearing ಅಷ್ಟೇ. Post conviction.
Lord, a week's time may be granted, my Lord. A week's time may be granted. I'll produce the documents, my Lord.
Where
Medical
is he taking treatment for that?
My Lord?
Where is he taking treatment?
My Lord, he has taken treatment at, my Lord, Tumkur District Hospital, my Lord.
Who had referred from the jail? He was referred or?
My Lord, yes, my Lord, jail, he was also referred, and there are materials, my Lord. I'll produce it before this honorable court, my Lord. Next week, next Monday, it may be taken.
But your application doesn't support that averment.
Yes, my Lord, I'll make,
No whisper in the application, that's what we say.
I'll produce it.
Record ಮಾಡ್ಕೊಳ್ಳಿ, ನಾನು ಮತ್ತೆ ಮುಂದಿನ ಸರಿ ಮರ್ತೋಗಿರುತ್ತೆ ನನಗೆ.
Counsel for the petition appellant submits that one of the grounds seeking suspension of sentence is that the appellant is suffering from HIV and is under treatment. Full stop. No such ground is apparent from the memorandum of facts enclosed to the application. At this juncture, counsel for the appellant seeks weeks accommodation to file better affidavit along with the medical records in that matter. Weeks time granted.
Because he is in custody.
Yes.
ಏನು legal service in
ಇಲ್ಲ, ಇಲ್ಲ.
This
2-4.
matter.
2-4. Seal number 32, VM Siddhappa.
Lord, it's a climate appeal, my Lord. Delay may be condoned 98 days.
ನೋಟಿಸ್ ಇನ್ನೂ ಹೋಗಿರೋದಿಲ್ಲ ಅಂದ್ರೆ ಡಿಲೇ ಮೇ ಬಿ ಕಂಡೌಟ್ ಅಂತ ಹೇಳ್ತೀರಿ.
Mainly issues notice, my Lord. Respondent 1 and
ಮ್ಯಾನೇಜರ್ HDFC ಜನರಲ್
PC Shivan.
ಇವರಿದ್ದಾರೆ ಪ್ರದೀಪ್ ಇಲ್ಲ ಅವ್ರ ಜೂನಿಯರ್ ಇಲ್ಲ ಹೇಳಂತ ಶ್ರೀ ಪ್ರದೀಪ್ ಲರ್ನರ್ ಕೌನ್ಸಿಲ್ ಇಸ್ ಡೈರೆಕ್ಟ್ ಟು ಟೇಕ್ ನೋಟಿಸ್ ಅಂತ ಬರ್ಕೊಳ್ಳಿ. ವಾಟ್ ಅಬೌಟ್ ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 1? ನೋಟಿಸ್ ಟು ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 1.
my Lord.
ನೋಟಿಸ್ ಟು ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 1
My Lord.
ಏನಾಗ್ಬೇಕು? ಹೋಗ್ಬೇಕಾ ಡಿಸ್ಪೆನ್ಸ್
Driver,
ಆಗ್ಬೇಕಾ?
owner and driver. Owner Toyota Innova car, my Lord. Respondent number 1.
Shall deposit. Then you file memo for dispensation of notice to that respond number 1. ನಿಮ್ ಸೀನಿಯರ್ ನಿಮ್ಗೇನು ಹೇಳಿಲ್ವಾ? ಎಂ ಸಿದ್ದಪ್ಪ ಹೊರಪುಲಿಗ ಅವರು
Next ಮಾಡ್ತೀನಿ.
ಏನ್ ಹೇಳಿದ್ದಾರೆ? ನೋಟಿಸ್ ಅಂತ
Notice response.
16-6. For admission, seal number 33.
ಆಫೀಸ್ಗೆ ಹೋಗಿ ಬರ್ತೀರಾ ಹೇಗೆ?
ಹಾ,
ಆಫೀಸ್ಗೆ ಹೋದ್ರಿ ಈ ಫೈಲ್ ನಿಮ್ಗೆ ಯಾವಾಗ ಕೊಟ್ರು ಇದನ್ನ ಅಟೆಂಡ್ ಮಾಡ್ಬೇಕು ಅಂತ?
ಬೆಳಗ್ಗೆ ಕೊಟ್ಟು.
ಹಾಯ್ ನಿನ್ನೆ ಹೇಳಿದ್ರಾ ಇವತ್ತು ಹೇಳಿದ್ರಾ?
ಬೆಳಗ್ಗೆ ಹೇಳಿದ್ರು.
ಬೆಳಿಗ್ಗೆ ಹೇಳಿದ್ರ ಫೈಲ್ ಅವಾಗ ನೋಡಿದ್ರಾ?
Lord.
ಫೈಲ್ ಡಿಡ್ ಯು see the file?
ಆಮೇಲೆ ನಾನು ನೋಡಿದ್ದೀನಿ.
ನೋಡಿಲ್ಲ.
ನಾನು ನೋಡಿದ್ದೀನಿ.
ನೋಡಿದ್ದೀರಾ?
ರೆಸ್ಪಾಂಡೆಂಟ್ಗೆ ಇಶ್ಯೂಸ್ ನೋಟಿಸ್ ಮಾಡಬೇಕು ಅಂತ.
ಹಾ?
ರೆಸ್ಪಾಂಡೆಂಟ್ಗೆ ನೋಟಿಸ್ ಇಶ್ಯೂಸ್ ಮಾಡಬೇಕು ಅಂತ ಹೇಳಿದ್ರು.
ನೋಟಿಸ್ ಮಾಡು ಅಂತ ಹೇಳಿದಂತ ಅಷ್ಟೇ ಹೇಳಿದ್ರಾ? ಸರಿ.
Seal number 33, B Pradeep, Shripad B Shastri.
Appellant. Case of death, man. The driver of offending vehicle, my Lord, having only DL of LMB, my Lord. LGV, my Lord, light goods vehicle.
ಏನ್ RTO ಎಕ್ಸಾಮಿನ್ ಮಾಡಿದೀರಾ?
Yes, RW2.
PW1 ಗೀತಾ
RW2, my Lord, HR Kumar.
ಅಂದ್ರೆ ಪೇ ಅಂಡ್ ರಿಕವರ್ ಅನ್ನು ಆರ್ಡರ್ ಮಾಡಿಲ್ವಾ?
No, my Lord, liability is passed on insurance company, my Lord.
Yeah. ಪೇ ಅಂಡ್ ರಿಕವರ್ ಮಾಡಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ. ಲೈಸೆನ್ಸ್ ಇದ್ದು ಎಂಡಾರ್ಸ್ಮೆಂಟ್ ಬೇಕಾಗಿಲ್ಲ ಅಷ್ಟೇ. ಅದನ್ನಾದ್ರೂ ಚೆಕ್ ಮಾಡೋದಕ್ಕೆ ಒಪ್ಪಿದ್ರೆ ನಾವು ಅಷ್ಟನ್ನೆಲ್ಲ ಮಾಡ್ತೀವಿ. ಪೇ ಅಂಡ್ ರಿಕವರ್. First respondent shall deposit the compensation amount in the tribunal within 2 months. Who was first respondent? Insurance company.
Mother, madam.
What was your defense? He was not
Not having valid DL, my lord.
So ಹಾಗಿದ್ರೆ ಏನಾಗುತ್ತೆ? ಪೇ ಅಂಡ್ ರಿಕವರ್ ಆಗುತ್ತೆ. ಅಲ್ಲ, ಬಟ್ ಈಸ್ ಎಂಟೈಟಲ್ ಟು ಹೋಲ್ಡ್ ಅಂತ ಇದೆ, ಅದಕ್ಕೆ ಬೇಕಾಗಿಲ್ಲ ಅದರಲ್ಲಿ. ಇಫ್ ಈಸ್ ಹೋಲ್ಡಿಂಗ್ ದಟ್ ಲೈಸೆನ್ಸ್ ಆಫ್ ದ ಸೇಮ್ ಕ್ಲಾಸ್, ದೆನ್ ಎಂಡೋರ್ಸ್ಮೆಂಟ್ ಇಸ್ ನಾಟ್ ರಿಕ್ವೈರ್ಡ್. ಅವಾಗ ಯು ಆರ್ ಲೈಬಲ್ ಟು ಪೇ. ವ್ಯಾಲಿಡ್ ಡ್ರೈವಿಂಗ್ ಲೈಸೆನ್ಸ್ ಇಲ್ಲ ಅಂತ ಹೇಳಿದ್ರೆ ಅವಾಗ ಪೇ ಅಂಡ್ ರಿಕವರ್. ನಿಮ್ ಡಿಫೆನ್ಸ್ ಏನಿತ್ತು ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ?
Same, my lord. Not having a valid DL ಅಂತ ಹೇಳಿ.
Call for records.
34, Lokesh Bhuvanahalli, S. Srishaila.
Claimant's appeal. Case of death, challenging the quantum of
ಅಡ್ಜರ್ಮೆಂಟ್ ಕೇಳ್ತಾ ಇದ್ರು ಅಂತ 85 ಅಡ್ಮಿಟ್ ಮಾಡಿ ಇದು ಮಾಡ್ತೀವಿ ಅಂತ ಹೇಳಿದ್ರು. 85 ಏನು ವಾಟ್ ಗ್ರೌಂಡ್?
quantum, challenging the quantum of
ಕ್ವಾಂಟಮ್
compensation.
ಯಾವ ಗ್ರೌಂಡ್ ಮೇಲೆ ಚಾಲೆಂಜ್ ಮಾಡಿ?
Assessment of, he was an income tax assessee. The tribunal has taken instead of taking the assessment year, action for the year 2017. Instead of taking the assessment year, it was taken 3 years back.
ಕರೆಕ್ಟ್. ಅಂದ್ರೆ
14-15 ತಗೊಂಡಿದ್ದಾರೆ.
ಎಷ್ಟು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ರಿ ನೀವು? IT ರಿಟರ್ನ್ಸ್,
Income tax,
IT ರಿಟರ್ನ್ಸ್ 2014, 15, 15, 16, 16, 17.
16-17.
ಯಾವಾಗ ಸಬ್ಮಿಟ್ ಮಾಡಿದ್ದು ಅದನ್ನ? ಡೇಟ್ ಆಫ್ ಆಕ್ಸಿಡೆಂಟ್ ವಾಸ್
Before,
4/1/2017.
date of accident. Prior to this,
Submitted it after the accident.
no.
2016, 17 ಅದು.
It was submitted in the month of October 2016.
ಅವರೇನೋ ಬೆಳಿಗ್ಗೆ ಟೈಮ್ ಕೇಳ್ತಿದ್ರು.
22/10
ಲಿಸ್ಟೆಡ್ ಫಾರ್ ಹಿಯರಿಂಗ್. We'll admit and list it for hearing because he was sitting at jail.
Yes, admit.
And it may also be referred to Lok Adalat. It's only issue.
ಆಗ್ಬೋದಾ?
Represent local authority.
ಸರಿ ಹೇಳ್ತಾರೆ. ಈಗ ಇವ್ರು ಹೇಳೋದು ಕರೆಕ್ಟ್ ಅಲ್ಲ. 2016-17 ವರ್ಷ ಸಬ್ಮಿಟ್ ಮಾಡಿರ್ತಾರೆ ಅವರು. ಅವಾಗ ಇನ್ಫ್ಲೇಷನ್ ಮಾಡಿ ಹಾಕಿರ್ತಾರೆ. ಇದು ತಗೋಬಹುದು, ಅವ್ರು ಇದು ತಗೊಂಡಿದ್ದಾರೆ ಅಂತ ಹೇಳ್ತಾರೆ. ಯಾವತ್ತು ಸಬ್ಮಿಟ್ ಮಾಡಿದ್ದಾರೆ? ಆಯ್ತು, ಲೋಕಲ್ ಆಗೋ ಚಾನ್ಸ್ ಇದೆಯಾ?
In this regard only we are disputing the same.
ಆಯ್ತು, ಪರ್ಸನ್ ಸರಿ ಹೋಗಿ ಬರ್ರಿ.
If it is,
ಆಸ್ ರಿಕ್ವೆಸ್ಟೆಡ್ ರೆಫರ್ ಟು ಲೋಕಲ್
Lokadala. Still number 35,
ಅಡ್ಮಿಟ್ ಮಾಡಿ ಲೋಕಲ್
big,
ಅಡ್ಮಿಟ್ ಅಂತ ಬರ್ಕೊಂಡು ಆಸ್ ರಿಕ್ವೆಸ್ಟೆಡ್.
still number 35, Dhanush Menon, V. Pradeep.
Provisions.
Claimant has been dismissed, my lord.
For the appellant, my lords, I thought it's no longer with our office, so we have been in touch with the party. The lord is on the grant.
Plus 160. So you want to convert 163 AP to 166?
Yes, madam. This is himself as driving the car, madam.
Driving the
Car.
victim himself driving the
Yes.
car. Oh. ಬರೋದಿಲ್ಲ. ಅದಕ್ಕೆ ಅವರು 163 ಮಾಡೋದು. ಅಂದ್ರೆ ಅದು 163 ಏನೂ ಬರೋದಿಲ್ಲ ಅಂತ ಇದೆ. Who is the advocate on record? Dhanush Menon.
He's no longer with our office, my lords. So, get in touch with the party.
Office ಅವರಾಗೆ. Who is the ಯಾವ? Amendment application has to be heard along with.
IA 1 of 2019 be heard along with the main admit.
2018 matter, you should have to do something.
We'll just seek instructions, then it may be decided on merits.
Yes.
Started good.
9-4.
Right.
Wait,
Cell number 36, Trimurthy KP.
Husband's petition for divorce on the ground of cruelty is dismissed, my lord.
Your case was not accepted?
Yes, dismissed.
have
The
no one
wife has made an allegation that the husband had an affair with his staff. And some photographs are produced. She has given police complaint also.
Admit call for it.
Issue notice.
Notice are right.
Issue notice to respondent.
Much of it.
16-6.
16-6.
Much of it.
Cell number 37, Raghunath MD, Monica Patil.
I appear for the appellant, my lords.
Come to the respondent.
In fact, my lords had on the last occasion directed both the parties to be present before my lords. In fact, the appellant is present.
Your lordship, respondent is suffering from cancer, lordship. If you may permit, we will file the necessary medical reports on the next day.
On last two occasions also, my lords had directed. In fact, both are senior citizens, my lord.
What is he suffering from?
Cancer, your lordship.
She is, which cancer?
No documents have been produced till date before. I understand. I understand.
Next date will produce the medical record. your
We are not asking for medical records. Are you aware what kind of cancer she is suffering from? Is she right now under any chemotherapy or something? He must be knowing what if disease his wife has.
She's been cured of it is what my client says. my lord.
Oh, my lordship.
She earlier had, no doubt, but now she has been recovered. She has recovered.
Sure. ಯಾವ ತರ ಏನಾಗಿತ್ತು ಎಂತ ಕ್ಯಾನ್ಸರ್ ಆಗಿತ್ತು? Trial court judgment already contention ತಗೊಂಡಾರೆ. Is she not? She could have appeared virtually at least.
If your lordship may permit, will,
What we tried last time, we were there and during last hearing.
my senior was there, lordship.
We wanted to advise the parties at this age, if something happens to somebody, the case abates either to him or to her.
No doubt.
Why at this age this, so we wanted to just interact with the parties regarding that.
Your lordship, date may be fixed. I'll ask our client to appear through
They
online.
have two children,
Yes, my lords. Both are married. They have two daughters.
right? Till
Both the
then,
daughters are married.
they were staying with whom?
In fact, one is in support of the father, the other one is in support of the mother, my lords.
And she's taking care of the mother.
She's
No, I'm
taking
sorry.
care of.
Yes.
No, that's
No, no, right? When she was suffering from cancer, who was
all was taken care of.
Daughter was taking care of.
In fact,
See,
my only
he
humble
is
submission.
not remarried. He has
Pardon,
not
ma'am?
remarried.
No, my lords.
ಮತ್ತೆ ಯಾಕ್ರಿ ಈ ಏಜಿಗೆ ಇದೆಲ್ಲ ಬೇಕು? ಈ ಕಡೆ ಬನ್ನಿ ಸ್ವಲ್ಪ. ಈ ಕಡೆ ಬನ್ನಿ. ಏನಾದ್ರೂ ಕ್ರಿಮಿನಲ್ ಕೇಸಸ್ ಏನಾರ ಆಗಿತ್ತಾ?
Either Swami. There's one pending, my lords.
ಕ್ರಿಮಿನಲ್ ಮಿಸ್ಲೇನಿಯಸ್ ಇದೆ.
Yes, my
ಈ ಕಡೆ
lords.
ಬನ್ನಿ. ಅಲ್ಲ ಬೇರೆ ಯಾವ್ದು 498 ಅಂತದ್ದು
ಆ ತರ ಏನಿಲ್ಲ. Only maintenance petition has been filed.
correctly last time we also asked
Yes, ma'am.
to advise the parties, it seems.
Of course, my lords. My only humble submission is this. I would leave it to my lords to
You are not
mediate.
You are not eligible for this case.
Of course, my lords, I'm too young for this case. That's why I would leave it to my lords for mediation.
ಯಜಮಾನ್ರಿ ಈ ವಯಸ್ಸಿಗೆ ನೋಡಿ ನಿಮ್ ಹೆಂಡತಿ ಏನಾರ ತೀರ್ ಹೋದ್ರೆ ಈ ಕೇಸು ಅಬೇಟ್ ಆಗುತ್ತೆ, ಅಥವಾ ನಿಮಗೆ ಏನಾರ ಆದ್ರೂ ಈ ಕೇಸ್ ಅಬೇಟ್ ಆಗುತ್ತೆ. ಏನು ಅವ್ರು ನಿಮ್ಮನ್ನ ಸಾಯಿಸಕ್ ಪ್ರಯತ್ನ ಮಾಡಿದಾರೆ ಅಂತ ಏನಾದ್ರು ಕ್ರಿಮಿನಲ್ ಕೇಸ್ ಆಗಿದೆಯಾ? ಸಾಯಿಸಕ್ ಪ್ರಯತ್ನ ಮಾಡಿದಾರೆ ಅಂತ ಏನಾದ್ರು ಕ್ರಿಮಿನಲ್ ಕೇಸ್ ಆಗಿದೆಯಾ? ನೀವೇನಾರ ಹಾಕಿದ್ರಾ ಕಂಪ್ಲೇಂಟ್? ಅಲ್ಲ ನಿಮ್ಗೆ ಏನಾದ್ರು ಶುಗರ್ BP ಲೋ ಶುಗರ್ ಆಗಿನೂ ಹಂಗಾಗಿರ್ಬೋದು ನಿಮ್ಗೆ. ಎಲ್ಲ ನೋಡಿ ವಿಚಾರ ಮಾಡಿ, ನೀವಿರೋ ಅಲ್ಲಿ ಎಲ್ಲೆಲ್ಲಿ ಬೇರೆ ಇರ್ತಿರೋ ಹಾಗೂ ಇಟ್ಕೋಬಹುದು. ಈ ಕೇಸ್ ಈ ವಯಸ್ಸಾಗಿ ನಿಮ್ಗೆ ಎಷ್ಟು ಈಗ ವಯಸ್ಸು? ನೀವ್ ಅಲ್ಲಿ ಹೋಗಿರಿ ಅಂತ ಹೇಳ್ತಾ ಇಲ್ಲ, ನೀವ್ ಎಲ್ಲಿರ್ತಿರೋ ಈಗ ನಿಮ್ಮ ಒಬ್ರು ಮಗಳು ಒಂದ್ ಕಡೆ ಒಬ್ರು ಮಗಳು ಒಟ್ಟಿಗೆ ಇದೀರಿ ತಾನೆ. ಹೀಗೆ ಜೀವನ ನಡೆಸ್ಕೊಂಡು ಹೋಗ್ಬೋದಲ್ಲ ಇನ್ನೆಷ್ಟು ದಿವಸ. ಅಲ್ಲ ಕರೆಕ್ಟ್. ಈಗ ನೀವು ಡೈವರ್ಸ್ ತಗೊಂಡು ಏನ್ ಮಾಡೋರು? ಅಕಸ್ಮಾತ್ ನೀವೀಗ ಕೆಳಗಿನ ಕೋರ್ಟಲ್ಲಿ ನಿಮ್ ಪರವಾಗಿ ಆಗಿಲ್ಲ, ಅಕಸ್ಮಾತ್ ಆಗಿ ಡೈವರ್ಸ್ ಆದ್ರೆ ಏನ್ ಸಾಧನೆ ಮಾಡಲ್ಲ. ಈಗ ನಿಮ್ ಪಾಡಿ ನೀವು ಬೇರೆ ಬರೋಲ್ಲ ಸರಿ. ಈಗ ನಿಮ್ಗೆ ಯಾರು ನೋಡ್ಕೊಳ್ತಾರೆ? ಜೊತೆಗೆ ಯಾರು ಇರ್ತಾರೆ? He's staying alone
Please, my lords.
and she's staying.
She's staying in a different portion of the house. On the hind side, my lords.
Living in different parts.
Different. Yes, my lords.
ಈಗ ಹೇಗಿದ್ದೀರೋ ಹಾಗೆ ಇಟ್ಕೊಂಡಿರ್ಬೋದಲ್ಲ. ಹಾಗೆ ನೀವು ಸೇರ್ಕೋಬೋದಲ್ಲ ನಿಮಗೆ ಆಶ್ರಮಕ್ಕೆ. ಈಗಲೇ ಬರೋದಿಕ್ ಬಿಡ್ಬೋದಲ್ಲ, ಯಾರಿಗೇನ್ ಬರ್ಬೇಕು ಅಂತ ನಿಮ್ ಜೀವನ ಮುಗಿದ ಮೇಲೆ. ಅಲ್ಲ ನಿಮ್ ಜೀವಮಾನ ಮುಗಿದ ಮೇಲೆನೆ ಅವ್ರಿಗೆ ಹೋಗ್ಬೇಕು ಅಂತ ಬರೆದು ಕೊಡ್ಬೋದಲ್ಲ. ನಿಮಗೆ ಬ್ರದರ್ಸ್ ಮತ್ತೆ ಯಾರು ಸಿಸ್ಟರ್ಸ್?
ಮೊಮ್ಮಕ್ಕಳು ಜನ ಏನ್ ಮಾಡ್ತಾರೆ? ಏನ್ ವಯಸ್ಸು ಅವ್ರಿಗೆ?
ಮೊಮ್ಮಕ್ಕಳು 21 ವರ್ಷದವ್ರಿದ್ದಾರೆ.
ನಿಮ್ಮ ಸ್ವಂತ ಮನೆಯಲ್ಲಿ ಯಾರು ಇದ್ದಾರೆ? ಅವರಿದ್ದಾರೆ. ನೀವು ಬಾಡಿಗೆ ಮನೆಯಲ್ಲಿದ್ದೀರಾ?
ಬಾಡಿಗೆ ಮನೆಯಲ್ಲಿ. ಮತ್ತೆ ಅವ್ರು ಹೇಳಿದ್ರು ನೀವು ಒಂದೇ ಬಿಲ್ಡಿಂಗ್ ನಲ್ಲಿ ಬೇರೆ ಬೇರೆ ಭಾಗದಲ್ಲಿ ಇದ್ದೀರಿ ಅಂತ.
That was earlier, my lords. That was earlier.
ಡಾಕ್ಟರ್ಸ್ ಎಲ್ಲಿದ್ದಾರೆ? ಏನ್ ಮಾಡ್ತಾರೆ ಅವರು? ನೀವು ಚೆನ್ನಾಗಿ ಇಟ್ಕೋಬೇಕು. ಬರೀ ಅವ್ರಿಗೆ ಬ್ಲೇಮ್ ಮಾಡ್ಕೊಂಡಿದ್ರೆ ಹಾಗೆ.
ತಂದೆ ಮತ್ತೆ ಕೇಳಿಲ್ಲ ಅಂತ ಅಲ್ಲಿ ಇರ್ಲಿ ಏನೇ ಇರ್ಲಿ, ನಾವು ನಿಮ್ ಬಗ್ಗೆ ಏನು ಹೇಳ್ತಾರೆ. ಮುಂದಿನ ಸರಿ ಅವ್ರ ಮಕ್ಕಳನ್ನ ಏನಾದ್ರು ಕರ್ಸಕ್ಕಾಗತ್ತಾ? ಇವ್ರ ಮಕ್ಕಳನ್ನ ಕರ್ಸಕ್ಕಾಗತ್ತಾ? ಡಾಟರ್ಸ್ ನೀವಲ್ಲರಿ ಅವ್ರಿಗೆ ಕೇಳ್ತಾ ಇದ್ದಾರೆ. ಇಫ್ ದೇ ಆರ್ ಕನೆಕ್ಟೆಡ್, ಒಬ್ಬಳು ಡಾಕ್ಟರ್ ಒಬ್ಬಳು ಮಗಳು ನಿಮ್ಮ ಹತ್ರ ಬರ್ತಾರೆ ಅಂತ ಹೇಳ್ತಾರೆ ಅವರು. ಇದೆಲ್ಲ ಇದೆಲ್ಲ ಯಾಕೆ ಬೇಕು? ಕೊನೆ ಹಂತದಲ್ಲಿ ಎಲ್ಲರೂ ಕೂಡ ಚೆನ್ನಾಗಿ ಬದುಕೊಂಡು ಇರ್ಬೋದಲ್ಲ. ಕರ್ಸೋಣ, ನಿಮ್ ಮಕ್ಕಳನ್ನು ಕರೆಸಿ ಮಾತಾಡೋಣ, ಅವರನ್ನು ಕರೆಸಿ ಮಾತಾಡೋಣ ಅಂತ ಹೇಳಿ. ಅವ್ರನ್ನು ಕರೆಸಿ ಕೆಳಗಿನ ಕೋಟಲ್ಲಿ. ಕರೆಕ್ಟ್. ನೀವ್ ಯಾವ್ದು ಪ್ರಾಣಕ್ಕೆ ಅಪಾಯ ಇದೆ ಅಂತ ಯಾವ್ದು ಕೇಸ್ ಹಾಕಿದ್ ಕಾಣ್ತಾ ಇಲ್ವಲ್ಲ ಇಲ್ಲಿ. ಅವ್ರ ಮೇಲೆ ಏನು ಕೇಸ್ ಹಾಕ್ತಾರೆ ನಿಮಗೆ? ಲೀಗಲ್ ಸರ್ವಿಸ್ ಅಥಾರಿಟಿ ಅಡ್ವೊಕೇಟ್ ಆರ?
No, my lords. He's been, yes, my lords. Earlier in the lower court, he had 3 different advocates, my lord. Yes, my lords. For the appeal, I'm the advocate on record, along with my senior, my lords, Mr. M.D. Raghunath. M.D. Raghunath. Please, my lords.
Ask their children also, daughters also to be present on the next hearing date and it seems she was unwell during the trial. ಈಗ ಇದ್ರೆ ಒಂದ್ಸರಿ ಬರ್ಲಿ, ಏನೋ ಪ್ರಯತ್ನ ಮಾಡಿದ್ರೆ ಏನು
A date may be fixed, my lords. But my only humble submission is let the respondent also appear, my lords, because the appellants have been coming.
But Lordship, she may be allowed to appear through VC a lot.
ಪರ್ಸನಲಿ ಬಂದಷ್ಟು ಇಫೆಕ್ಟಿವ್ ಆಗೋದಿಲ್ಲ. Time on the ground that respondent is unwell, which is disputed by the other side. After interacting with the appellant for some time, it is found that presence of the daughters of the couple also may help in the conciliation. Now daughters are sailing with her. Therefore, counsel for respondent is requested to keep it is submitted that the daughters are sailing well with the respondent mother. Therefore, the counsel for respondent is requested to keep respondent and her daughters present in the next hearing date, and the appellants shall also be present to report on the next hearing date. List on
8-4.
Please, Agli, sir.
8-4.
Because I would leave it to my lords to mediate the said issue, my lords.
Because as a lawyer, we also
I understand, my lords.
they trust more their lawyers than the
At the same time, I have to bow down to my lords, please. Much obliged.
Number 38, Harish Kumar MC, Ashok B. Patil.
May I please, Lordships? I appear for the respondent wife, and I think the trial court records may be necessary to be summoned. At admission stage itself, matter could be.
Not admitted, your worship. ಮಾಡ್ಬೋದು.
Admit call for TCR.
The admission may kindly be, I mean, Lords, after the receipt of the TCR, it could be considered.
Admit it and call for TCR. Both say.
Cell number 39, Srinivas V. Nagaya for KV respondent.
Appearing for respondent.
Petitioner, my lord, suit for divorce filed by husband, my lord, maintenance was not paid, my lord. Suit.
This we are making a remark. All youngsters only come for these matrimonial cases.
Senior is an out of station, my lord.
It's out of station, Srinivasan.
Yes, my lord.
So what is the decree granted? Decree for dissolution of marriage.
Please,
Admit and grant stay.
please.
Request for stay. Stay.
Stay will also be
Admit
granted.
stay of judgment and order dated 4/2/2025, passed the MC number 10 of 2024 on the file of principal judge, principal family court at Kodagu Madikeri. Call for records.
Cell number 40, Charan Kumar KV.
For the appellant challenging the decree for divorce and permanent alimony
6 lakh, madam.
Passed by the
What is your prayer in the appeal? Your grievance is against divorce decree or only about alimony
Divorce decree and alimony.
as well?
Yes.
Is your age 26 and 34?
Yes, same order.
Please take also this thing.
Much.
Film
Issue notice,
41.
issue notice.
Applied. In
Since-
this case,
Film 41.
all the three are connected, madam. We filed the WS. WS was taken on record. On the same day, it was posted for judgment saying that you have not filed application for recalling. We advance it and file a recalling application. That is also dismissed. Judgment is pronounced. Now, kindly, ink page 66 may be taken out. Ink page 66. On 4/11/24, the Honorable Court allows my application to take the WS on record. But thereafter, the court says that since you have not filed any application for recalling the witness for cross-examination, posted it for judgment on the very same day by taking the WS on record. So, no. She also happens to be a claimant. She is the LR Sidrele Vartar. Our mother, father and mother filed it. She is the mother-in-law. Mother-in-law.
Mother is, daughter is alive.
Daughter Allah. Son's son expired, earlier son expired. Son's job was given to daughter-in-law. Now the daughter-in-law expires in the accident.
Claimants were the
Father, mother, and I, no. Wife only was given the
Chaitra, no?
Chaitra.
They are the parents of Chaitra.
Parents of Chaitra, mother-in-law.
What job she was doing?
No, she was the lecturer soon. She was the lecturer.
Same petition was of the year 2023.
House 23.
Says only regarding release.
House.
Admit note.
Only regarding the disbursement of amount.
The notice, stay till next hearing. Call for TCR.
We'll call for the TCR. So admission 1 minute only because start point is in
Date.
your.
House.
The opportunity was not given. That's your clue.
Until then, the disbursement of amount may be stayed.
Quantum,
Alla,
what a portion of it.
portion allotment ಮಾಡಿದ್ದಾರೆ ಕ್ವಾಂಟಮ್ನೇ ಕೇಳ್ತಾ ಇರೋದು ನಾವು because ಹೌದು ಅವ್ರು ನಮಗೆ no, they have not prepared any appeal.
Cell number 42, Jagdish Chair.
Same milad, they are continuous, all the three.
Daughter in their case.
Our ಮಕ್ಕಳು ಸುಮ್ಮನೆ grandchildren,
The age of the grandchildren.
minors ಸುಮ್ಮನೆ.
She has other children?
No, she doesn't have any children, but the victim Chaitra in expire ಆದ್ರು ಅವ್ರಿಗೆ brothers ಇದ್ದಾರೆ. Under the no, nobody else. ಇಲ್ಲ ಯಾರು ಇಲ್ಲ.
Connect ಮಾಡಬಹುದಲ್ಲ ಹಂಗಂದ್ರೆ ಎಲ್ಲ?
All the three may be connected. 43.
Correct, madam. Issue notice. Stay at the next hearing.
ಕಾಮನ್ ಎವಿಡೆನ್ಸ್ ಮಾಡಿಲ್ಲ, ಎಲ್ಲ ಕೇಸಲ್ಲೂ ಬೇರೆ ಬೇರೆ ಎವಿಡೆನ್ಸ್.
ಹೌದು ಸರ್, ಹೌದು. ಸೇಮ್ ಇದು ಅದರಲ್ಲಿ ನಾವು WS ಹಾಕ್ತೀವಿ, ನಮ್ಗೆ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನ್ ಮಾಡ್ಲಿಕ್ಕೂ ಅವಕಾಶ ಇಲ್ಲ, ಹಂಗೆ ಜಡ್ಜ್ಮೆಂಟ್ ಮಾಡಿರೋದು.
Then you'll get right.
Hello, we have filed the WS. That is what I'm saying. On 66, kindly page number may be taken out. My WS is taken on record. Director judgment got ಹಾಕ್ಬಿಡ್ತಾರೆ.
ಏನ್ ಹೇಳಿದ್ದಾರೆ ಅದ್ರ
ಅದು ಮಾಡಿಲ್ಲ. ಏನ್ ಫೈಲ್ ಮಾಡಿದ್ರೆ ಎಲ್ಲ ಏನ್ ಫೈಲ್ ಮಾಡಬೇಕು.
Regarding disbursement, let there be estimate. Much obliged.
For final disposal, cell number 44, T. Vijay Kumar, KT Gurudev Prasad.
My lord, I am for the appellant, my lord. I am ready, my lord.
Yes,
I appear for the respondent.
yes, argue.
Ready.
ಮಾಡಿ argument. Yes, yes.
The
Mr.
case of
Kumar, very ready.
My lord.
Yes, you have to argue the matter.
Yes, my lord. My lord, this appeal is by the BMTC, my lord, challenging negligence and quantum of compensation awarded by the tribunal. My lord, the accident has taken place on 6/1/2020 at about 9 a.m. when the BMTC bus was coming from Pottigebalya. My lord, at that time, my lord, there was a brake fail of the bus. Therefore, my lord, the driver of the bus took the bus to the extreme right side of the road and stopped on the right side of the road. At that time, my lord, one Toyota Etios car and also one auto rickshaw, which was on the opposite direction, my lord, they suddenly moved the vehicle and dashed against the scooter. Thereby, my lord, this accident has taken place. There was no contact or impact between the scooter and the BMTC bus. It was the accident between the Toyota car and the scooter. My lord, the complaint, my lord, one Nanjegoda, my lord, he was not at the place of accident. And my lord, he has given the false complaint only against the BMTC bus. My lord, on the basis of the complaint, false complaint, my lord, the police have filed a charge sheet only against the driver of the BMTC bus. My lord, the driver of the BMTC bus has been examined as RW1. And he has clearly submitted that though there was a brake fall and he took the bus to the right side, but not dashed to the scooter of the deceased. Thereby, my lord, the tribunal, without appreciating this aspect, my lord, tribunal holds that there is a total negligence on the part of the driver of the BMTC bus. My lord, regarding quantum of compensation, my lord, the deceased is working in the post office as a postal assistant and drawing a salary of rupees
33 years.
50,965 per month. Your last may kindly see Exhibit P 20. Exhibit P 20, my lord. These are the pay slips, 3 pay slips for the month of December, October and November 2019. Kindly see the pay slip under this thing, my lord. Basic is 33,300. DA 5,661. HRA, my lord, 5,992. But this transport allowance cannot be considered as a total salary for assessment of compensation. And also DA, TPA, that is also cannot be considered because the dearness pay is already paid as 5,661. These two items, my lord, cannot be considered as a regular income and cannot be considered for the purpose of assessing the disability. Then, my lord, on the right side of the road, you will ask me kindly see, right side of the column, income tax is not deducted at all. Though the gross salary is, my lord, 51,565 in 2019, definitely it attracts income tax beyond the limit. My lord, they have not deducted the income tax. Income tax should have been deducted. Tribunal, without deducting the income tax, simply deducted only professional tax and awarded compensation. You will ask me kindly see the take-home salary is only for 42,637. And my lord, the first petitioner is given appointment as a compassionate ground. And also, my lord, they have received all retirement benefit. In view of the judgment of the Honorable Supreme Court in Bakran Angle, we have versus the Bakra PS Corporation. All retirement benefits should have been taken into consideration while awarding compensation. Here, my lord, tribunal, my lord, has not at all considered those aspects and awarded huge compensation, my lord. Therefore, compensation will have to be reduced. The claimant, except examining herself, she has not examined the employer or the eyewitness.
Which is that judgment? You have to give the judgment.
Please, my lord, I am not able to hear.
Which is that judgment you are relying? Which is that judgment?
My lord, in para 12 of my appeal memo, I have mentioned para 12 of my.
Copy kodbekalla namge.
I'll furnish to the court. I'll furnish to the court.
You said you are ready. Then we will not refer to that. Yes, sir. Yes, Mr. Guru Prasad. Sir, head.
So far as negligence is concerned, he
Yes.
so far as negligence is concerned, he caused a series of accidents. And in spite of that, he disputing the involvement and he is denying his negligence.
He is examined.
Even according to him, there was a brake failure. It is his duty to maintain the vehicle in a proper condition when he was on the road.
He is examined as RW1.
RW1. He admits the accident.
He admits the involvement of other
Yes.
other vehicles also.
Whether other vehicles also. First, he dashed against a car and then to a motorcycle. Afterwards, he came and dashed to my scooter, and the rider of the scooter died on the spot. He cannot dispute the involvement of the vehicle itself.
He did not dispute that. He was saying that there was a brake failure, etc.
Even brake failure, it is also his responsibility. It is his duty to maintain the vehicle on a proper condition.
Yes.
So far as Quantum is concerned, he was working as a postal assistant at CMM Court Post Office. He is a central government employee. Exhibit P28 is the salary slip. P28.
No, the 20 last drawn.
2020.
20 is the last drawn salary slip anta kansute.
Allah.
28 is for which month this is?
That is December
For December 2019.
19.
Yes,
Accident
ma'am.
is January 2020.
Then both are same anta kansute nodi.
Yes, both are same.
ನಿಮ್ಮದಾಗಿದೆ ಅವ್ರನ್ನ ಕೇಳ್ತಾ ಇದೀವಿ ಇರಿ ಸ್ವಲ್ಪ.
Accident is on 6/1/2020.
6/1/2020.
The salary slip for the previous month, December 2019.
ಇದು P20 ನಾವು ನೋಡಿದ್ವಲ್ಲ ಅದು ಹಾಗೆ ಇದಾಗಿದೆ. P28 and P20. P20 is also, this is your document only.
ಆಯ್ತು
ಇನ್ನು
ಅದ್ರ
ಕೂಡ ಇದು ಸ್ಯಾಲ್ರಿ ಸರ್ಟಿಫಿಕೇಟ್ ಅಂತ ಇದೆ.
ಹೌದು ಸ್ಯಾಲರಿ
ಇದು
ಸರ್ಟಿಫಿಕೇಟ್
ಪೇ ಸ್ಲಿಪ್ ಅಂತ ಇದೆ.
ಪೇ ಸ್ಲಿಪ್ ಎರಡು ಒಂದೇ ಇದೆ. ಪೇ ಸ್ಲಿಪ್ ಅಲ್ಲಿ
Both gross salary is 51,165.
51,165.
825.
Yes, out of that only 200 rupees per
Subscription ಅಂತ ಮಾಡಿದ್ದಾರೆ ಇದರಲ್ಲಿ. That is not here in this.
ಅಲ್ಲ ಅದರಲ್ಲಿ
Right. This is the last salary slip ಅಲ್ವಾ?
ಇದರಲ್ಲಿ P28 ಅಲ್ಲಿ deductible amount is only professional tax 200 rupees.
Right. ಅದೇನ್ ಡಿಡಕ್ಷನ್ ಮಾಡ್ಬೇಕು.
ಕರೆಕ್ಟ್ ಆಗಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ 2,200 rupees ಡಿಡಕ್ಟ್ ಮಾಡಿ 51,165 ತಗೊಂಡಿದ್ದಾರೆ.
ಇದ್ರಲ್ಲಿ ಬರಲ್ವಾ? ಟ್ಯಾಕ್ಸಿಬಲ್ ಲಿಮಿಟ್ ಅಲ್ಲಿ ಬರ್ತಿರ್ಲಿಲ್ವಾ ಅವಾಗ?
ಇಲ್ಲ.
In the salary slip, HRA
ಅದೆಲ್ಲ ಕರೆಕ್ಟ್ ಆಗಿ
allowance, DA and
ಹೌದು ಹೌಸ್ ರೆಂಟ್ ಟ್ರಾನ್ಸ್ಪೋರ್ಟ್ ಅಲವೆನ್ಸ್ DA ಅಷ್ಟೇ.
ಟ್ರಾನ್ಸ್ಪೋರ್ಟ್ ಅಲೌನ್ಸ್ ಇದರಲ್ಲಿ ತೋರಿಸಿದ್ದಾರೆ.
ಬೇಸಿಕ್ ಅಷ್ಟೇ.
ಟ್ರಾನ್ಸ್ಪೋರ್ಟ್ ಅಲೌನ್ಸ್ ಅಂದ್ರೆ ಪೋಸ್ಟಲ್ ಅಸಿಸ್ಟೆಂಟ್ ಅಂದ್ರೆ ಏನು?
Whatever salary he was getting, everything goes to the benefit of
ಪೋಸ್ಟಲ್ ಅಸಿಸ್ಟೆಂಟ್ ಅಂದ್ರೆ ಕೆಲಸ ಏನು? ಡಿಸ್ಟ್ರಿಬ್ಯೂಷನ್ ಇದನ್ನ ಇನ್ನ
ಅಲ್ಲ ಅಲ್ಲೇ ಕುತ್ಕೊಂಡು ಅಸಿಸ್ಟೆಂಟ್ ಪೋಸ್ಟಲ್ ಅಸಿಸ್ಟೆಂಟ್
ಟೇಬಲ್ ವರ್ಕ್.
ಟೇಬಲ್ ವರ್ಕ್
ಆರ್ ಯು ಶ್ಯೂರ್?
ಟೇಬಲ್ ವರ್ಕ್
ಟ್ರಾನ್ಸ್ಪೋರ್ಟ್ ಅಲೌನ್ಸ್ ಕೊಡ್ತಾರೆ.
ಸೆಂಟ್ರಲ್ ಗವರ್ಮೆಂಟ್ ಸ್ಕೀಮ್ ಸೆಂಟ್ರಲ್
ಕೊಡ್ತಾರೆ.
ಸೆಂಟ್ರಲ್ ಗವರ್ಮೆಂಟ್ ಸ್ಕೀಮ್ ಅಲ್ಲಿ.
Okay. Like even if it is taken, whether it comes in the taxable limit or that, this 2000.
Within it, that is why
2019 Finance Act ನೋಡಿ. ಅದು ತಗೋಬೇಕಾಗತ್ತಾ ಟ್ರಾನ್ಸ್ಪೋರ್ಟ್ ಅಲೌನ್ಸ್? ಇದರಲ್ಲಿ ಏನು ತಗೊಂತಿರೋದಿಲ್ಲ, ಸ್ಪೆಷಲ್ ಅಲೌನ್ಸ್ ಅಂತೆಲ್ಲ ಇರ್ತಾವಲ್ಲ, ತಗೊಳ್ಳೋದಿಲ್ಲ. ಬೇಸಿಕ್ ಸ್ಯಾಲ್ರಿ ಅಂಡ್ ಇದನ್ನು ತಗೊಂತಿರ್ತೀವಿ. ಅದಕ್ಕೆ ಕೇಳಿದ್ವಿ ಅವ್ರಿಗೆ ಪೋಸ್ಟಲ್ ಇದು ಅಂತಂದ್ರೆ ಪೋಸ್ಟಲ್ ಅಸಿಸ್ಟೆಂಟ್ ಅಂದ್ರೆ ಇವರು ಡಿಸ್ಟ್ರಿಬ್ಯೂಷನ್ ಮಾಡ್ಕೊಂಡು ಡೈಲಿಫಿಗೆಲ್ಲ ನಾವು ಕೊಡ್ತೀವಿ ಅದನ್ನು. ಹಾಗೆ ಅಂಥದ್ದಾದ್ರೆ ಇಟ್ ಬಿಕಮ್ಸ್ ಪಾರ್ಟ್ ಆಫ್ ದಿ ಸ್ಯಾಲ್ರಿ. TP ಅಂದ್ರೆ ಅದು DA ಅಂಡ್ TP ಟ್ರಾನ್ಸ್ಪೋರ್ಟ್ ಅಲೌನ್ಸ್ ಮೇಲೆ DA ಆಗುತ್ತೆ. Even assuming that 3,600 is paying. 33,300 plus DA 5,661. 5,661. House rent allowance 7,992. 33,300, 5,661. Another 7,992. ಇದು we are not able to get it. Transport allowance ಅವ್ರು ಏನಂತ ಕೆಲಸ ಮಾಡ್ತಿದ್ರು ಅಂತ.
ಟ್ರಾನ್ಸ್ಪೋರ್ಟ್ ಅಸಿಸ್ಟೆಂಟ್ ಅಂತ ಇದೆ, ಪೋಸ್ಟಲ್ ಅಸಿಸ್ಟೆಂಟ್ CMM ಕೋರ್ಟ್ ಪೋಸ್ಟ್ ಆಫೀಸ್.
ಅದು ಡಿಸ್ಟ್ರಿಬ್ಯೂಷನ್ ಮಾಡೋದಕ್ಕೆ ಇರ್ಬೇಕು. ಅದಕ್ಕೆ ಇರುತ್ತೆ. ಹಾಗಿದ್ರೆ ಇಟ್ ಬಿಕಮ್ಸ್ ಪಾರ್ಟ್ ಆಫ್ ಹಿಸ್
whatever amount, whatever my respectful submission is, whatever amount he was getting, everything goes to the benefit of the family. That is what the Supreme Court has said. And
ವೇರಿಯಬಲ್ ಇನ್ಕಮ್ ಇದ್ರೆ ಅದು ಹೋಗೋದಿಲ್ಲ. ಇಫ್ ಇಟ್ ಇಸ್ ಪಾರ್ಟ್ ಆಫ್ ಹಿಸ್ ರೆಗ್ಯುಲರ್ ಇನ್ಕಮ್ ದೆನ್ ಇಟ್ ಬಿಕಮ್ಸ್. ಸೊ ಅದನ್ನೇ ತಗೊಳ್ಳೋಣ ಅಂತ ಹೇಳಿದ್ವಲ್ಲ. 51,165 into 12 ಮಾಡಿ
ಅದರಲ್ಲಿ 200 ರೂಪಾಯಿ ಕಳಿಬೇಕು.
200 rupees minus
200 rupees ಕಳಿಬೇಕು.
minus 200. 165 minus 200 ಅಂದ್ರೆ
50,995.
965 into 12. ಇಲ್ಲ ಅದಕ್ಕೆ 40% ಸೇರಿಸ್ಬೇಕಲ್ಲ.
30%.
His age was
30%.
His age was
43.
43 years. 30%.
30%.
30% of 50,965 ಎಷ್ಟಾಗುತ್ತೆ ನೋಡಿ. 15,289.5. ಸೊ ಅದನ್ನ ನಾವು 300 ಮಾಡ್ಬೋದು. ಸೊ 50,965 plus 15,300. ಎಷ್ಟಾಗುತ್ತೆ? 66,000 ಇದು per month ಆಯ್ತು. Into 12
14.
1,95,000 180. ಫೈನಾನ್ಸ್ ಆಕ್ಟ್ 2019 ನಲ್ಲಿ ಎಷ್ಟಿತ್ತು ಟ್ಯಾಕ್ಸಬಲ್ ಇದು? ಎಕ್ಸಾಮ್ಷನ್ ಇದೆ ಫಸ್ಟ್ 50 lakhs 2,50,000 ಇದೆ. ಅದ್ರ ಮೇಲೆ ಅಪ್ ಟು 5 lakhs 5% ಅಲ್ಲ, ಫಸ್ಟ್ 2,50,000 is exempted. 2,50,000 ಇಂದ 5 lakhs ವರೆಗೆ 2 lakhs ಬರಂಗಿಲ್ಲ, ಇದು ತಗೋಬೇಕಾಗುತ್ತೆ. ಇದೆಷ್ಟು 20% ಇದೆ. ಮೈನಸ್ ಮಾಡಬೇಕು. 7,95,000 ಅಲ್ಲಿ 2,50,000 50,000
12,500 plus 20%.
1/4 ಡಿಡಕ್ಟ್ ಆದ್ಮೇಲೆ
ಈಗ ಇದನ್ನ ಕಳಿಬೇಕಲ್ಲ, ಒಂದು ಟ್ಯಾಕ್ಸ್
ಇಲ್ಲೇ ಆಗ್ತದೆ establishment. If it is beyond 5 lakhs, 12,500 plus 20% of the amount.
ಹೌದು. ಎಷ್ಟಾಗುತ್ತೆ? ಅಲ್ಲ, 5,95,180 ಮತ್ತು 2 lakh ಅಲ್ಲ, 5,95,180 ಇದು ಎಕ್ಸಾಮ್ ಆದ್ಮೇಲೆ ಥರ್ಡ್ ಪ್ರಾಬ್ಲಮ್ ನೀವು ಹೇಳ್ತಿರೋದು. ಟೋಟಲ್ ಇನ್ಕಮ್ exceeds 10 lakhs. ಇದು third.
Exceed 5 lakhs, but does not exceed 10 lakhs. So
So
between 5 lakh to
12,500 plus 20% and the amount which
by which the total amount exceeds 5 lakhs.
ಅಂದ್ರೆ ಮೊದಲು 12,000 ತಗೊಂಡು ಯಾರಾಯ್ತು? ಎಷ್ಟು ಉಳಿಯುತ್ತೆ ಅಂದ್ರೆ 5 lakhs ತೆಗೆದ್ರೆ 2,95,000. ಅದ್ರ ಮೇಲೆ 20%. ಸೊ 12,500 ಪ್ಲಸ್ ಈಗ ಬಂದಿದ್ದೆಷ್ಟು? 59,000 036 ಇದೆರಡು 71,536 ಅದನ್ನ ಮೈನಸ್ ಮಾಡಬೇಕು. 536 530 ಮಾಡೋಣ. 530 ಅದೇ ಮೈನಸ್ ಮಾಡಿದ್ರೆ ಎಷ್ಟು ಬರುತ್ತೆ? 7,95,180 minus 71,530 530 7,22,650. ಡಿಡಕ್ಷನ್ ಎಷ್ಟಿದ್ರಲ್ಲಿ ಪರ್ಸನಲ್ ಡಿಡಕ್ಷನ್?
1/4.
ಹೌ ಮೆನಿ ಡಿಪೆಂಡೆಂಟ್?
5 claimants.
5 claimants 1/4 ಕರೆಕ್ಟ್?
1/4 ಅದು ಕರೆಕ್ಟ್ ಆಗಿ ಮಾಡಿ.
Up to 6.
ಅಂದ್ರೆ 3/4 ತಗೋಬೇಕಿದೆ. 71,500 7,22,000 23,000 23,000 5 lakh 7.5. ಇದನ್ನ we can 5,42,000 740 ಮಾಡ್ಕೊಳ್ಳಿ ಇಂಟು ಮಲ್ಟಿಪ್ಲೈರ್ ಅಪ್ಲಿಕಬಲ್
14 43 years.
25 lakhs 98,360. ಇನ್ನು ಉಳಿದಿದ್ದೆಲ್ಲ ಇದು these are 5 claimants ಅಲ್ವಾ?
ಹೌದು, ಕ್ಲೈಮ್ 5. ಅದ್ರಲ್ಲಿ ಕನ್ಸರ್ಷನ್ ಲವ್ ಅಂಡ್ ಅಫೆಕ್ಷನ್ ಇದು ಫಿಲಿಯಲ್ ಕನ್ಸರ್ಷನ್ ಕೊಟ್ಟಿದ್ದು 44,000 ಒಂದೇ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಅಲ್ಲ ಅದು ಮಾಡ್ತೀವಿ, ಅದನ್ನೇ ಮಾಡ್ತೀವಿ. 44 into 5 ಎಷ್ಟಾಗುತ್ತೆ? 44 2,20,000 ಪ್ಲಸ್
ಅವ್ರದ್ದೇನು ಅಪೀಲ್ ಇಲ್ಲ ಇದರಲ್ಲಿ.
33,000 ಇರ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಅಷ್ಟಕ್ಕೆ ರೆಸ್ಟ್ರಿಕ್ಟ್ ಮಾಡ್ತೀವಿ. ನೋಡೋಣ ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ. ಅಪೀಲ್ ಇರ್ಲಿಲ್ಲ ಅಂದ್ರೂ ಕೊಡಬಹುದು ಅಂತ ಸುಪ್ರೀಂ ಕೋರ್ಟ್
ಅಲ್ಲ
ಜಡ್ಜ್ಮೆಂಟ್.
ಇಲ್ಲ, ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಹೇಳಿದೆ ಕೊಡಬಾರ್ದು.
ಫೇರ್ ಕಾಂಪನ್ಸೇಷನ್ ಹ್ಯಾಸ್ ಟು ಬಿ ಅವಾರ್ಡೆಡ್ ಅಂತ. There is a
ಅಲ್ಲ, ರೀಸೆಂಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ಸೇಸ್ ನೋ ಎನ್ಹಾನ್ಸ್ಮೆಂಟ್, ನೋ.
which is that recent judgment?
Yes, my lord, I got. Even division bench also followed the very same judgment and
51,360 ಅವಾರ್ಡ್ ಮಾಡಿರೋದು ಎಷ್ಟಿದೆ? How much is the amount awarded?
84 lakhs 35. ಅದರಲ್ಲಿ ಟ್ರಾನ್ಸ್ಪೋರ್ಟೇಷನ್ 10,000 ಕೊಟ್ಟಿದ್ದಾರೆ.
ಏನ್ 10,000?
ಟ್ರಾನ್ಸ್ಪೋರ್ಟೇಷನ್ ಆಫ್ ಬಾಡಿ, ಡೆಡ್ ಬಾಡಿ.
ಎರಡು ಅದು ತಪ್ಪಲ್ಲ ಅದು.
ಅಲ್ಲ, ಅದು ಟ್ರಾನ್ಸ್ಪೋರ್ಟೇಷನ್ ಬಿಲ್ ಹಾಕಿದ್ದಾರೆ.
Bill ಹಾಕಿದ್ರು see now that is standardized 16,500 16,500 ಕೊಟ್ಟಿದ್ದಾರೆ ಅಲ್ಲಿ ಅವ್ರು 84,35,000 ಕೊಟ್ಟಿದ್ದಾರೆ ಹೆಚ್ಚು ಮಾಡಕ್ ಬರೋದಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾ ಇದಾರಲ್ಲ ಹೆಚ್ಚು ಮಾಡಕ್ ಆಗೋದಿಲ್ವಲ್ಲ what is awarded is lesser than ನಾವು ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಮಾಡಿದಾಗ reassess ಮಾಡಿದಾಗ ಬರೋದು 78,51,360 ಅಂದ್ರೆ partly ಎಲ್ಲ ಆಗುತ್ತೆ
ಎಷ್ಟು ಬಂತು?
360 ನಮ್ ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಪ್ರಕಾರ ಇದನ್ನ ಸ್ವಲ್ಪ ರೆಡ್ಯೂಸ್ ಆಗುತ್ತೆ ಅಲ್ಲ ನಾವು ತಗೊಂಡ್ವಲ್ಲ 2,20,000 2 lakh ಅವರು ಟ್ಯಾಕ್ಸ್ ಡಿಡಕ್ಟ್ ಮಾಡಿಲ್ಲ ಹಂಗಾಗಿ ಅದು ಜಾಸ್ತಿ ಆಗಿದೆ ಟ್ಯಾಕ್ಸ್ ಡಿಡಕ್ಟ್ ಮಾಡಿದ್ದಾರೆ ಸೊ ಸ್ವಲ್ಪ ರೆಡ್ಯೂಸ್ ಆಗುತ್ತೆ ಬಿಕಾಸ್ ಟ್ಯಾಕ್ಸ್ ವಾಸ್ ನಾಟ್ ಡಿಡಕ್ಟೆಡ್ ಬೈ ದ ಟ್ರಿಬ್ಯುನಲ್ tax was not deducted by the tribunal, so to some extent it will be 84 lakhs to 78 lakhs and odd bar. Admission
appeal is by the appellant insurance appellant DMTC agreed for the order.
My lord, the recent Supreme Court judgment, my lord, AR 2011, 14 SCC.
2011 recent,
ಅಲ್ಲ ಆಮೇಲೆ 2008, 18 ಒಂದಿದೆ ಮತ್ತೆ ನಮ್ 21, 22 ನಮ್ಮ ಹೈಕೋರ್ಟ್ ಇದೆ. I'll tell them. Regarding no enhancement. My lord, AR 2018 SC.
Enhancement ಬರ್ತಾನೆ ಇಲ್ಲ ಅದರಲ್ಲಿ.
ಅಲ್ಲ ಹೇಳಿದ್ದು just.
ಅದೇ because we know there is one judgment which says that
ಅಲ್ಲ because your lordship said you can enhance it ಅಂತ that's fine.
Other experts ಇದ್ರೆ ನಮ್ಮ ಭಟ್ರು ಇದಾರಾ ಇದ್ರೆ
Please my lord.
Guru Prasad.
Yes.
Which is that judgment which says that the court has to award fair compensation even without appeal it can be enhanced ಅಂತ ಇದೆ ಅಲ್ಲ ಯಾವ
ಇದೆ
ಅಲ್ಲ ಅದಾದ್ಮೇಲೆ ಸಬ್ಸಿಕ್ವೆಂಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ಬೇಕಾದಷ್ಟು ಬಂದಿದೆ.
ಇದೆ 2000
ಇದು ರೀಸೆಂಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ಆಫ್ ಹೈಕೋರ್ಟ್ 2018.
ನಮ್ಮ ಹೈಕೋರ್ಟ್ 2000
ನಮ್ಮ ಹೈಕೋರ್ಟ್ ಇದೆ
2020
2020
ILR 2020
ಯಾಕಂದ್ರೆ ಮುಂದೆ ಯಾವಾಗಾದ್ರೂ ಬರ್ತೇವೆ now that question does not arise we know there is
please my lord.
it was stated that even Pranay said this case there is such observation.
ಆಮೇಲೆ ILR 2016 ಡಿವಿಷನ್ ಬೆಂಚ್ ಆಫ್ ಜಡ್ಜ್ಮೆಂಟ್ ಇದೆ ನಮ್ಮ ಹೈಕೋರ್ಟ್ 2016
without appeal also you can enhance another. There is one judgment which which says that even without appeal you can because court has to duty bound to avoid
My lord, just for the sake of academic purpose, well, our division bench in MFA 5359 of 2014 case
ಕೊಟ್ಟಿರಿ ನಾವು ಅದನ್ನ ನಮಗೆ ಮುಂದೆ ಯೂಸ್ ಆಗುತ್ತೆ
ಮುಂದೆ please my lord, just for academic purpose I am telling.
Judgment award dated 29/8/2022, whereby the tribunal awarded a sum of fees
introduction application ಕೊಡ್ತಾರೆ ಬಟ್ ಇದರಲ್ಲೇ ಅಬ್ಸರ್ವೇಷನ್ ಇದೆ ಪ್ಲೀಸ್ just
the very facts of the case leading up to filing the present appeal is that on 6/1/2020 about 9 seized butter was riding his two-wheeler bearing registration number KS-02-JY-5407, on the left side of Magadi Main Road, proceeding towards Sumanahalli Circle, when he reached Kottike Palya bus stop, comma, a BMTC bus bearing registration number KA 57696, driven by its driver in a very high speed, rash and negligent manner, dashed against a car, thereafter dashed the vehicle of the deceased. Due to the impact, the deceased fell down and the wheels of the bus ran over his scooter, causing injuries, due to which he succumbed at the spot. Thereupon, a petition is filed by the wife and children of the deceased under section 166 of the MV Act, seeking compensation in a sum of rupees 80 lakhs on the premise that the deceased, who was aged about 43 years, hale and healthy, working as a postal assistant at CMM Court Post Office, drawing a monthly salary of rupees 51,165 per month, that he was contributing entire earning to the family. The untimely demise of the deceased on account of rash and negligent driving of the respondent, the petitioners or claimants were put to financial and emotional distress. On service of notice, respondent appeared and filed statement of written statement. Accident in question is not disputed. Accident question resulting in death of deceased Bailappa is not disputed. However, it is contended the driver of the offending bus was driving the same cautiously, and due to certain mechanical defects, the bus was taken by him to the right side and had stopped the bus. In the process, the bus had come in contact with a car and an auto rickshaw, who in turn had dashed against the deceased vehicle of the deceased, causing the accident. Full stop. To which the appellant driver of the appellant was not responsible. Other claim made by the petition is also denied. Based on the pleading, tribunal framed issues. Full stop. Claimant examined. Wife of the deceased examined herself as PW1, and one Purushottama has been examined as PW2 and exhibited.
PWT is eyewitness, huh? Purushottam, salary, employer.
Employer.
Purushottama, the representative employer, has been examined as PW2, exhibited 30 documents marked exhibit P1 to P30. One TG Venkatesh has been examined as RW1. No documents are produced. On appreciation of the evidence, tribunal held that the accident in question had occurred due to the rash and negligent driving of the driver of the offending bus, resulting in the death of the deceased. Full stop. Take into consideration the salary which was drawn by the deceased as per exhibit P28, and other conventional granting company on the conventional head, held the claimants are entitled for sum of fees 84, 35, 074 as compensation with interest at 6% per annum, being agreed to the same. the appellant before this court. She so and so that counsel appearing through the video conferencing, taking this court to the records, submit that the tribunal has grossly erred in fixing the liability on the driver of the vehicle, and that while calculating the compensation, the tribunal has not taken into consideration the amount deductible from the salary towards the tax. Full stop. He also submits that the tribunal has not taken into consideration that upon the demise of the deceased, the representatives, legal representative claimant were paid the retirement benefits which ought to have been excluded.
Padma,
Hence seeks for allowing of the appeal.
Sebastian Macrosity.
Per contra, that counsel appearing for the respondent, justifying the order passed, the award passed by the tribunal, submit that the calculation of the amount is based on the documentary evidence produced in the nature of salary slip, exhibit P28. Full stop. He further submits that the other amount awarded is as per the orders, judgments issue, as per the orders of the apex court. Full stop. He also submits that admittedly the offending vehicle had technical defects, which is the responsibility attributable to the driver of the vehicle, and no plea of negligence can be attributed on the other vehicles or on the deceased. Hence submits that the contention of the appellant with regard to the liability cannot be countenanced. Third, there is the records. The twin question that arises for consideration is with regard to the liability and the quantum. So, the counsel for the petitioner appellant vehemently submitted that there was no negligence on the part of the driver of the offending vehicle. In his evidence recorded, in his evidence RW1 has categorically admitted
ಬರೆಯಲಾಗಿತ್ತು ಅದನ್ನು ಹಾಜರುಪಡಿಸಲು ತೊಂದರೆ ಇಲ್ಲ. ಒಂದು ಆಮೇಲೆ ಮೋಟಾರ್ ವೆಹಿಕಲ್ಸ್ ಇನ್ಸ್ಪೆಕ್ಟರ್ ಮೋಟಾರ್ ವಾಹನ ನಿರೀಕ್ಷೆ ವರದಿಯಲ್ಲಿ ಬಸ್ಸಿಗೆ ಯಾವುದೇ ತಾಂತ್ರಿಕ ದೋಷ ಇರಲಿಲ್ಲ ಎಂದು ನಮೂದಾಗಿದೆ ಅಂದರೆ
in his evidence RW1 categorically admitted that he has not produced any documentary evidence to show that there was any technical or mechanical defect in the offending vehicle. He is also admitted that the inspector, traffic exhibit P9, motor vehicle accident report, inspector report does not refer to any technical defect with the vehicle.
There is no mechanical defect.
He also admits that there is no mechanical defect as per the report of the inspector. That such being the material evidence available on record, the contention urged on behalf of the appellant that the vehicle was having technical defect resulting in accident cannot be accepted.
It has 7.
As rightly pointed out by the response of the respondent, the offending bus before dashing against the vehicle of the deceased, had hit a car, a RO, and 7 two-wheelers, which had resulted in 2 deaths, apart from the 2 deaths of the 2 deaths of the riders of the 2-wheelers, including the deceased Bailappa in the incident case. Facts on record would reveal that the accident in question, as taken note of the tribunal, had been caused on account of the negligent driving of the offending bus. Therefore, the question of liability as raised does not stand for scrutiny, and the same is rejected. Coming to the question of quantum of determination of quantum of compensation, exhibit P28 with the salary slip PW2 has been examined in support of the said document. There is no dispute of the fact that said deceased Bailappa was working as postal assistant in CMM Court post office. Thus, he was a permanent employee, central government employee, drawing a salary of rupees 51,165 per month. Since the age of the deceased was 43, the sum of which 200, the sum of which 200 is deducted towards the professional tax. Thus, the salary being received by the deceased was rupees 50,965. As per the judgment of the apex court in the case of Pranay Sethi, for 25%, since the age of the deceased is above 40, 25% of the salary, 30% of the salary, 30% salary is added towards future prospects. The age of the deceased being 43, multiplier of 14, 14 is applied.
Deduction.
Thus, the total income of the deceased per annum would be rupees estimate 66 alado
50.
total per annum into 6 lakhs.
50,965 plus 15,300 is equal to 66,265 into 12. ಅದಕ್ಕೆ 15,300 ಇಟ್ಕೊಂಡ್ವಿ ನಾವು ರೌಂಡ್ ಮಾಡಿ. ಅದ್ರಲ್ಲಿ 66,000 is equal to 66,265 into 12 is equal to 7,95,180 per annum. ಆಮೇಲೆ ಡಿಡಕ್ಷನ್
As per the
income tax.
As per the Finance Act 2019,
19.
income exceeding rupees 5 lakhs and not exceeding 10 lakhs,
Payable number is
the
71,000.
tax payable thereon is 12,500 plus 20% of the amount by which the total income exceeds 5 lakhs, calculated as such. An income of rupees 71,536
rounded to
530 is required to be deducted towards the annual income. Thus, the annual income of the deceased would be rupees dash
7,95,180 minus 71,530 is equal to 7,23,650.
The in terms of the appellants being the respondents, the claimants being the wife and children of the deceased are entitled for rupees 40,000 each.
Minus deduction before deduction.
Since there are 4 dependents,
Five
dependents, 1/4 is required to be deducted towards the personal living and living expenses of the deceased. So the loss of dependency would be rupees dash
7,23,650 into 3 upon 4. 5,42,737.5 rounded 5,42,740.
as per judgment of court in the case of Magma, clarified by
just only into 14 multiplier ಅಂತ ಮಾಡ್ಕೊಂಡು is equal to 75,98,360.
As per the judgment of the Magma, clarified by Satinder Kaur, the claimants being the legal representatives are entitled for rupees 40,000 towards the loss of consortium, spousal and filial consortium. And since and plus 10% of the escalation at the expiry of 3 years. The in addition, they are also entitled for rupees 15,000 each towards the loss of estate and funeral expenses.
With escalation at 10%.
The escalation at 10%. The tribunal, however, has not taken into consideration the amount deductible towards the tax as calculated here and above. In the clear the matter.
Just
into the matter, the claimant would be entitled for rupees as against rupees dash.
Just compensation payable is as follows in the table of
Table.
contents. Loss of dependency 75,98,360. Consortium 2,20,000. Loss of estate 16,500. Inter-alia 16,500. Total 78,51,360 as against.
As against, so appeal partly allowed.
Amount in deposit,
Interest ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ?
6%.
Needless to state, therefore, said amount shall carry interest at 6% from the date of the claim till disbursement.
One submission, my lord. A sum of rupees 25,000 as paid as interim compensation that has not been deducted.
Compassionate loan appointment ಅದನ್ನೊಂದು ಸತಾಸ್ಟ್ರಿಂಗ್ ಮಾತ್ರ ಜಡ್ಜ್ಮೆಂಟ್ ಹೇಳಿ. Compassionate loan appointment terminal beneficiary suggesting macro. They arise out of contractual.
As regard the contention of mail, as regard the contention comes to the appellant regarding the amount received towards the service retirement benefits, death cum retirement benefits, and the compassionate appointment received by the claimant number one to be taken to consideration from the apex court in the case of Sebastian Lacra and others versus National Insurance Company has held, larger bench has held that the amount received by the claimant for legal heirs of the deceased under employee family benefit scheme cannot be deducted while calculating the loss of income.
All these amounts are earned by the deceased on account of contractual.
In as much as such benefits are received by the deceased under the contract and the statutory benefits, same cannot be given deduction under the compensation payable under compensation payable under section 168 of the Motor Vehicles Act.
My lord, a sum of rupees 25,000, my lord, as paid as interim compensation that has not been deducted. Interim compensation, not the initial deposit.
There is that contention and.
Yes, I have taken the contention. I have taken the contention.
Where is that?
And
Where is
kindly
the
see
evidence?
cross-examination, my lord. Cross-examination, page 7 of PW1.
Page 7 of PW1.
PW1.
Recent judgment of this honorable court.
ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡುವಾಗ ಅವ್ರು ಹೇಳಿಲ್ಲ ಜಡ್ಜ್ಮೆಂಟ್ ಎಲ್ಲ ಕಂಪ್ಲೀಟ್ ಆದ್ಮೇಲೆ ಹೇಳ್ತಾರೆ.
ಕೊಟ್ರು ಎಕ್ಸ್ ಗ್ರೇಷಿಯಾ ಪೇಮೆಂಟ್ ಡಿಡಕ್ಟ್ ಮಾಡಬಾರ್ದು ಅಂತ.
ಅಲ್ಲ, it cannot be, it is interim compensation, my lord.
Where is that PW1 evidence in PW1?
PW7, para 7, my lord. Cross-examination, last page.
Then why did you not mention it when we were arguing earlier? Para 7.
I have taken a specific ground in the appeal memo also.
You are arguing here.
Yes,
You
ma'am.
are- Then why did you argue? We are looking
Actually,
at.
I wanted to give a, my lord, actually, I wanted to give a reply, my lord, regarding two aspects.
Listen to us.
Yes.
If we have to look at the appeal memo, we were not required to hear you.
My lord, actually, I wanted to give a reply, my lord. Your lordship suddenly started dictating the judgment. That's why, my lord, I couldn't disturb your lordship. Page 7, para 4 of cross-examination of PW1.
25 ತಗೊಂಡಿದ್ದಾರೆ ಅಂತ ಹೇಳಿದಾರಲ್ಲ.
ಹೇಳಿದ್ದಾರೆ ಬಟ್ ಇವಾಗ ರೀಸೆಂಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ಧಾರವಾಡ ಬೆಂಚ್ ಡಿವಿಷನ್ ಬೆಂಚ್ ಎಕ್ಸ್ ಗ್ರೇಷಿಯೋ ಪೇಮೆಂಟ್ ಕೊಟ್ರು ಡಿಡಕ್ಟ್ ಮಾಡಬಾರ್ದು ಅಂತ.
ಇತ್ತೀಚೆಗೆ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ಬಂದಿದೆ ಇನ್ನೊಂದು ಜಸ್ಟಿಸ್ ನಾಗರತ್ನ ಅವ್ರದ್ದು.
ಅಲ್ಲ
ಎಕ್ಸ್ ಗ್ರೇಷಿಯಾ ಪೇಮೆಂಟ್ ದೇ ಕ್ಯಾನಾಟ್ ಹಾವ್ ಡಬಲ್ ಬೆನಿಫಿಟ್ ಅಂತ ಬಂದಿದೆ ಅದು. Have you seen that judgment?
ನಮ್ಮ ಹೈಕೋರ್ಟ್ ಈಗ ರೀಸೆಂಟ್ ಡಿವಿಷನ್ ಬೆಂಚ್ ಜಸ್ಟಿಸ್
Follow the Supreme Court judgment or coordinate bench judgment?
ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ಎಲ್ಲ ತುಂಬಾ ರೆಫರ್ ಮಾಡಿ ಡಿವಿಷನ್ ಬೆಂಚ್ ಜಸ್ಟಿಸ್ ದೇವದಾಸ್ ಅಂಡ್
ರೆಫರ್ ಮಾಡಿದ್ದಾರೆ
ಮಾಡಿ ಎಲ್ಲ ಮಾಡಿ ಎಕ್ಸ್ ಗ್ರೇಷಿಯಾ ಕೊಟ್ರೆ ಕೊಡಬಾರ್ದು ಅಂತಾನೆ ಇದೆ, ಡಿಡಕ್ಟ್ ಮಾಡಬಾರ್ದು ಅಂತ ಇದೆ.
Madam, it is only an interim compensation. Otherwise, they will stop giving compensation at all.
Compassionate. Medical expenses reimbursement 45. ಅದು ಮಾಡಬೇಕು ಅಂತ ಹೋಲ್ಡ್ ಮಾಡಿದ್ದಾರೆ ಅವರು. I said that Sebastian Latra is the larger than judgment. ಅದು ತಗೊಂಡು ಫಾಲೋ ಮಾಡಬೇಕಾಗುತ್ತೆ ಅಂತ ಹೇಳಿ ಇವಾಗಲೇ ಏನಾಗುತ್ತೆ ಇನ್ಶೂರೆನ್ಸ್ ಪಾಲಿಸಿ ತಗೊಂಡಿದ್ದು ಪ್ರೀಮಿಯಂ ಕೊಟ್ಟಿರ್ತಾರೆ ಅದಕ್ಕೆ ಕೊಟ್ಟಿರ್ತಾರೆ ಕಾಂಟ್ರಾಕ್ಚುವಲ್ ಅದಕ್ಕೆ ದಟ್ ಇಸ್ ಕವರ್. ವಿಂಡ್ ಫಾಲ್ ಅಂತ Estimation of Shashi Sharma applied for vacancy. Madam is appointed. The dependent of the deceased qualified as a petitioner in the doctor present. This is was provided professional assistance to the civil department employee for this period. This is an order whatsoever including as a part of the property. This is in order to compensate for loss of dies in harness. In the case of natural collection, when negligence is paid, loss of dependence is compensated for very same reason. There cannot be observed. There cannot be any duplication of payments or a windfall owing to misfortune. In other words, on the death of a person in harness owing to a road traffic accident, the dependence of the deceased cannot doubly benefited as a person who is dependent of the deceased who dies. They said this cannot apply to the that's apply to larger judgment. But even for the expiation of payment and because they cannot be penalized twice. And then 25,000 minus ಅಂತ ಮಾಡ್ಕೋಬೇಕಷ್ಟೇ. ಅಡ್ಮಿಟ್ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ.
ಅಡ್ಮಿಟ್ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ. ಮೈ ಸಬ್ಮಿಷನ್ ಇಸ್ ರೀಸೆಂಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ಧಾರವಾಡ ಬೆಂಚ್.
ಇದು ನೋಡ್ಕೊಳ್ಳಿ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್. ಇದು ರೀಸೆಂಟ್ ಯಾವ ಇಯರ್?
ಇವಾಗ
2024 ಫೆಬ್ರವರಿ 5, 2024.
ಸರಿ
ಸುಮ್ನೆ ಬಾಯಲ್ಲೇ ಹೇಳ್ತಾ ಇರ್ತೀರಾ, ಯಾವ ಜಡ್ಜ್ಮೆಂಟ್ ಕೈಯಲ್ಲಿ ಇರೋದಿಲ್ಲ.
ಅವ್ರ ಆ ಪಾಯಿಂಟ್
ಓನ್ಲಿ ವಿ ಹ್ಯಾವ್ ಟು ಡೂ ದ ಹೋಮ್ ವರ್ಕ್. ಮೈನಸ್ ಅಂತ ಬರುತ್ತೆ ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಅಲ್ಲಿ ಮೈನಸ್ ಎಕ್ಸ್ಕ್ರೀಷನ್ ಆಫ್ ಪೇಮೆಂಟ್ ಮೇಡ್ ಬೈ ದ ಅಪೆಲೆಂಟ್ ಮಾಡಿ ಮೈನಸ್ 25,000 ಮಾಡಿ ಅವಾಗ ಅದ್ರಲ್ಲಿ ಎಷ್ಟು ಬರುತ್ತೆ ಇಲ್ಲಿ ನಮ್ದೇ ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಇತ್ತು
78,26,360 ಬರುತ್ತೆ.
20 lakhs ಅಷ್ಟು
ಅಮೌಂಟ್ ಇನ್
deposit shall be transmitted at the ಹೇಳಿದ್ದಾರೆ and TCR shall be transmitted to the tribunal forthwith. ಅದು ಡೆಪಾಸಿಟ್ ಮಾಡಬೇಕಲ್ಲ ಅದಕ್ಕೆ 4 weeks
Amount in deposit may be transferred to the tribunal.
For final hearing, cell number 45, Lata Shetty, Vaishali Hegde for R4.
For the respondents 2, 3, 5 and 7.
This matter, my lord, I have engaged Bipin Egde, my lord, he has some personal inconvenience today. Kindly it may be taken up another day.
Let be 1695. Final hearing. Whom have you engaged?
Bipin Egde, my lord.
You can start, then we'll hear him.
It's like.
Yes, what do you say?
Let them start, my lords.
So you are advocate on record, no?
Please, my lord. The client has, they have instructed me to engage senior counsel.
Then he should be present here.
Yes, some person.
Original case is of year 2000.
Please, my lord.
Only quarter century. Is that not enough?
I understand, my lord.
What
Next
were
week,
the
any
issues?
a suit for partition.
Defense is that of a will, my lord. It was disbelieved.
He set up the will.
Yes, D2 set up a will. That was
Wherein, my
disbelieved
lord,
by
the plaintiff has not entered the witness box. As per the Evidence Act 114, my lord, if they doesn't.
Now you have to argue because you are well versed with the facts. You cannot say I have engaged senior counsel. Yes. Surrounded by suspicious circumstances. Will was executed by whom? Alleged will?
My lord,
Mother.
The mother in favor of the son, my lord.
Son.
one of the son, excluding the other children.
2A. The second ground was that he has effected improvement to the property.
Please.
ನೋಡಿ ಇಲ್ಲ ಹೋಗುತ್ತೆ 27 entitled 8 allowance. ಕರ್ಕೊಂಡು ಬನ್ನಿ ಮಧ್ಯಾಹ್ನ
My lord, next
30.
week, today he has
Then we
parted
impose
matter.
cast and adjourn.
No, my lord, in
Okay, not a.
You take us to the facts that you can do.
ಇಲ್ಲಿ ಸ್ವಲ್ಪ ಏನಾರ ಇದನ್ನ ಹಾಕಿಸಿಡ
please,
Take us to the facts.
please, my
If
lord.
required, we'll see that. It's ultimately partition suit, will is propounded. If you are examining the
Yeah, it
witnesses
appears
there in the matter.
you have admitted the nature of the property. You have set up a will to exclude him. Then
That is
exclude the will, that is the only
That is a
question.
wrong
And
observation
second
of
is,
the trial court, my lord, that we have set up the will.
improvement of the
Well,
property.
I'll convince your lordship, my lord, it's a wrong finding
No,
of
no,
the,
you can convince at 2:30.
my lord, any day, tomorrow or next week, my lord, will go on with the matter.
You make a beginning, madam, let's see. If it's required, we grant it.
Next,
Madam.
ಹೌದು.
Tomorrow, my
Yes.
lord,
ಇದು 2010 ಅಲ್ಲ 2000 quarter century
ನಮ್ಮ ಮುಂದೆ
Please,
15 ವರ್ಷ ಇದೆ.
afternoon.
tomorrow, my lord.
Serial number
54.
54.
Morning session ಅಲ್ಲಿ opposite advocate inform ಮಾಡಿ ಅಂತ.
Both of you are here.
For the appellant.
ಹಾ ಯಾರು ಬೆಳಿಗ್ಗೆ
But this is the case where your lordship directed the appellant to be present. That Mysore case.
ಹಾ,
He can adjourn. Senior Maigu sir.
ಇದು
Child custody.
DLS ಗೆ ಹೋಗಿ ಬಂದಿರೋ ಕೇಸ್.
ಹೌದು ಹೌದು.
ಇವತ್ತು ಬೆಳಿಗ್ಗೆ ನೀವು ಇಲ್ದಾಗ ಮೂವ್ ಮಾಡಿದ್ರು ಅವರು ನಾವು ಅವರು ಅದರ್ ಸೈಡ್ ಬರ್ಲಿ ಅಂತ ಹೇಳಿದ್ವಿ. You moved in the morning.
Yes, ma'am.
Why did you do like that?
Senior
In
Maigu.
his absence.
He can adjourn. Senior Narco.
Contempt ಆಗ್ಬೇಕಾಗುತ್ತೆ. What was the direction last time? Party should be present.
My lord, kindly see the order dated 28/2/25.
ಅಲ್ಲ ಅದೆಲ್ಲ ಹಿಂದಿನ ನಮಗೆ ನೆನಪಿದೆ ಈಗ. What was the last order? 11/3 as at about 4:50 PM learner counsel for appellant mentions that appellant is present before this court along ಅದು ಅವತ್ತು ಕೆಮ್ತಾ ಇತ್ತು ಮಗು. Such a mention was not made during the course of the day. Those in several cases where the parties appeared, their respective counsel mentioned such a cases were disposed of. Appellant claims to be waiting along with the child aged 7 years since morning. Apparently mentioned. There is no direction that appellant should be present. Allegations against the courts and DLS only visitation only visitation ಕೊಟ್ರೆ ಅಲ್ಲಿ ಹೋಗಿ ಆಫೀಸರ್ ಮೇಲೆ ಗಲಾಟೆ ಮಾಡೋದು ಅಲ್ಲಿ ಮತ್ತೆ ಅವ್ರ ಮೇಲೆ ಕಂಪ್ಲೇಂಟ್ ಓಪನ್ ಕೋರ್ಟ್ ನಲ್ಲಿ ಅವರು ಅಡ್ವೊಕೇಟ್ ಏನ್ ಹೇಳ್ತಾರೆ ಅಂದ್ರೆ ದಟ್ ಲೇಡಿ ವೈಫ್ ಶಿ ಇಸ್ ಕ್ಲೋಸ್ ವಿತ್ DLS ಅಲಿಗೇಷನ್ ಇನ್ ಓಪನ್ ಕೋರ್ಟ್. ಅದಕ್ಕೆ ನಾವು ಅದಕ್ಕೆ ಆಮೇಲೆ ಅಡ್ವೊಕೇಟ್ ಚೇಂಜ್ ಮಾಡ್ಕೊಂಡ್ಬರೋದು. No, will not adjourn it.
My senior is not keeping with me. That's why.
Ask
And
him.
next week,
Parties also have been.
next week happen.
There is a specific direction.
Your prayer is rejected.
My lord, serial number 45. Tomorrow, my lord, I will.
Yes, Miss ಎಲ್ಲಿದೆ ರವಿಶಂಕರ್ ಇಲ್ವಲ್ಲ ನಿಮ್ಮ adversary? Cast ಹಾಕೋಣ, cast ಹಾಕಿ we'll take up that other matter. We'll impose cost in this.
No, my lord,
If
tomorrow,
they can
my
afford to engage in a senior advocate, they can pay the cost also.
tomorrow only, my lord,
It's adjournment on the ground that she has engaged the services of senior counsel. Now counsel for the respondent opposes the adjournment. The matter is of the year 2010. Original proceedings are of the year 2000. 2000. However, to grant as a last chance, on payment of cost of rupees, extra corner.
my lord,
What is he? Doctor.
the dog,
Yes, a doctor.
Doctor running a
Dollar ನಲ್ಲಿ ಹಾಕೋಣ ಹಾಗಿದ್ರೆ
doctor running a
my lord, no, my lord.
5,000 payable to ಇದರಲ್ಲಿ ಯಾರು senior citizens ಇದಾರ? Who is the contesting party here? Serial number ಎಷ್ಟು? First final hearing.
Serial number 45.
Respond number. Who is the contesting respondent here? Shankar, you are appearing for R13, na?
R13, my lord, one of
Everybody advocates welfare fund ಗೆ ಹಾಕಿಸಿ. Payable to the advocates welfare fund. List on
1/4.
1 to 4, my lord, I am having personal inconvenience, my lord. 4 days I will not be in station.
Shorter date ಕೊಡಿ.
After
2010 matter.
or my lord before 29.
Before 29th.
Before 29, my lord, otherwise after 6th, my lord of April.
ಆಯ್ತು ನೋಡಿ ಯಾವ್ದು ನಮ್ಗೆ ಯಾವ್ದು ಅನ್ಸ್ತದೆ?
27th. 7th.
Serial number
You have to
40.
telecast and produce the proof. 47. ಅದಕ್ಕೂ ಅರ್ಜೆಂಟ್ ಗಿರೀಶ್ ಕೊಡಿ.
My lord, the cost may be reduced, my lord, kind.
Then we'll convert it to dollar.
Yeah. Can maybe made 2000, my lord, at
Withdrawal of the appeal. ಇನ್ನೊಂದು ಕನೆಕ್ಟೆಡ್ ಅಪೀಲ್ ಆರ್ಡರ್ ಆಗಿದೆ.
Amount by the claimants.
Amount is deposited here.
Yes, my lord, that is permitted to withdrawn by the claimant.
ಬೇರೆ ಕೇಸಲ್ಲಿ, not here.
It is a connected case.
Memo for withdrawal of the appeal. Recording the memo, appeal is dismissed as withdrawn.
My lord, sir. Serial. My lord.
As per memo.
Yes, recording the memo ಅಂತ ಹೇಳಿದ್ರು.
Serial number 46, my lords. I appear for respondent number 1 in this matter. I've
ಇದು
informed,
2011ರಲ್ಲಿ.
I've informed the other side, my lords, kindly be granted a week's time, my
Appear
lords.
for
in
the
this matter.
appellant.
ಏನ್
A
ಹೇಳ್ತೀರಿ?
week's time, my lords, any day in the next week.
ನಾವೇನೋ ರೆಡಿ ಇದ್ದೀವಿ. ಎನಿ ಡೇಟ್
ಹೀಗೆ ಹೋಗುತ್ತೆ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ. ಅವ್ರು ಸ್ಟಾರ್ಟ್ ಮಾಡ್ಲಿ ಬಿಡಿ, you can argue on some other day.
My lords, sir.
Let him start.
Once for all will, on the,
ಫಾರಾಲ್ ಆಗೋದೇ ಇಲ್ಲ, ಒಂದು ಸೆಷನ್ ನಲ್ಲಿ RFA ಮುಗಿಯೋದಿಲ್ಲ.
the cost may be reduced.
ದೊಡ್ಡದಾದ್ರೆ ಇಲ್ಲಿ ಹೋಗ್ಬಿಡಿ ಡಿಸ್ಪೋಸಲ್ ತರ ಇಲ್ಲಾಂದ್ರೆ ಅಲ್ಲೇ ರೇಣುಕಾ ಅಲ್ಲೇ ನಿಂತ್ಕೊಂಡ್ಬಿಡ್ತಾನೆ. ಖುಷಿ ಒಂದೇ ಸಾಕು. ಅಲ್ಲಿ ಇದನ್ನ ಸ್ವಲ್ಪ ಸ್ಪ್ರೇ ಹೊಡೆದಿದ್ರಾ? ಅವಾಗ್ಲೇ ಹೊಡಿಬೇಕು ತಾನೆ, ಹೇಳ್ದೆ ತಾನೆ ನಾನು. ಚೂರ್ ಚೂರ್ ಹೊಡಿರಿ ಅಲ್ಲಿ ಖಾರ.
ಸ್ಮೆಲ್ ಅಂತ ಹೇಳಿ
ಮೇಲ್ಗಡೆ ಒಂದೇ ಎಸಿ, ಮೇಲ್ಗಡೆ ಆಫ್ ಮಾಡಿ. ಹ್ಮ್.
serial number 51.
51. Wait for the other side.
And further. And further.
Yeah, ಆಗ್ಬೋದಾ?
Please.
As requested by appellant's counsel, list on 8-4.
ಒಂಬತ್ತು.
Ninth.
Nine.
Serial number 52, my lord.
Hmm?
Serial number 52, respondent, sir. Senior is in out of station, my lord. Kindly.
Yeah, for the respondent,
Yes, my lord.
nobody has moved it. In a second set to be filed, IA 1 of 2020. Who has statement of objections to IA 1 of 2020? Who has filed that? IA 1 of 2020 was filed by whom? In serial number 52.
Senior is in out of station. Kindly.
Have informed Mr. Balgangadhar?
We will inform now.
As requested, adjourned at the request of response counsel. Yes. Has passed out? Huh.
50.
Purna Bodhara. This is motor accident. Huh? Who has moved it? Somebody has moved it. Who has moved it?
We have.
You are for the appellant.
Yes.
Claimants, huh? Adjourned at the request of the appellant's counsel.
Pastor matter, till number 3, Sirajuddin Ahmad, SPP.
ಯಾಕೆ ಪಾಸ್ ಆಗಿರ್ತಾರೆ ಬಂದಿರ್ಲಿಲ್ಲ ಸೀನಿಯರ್ recalling the order dated 17/9. Dismiss ಆಗಿದೆ. No representation for the appellant adjourned.
Pastor matter, till number 19. Ashokin Patil, SP
1
Prakash.
to 3. My lord, my
This is
learned
regard-
friend, morning, my lord, cited the one judgment. My lord, that judgment, my lord, is not applicable to the case in hand. In that case, my lord,
Was the fraud there? Some, that was with regard.
here, my lord, in that case, my lord, the falsely implicated the vehicle.
Vehicle itself was.
Huh. Here, my lord, there is no such dispute. Only one vehicle here. Here, my car is.
According to them, we have planted a person who has a valid license or due license.
That is their contention.
Even
is their
assuming,
contention.
that's what we asked Mr. Patil in the morning. Even assuming that the first person was the driver, he was not holding the valid driving license. Still, the position is you have to pay and recover.
Recover.
So, yes.
Inmates of the vehicle, notes, I could not lay hands, my lords, that inmates of the vehicle, my lords, would not be a third party. And there is a Madras High Court, my lord, division bench judgment, which says, my lords, the inmates are not third parties, my lords, here. Even if, my lords, even if they are, my lords, to be stated, the vehicle is involved, they don't become, my lords, third parties insofar as the, my lords, inmates are concerned.
Except the driver, others will not become the third party. sir.
Third
No,
party.
my lords.
My lord, last week also, my lord, Krishna Swami, my lord, argued in my matter also. Your lordship, my lord, granted to withdraw the amount also. Last week,
I
one
do
matter.
not remember.
Third parties.
My lords, I'll
How
produce
much
that,
is
my
that?
lords, if it is taken up
My
next
lord,
week.
11,53,221. 50% of the award amount. 11,53,000. 221.
20 lakhs 37,100 is the same. Payments are.
Means if it is taken next week, my lords, it could be disposed of finally. My lords, I'll produce that, my lords, the judgment of, my lords, Madras High Court, where they, my lords, where they have held
2023 there.
23. Any date,
Yes,
my lord,
yes,
next week if it is taken, my lord, I will.
that event. Even in that event, see, even if your contention now
Yes,
is
yes.
that a person without license was driving the vehicle.
Yes.
And the
Pay
subsequently
and recover principle would be applicable. Yes,
in submission record ಮಾಡಿ ಮಾಡ್ತೀವಿ ಬಿಡಿ.
please. Only with regard to that proposition, my lords, whether the inmates, my lords, would be,
The award release 50% out of the amount in it.
yes, yes.
ಇದೇನು admit ಆಗಿದೆಯಾ? 1 for withdrawal.
Appeal admit.
Not at
ಆಗಿದೆ.
admit.
1912 ಇಲ್ಲ. First 1912 ಆಗಿದೆ. Check ಮಾಡಿ 1912 admit ಆಗಿದೆ, ಬರೀ records call for ಮಾಡಿತ್ತು.
PCR ಬಂದಿದೆ.
admit ಆಗಿದೆ.
Admit ಆಗಿದೆ.
Order number 1 of 2025.
The proposition, my lords, in that, my lord, the proposition in Veerappa case is that, my lord, if there is a fraud played, my lords, on the insurer or on the court, my lord, the owner alone would be liable, my lord. That is how, my lords, though the facts are different, my lords. There, in that case, my lord, there was already a FIR and charge sheet which was suppressed and a PCR came to be filed. And they did not prove independently, my lord, whether the vehicle was involved. Here, my lords, though all of them being aware that, my lords, the
But you examine the owner himself as your witness. Owner
he,
cum
he has
driver.
examined. He is examined as RW1. He's contested the matter.
My lord,
He's,
That
but he says regarding the,
he was not the driver of the vehicle,
but
right?
he
my lord,
says,
he
But
said,
charge sheet, whether charge sheet is quashed,
no, my lords, it is not.
we understand charge sheet is not
We
the.
cannot, my lords, we cannot challenge it.
ಅವ್ರು ಏನಾದ್ರು ಚಾಲೆಂಜ್ ಮಾಡಿದಾರ?
ಇಲ್ಲ
ಮಾಡಿಲ್ಲ, ಅವ್ರು
ಮಾಡಿಲ್ಲ,
ಮಾಡಿಲ್ಲ.
my lord, he himself said that at the time of accident, I am the driver of the vehicle, my lord.
Cross examination.
And moreover, my lord,
This chief examination, he says so.
at the
And we suggest, my lords, in the cross examination that Anand Kumar was the, my lord, the driver of the vehicle. My lords, he does not answer to that question. He does not answer to that question, my lords.
Subject to result of the appeal ಅಂತ ಮಾಡ್ತೀವಿ. In compliance with the interim order of this court, while granting stay, the appellant has deposited 50% of the award amount with accrued interest.
accrued interest.
With accrued interest before tribunal or here?
My lord, before
the
senior
tribunal.
civil judge J. Channagiri.
Before the tribunal. Response 1 to 3, the claimants. Under the above application, response 1 to 3, the claimants are seeking release of the said amount. Shri Ashok and Patil, legal counsel for the appellant, submits that the liability of the appellant is the compensation was disputed on the ground that the actual driver of the tortfeasor / driver was not holding a valid driving license and to make unlawful gain from the insurance company. Later, respondent number 1 now,
Who is the owner also?
respondent number 1, the owner cum driver of the vehicle was planted in the case. The counsel for the counsel for response 1 to 3 / claimants submits that respondent number 1 had not questioned the charge sheet and he has admitted in his evidence that he was the driver of the vehicle. The accident is not in dispute, even assuming that a person without driving license or without a valid driving license was driving the offending motor vehicle. The legal position as on today is that the insurer has to pay and recover. The claimants are the widow and children.
My lord, the 2 and 3 are the sisters. But one is the father.
His name is Indu Kumar.
Indu Kumar, Indu Kumar is deceased, Prem Kumar is the father.
Father.
And my lords,
Prem Kumar is-
siblings.
ಸಿಸ್ಟರ್ಸ್ ಅವ್ರಿಗೂ ಅವಾರ್ಡ್ ಮಾಡಿದಾರ?
ಹಾ.
ಎಷ್ಟೆಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ?
Consortium.
ಆಗಲ್ಲ. ಪರ್ಸೆಂಟೇಜ್ ಕೊಟ್ಟಿದ್ದಾರೆ. How do they become the dependents? Apportionment
ಅಪೋರ್ಷನ್ಮೆಂಟ್ ಏನು ಇದ್ ಮಾಡಿಲ್ಲ.
Petitioner number
ಅಪೋರ್ಷನ್ಮೆಂಟ್
ಇಲ್ಲೇ ಇದೆ ಅಲ್ಲ. Respondent 2 is at liberty to recover compensation amount so paid to the petitioner from respondent number 1 and
Because that is because, there is no permit for the offending vehicle. There is no permit also. We are on the ground of
position regarding permit.
it-
Amount pay and recover.
pay and recover birth, yes. And that I have not questioned, my lords. I have only questioned, my lords, with regard to the,
What ಅಲ್ಲಿ ಯಾರ್ಯಾರಿಗೆ ಎಷ್ಟೆಷ್ಟು
ಯಾವುದು ಅದು ಬರ್ದಿಲ್ಲ ಅಲ್ಲಿ.
will now award 50% only to the father. Therefore, tribunal is hereby claimant number 1 is the father of the deceased. Considering the same, the tribunal is hereby directed to digitally release 50% of the amount in deposit to claimant number 1 and invest the balance amount in FD in any nationalized/scheduled bank of the choice of the claimants for a period of 3 years. IA 1 of 2025 is disposed, 25 is disposed of accordingly. Transmit the TCRs to the tribunal. Tribunal shall resubmit the records soon after the purpose is over.
may I request this observation in the, my lords, that the amount which is,
Subject to the result of this appeal.
the amount which is now released, my lords, I may be, my lords, I may be granted the liberty to, my lords, to enforce, my lords, pay and recover as a pay. Ide, but my lords, since it is, the matter is appeal is pending, they may object, my lords. Otherwise, they will sell out all the assets. Please, my lords.
They have not preferred any appeal.
Any appeal, yes, yes.
Correct. Now it's always open to you. Why should you?
Please.
Yes.
Final hearing at 2:30. Cell number 56, Jayant Balkrishna, party in person, Vinit V. Bhagat, Ventesh R. Bhagat.
I am for the respondents, my lords. In a connected case, I am for the appellant. I may be permitted to argue online, my lords. I am having some inconvenience today.
Since when you are appearing as party in person? 8/11/2021. There was an application to permit him to. In court, a permit.
In person.
There's an order, my lords. Those all documents will be considered. I will be considered at the time of final hearing, my lords.
Yes. Yes.
My lords, I have submitted my paper book, 3 volumes and 2 supplemental volumes. And I've also recently, this month, provided an updated synopsis. I'd like your lordships to please refer to that when I come to that point. To begin with, I would like to provide a nutshell of the overall litigation. The subject matter of the litigation is construction of a residence on an 80 by 120 plot approximately in Jakkur, near Yelahanka. Tenders were taken for a civil contractor work only, and even those items of work, not all civil works were apportioned to the respondent, was the contractor. Now, the important aspect of it is the issues that the court has framed. It is on page 72 of volume 1, numbered page 72, volume 1.
This.
It is your lordship. issues. Number one, whether the plaintiff proves, that is myself, proves that the defendants are liable to pay us, defendant is liable to pay a sum of rupees 17 lakhs 48,000 along with interest at 18% per annum from the date of suit till the date of realization. The second issue is whether the plaintiff further proves that there was a cause of action as alleged. In that respect, I have claimed some rental proceeds, and I will elaborate on that subsequently. Number three, whether the defendant proves that the plaintiff is liable to pay a sum of 4.88 lakhs as a counterclaim. So that is how we have RFA 1922/12 as the connected matter. Now, 4, whether the plaintiff is entitled for the decree sought. 5, whether the defendant is entitled for counterclaim sought and what decree or order.
What are you referring to? Which volume are you referring to?
Volume 1. Your Lordship, it is a pink volume. That is not the correct one. It is a pink cover. It is, I believe.
What of the pink volume it is?
Paper book first set anta ide volume.
Totally, there are 3 sets of paper book, my lords.
Sir, only one set you have given.
3 sets, Your Lordship. 19, 11, 20.
3 sets. You have to give for each judge 2 sets. You have
2
to
sets, yes. For first set and second set, both have been given.
Page number is 2 because I am seeing this.
Page number 72 of volume 1.
Page 74.
72. Your Lordship, what you have there is not the correct one. It is not on green paper. I mean, it is not on that.
Yes. Yes.
May I proceed now that I've covered the issues?
Just a minute.
Basically, there were
Volume number 1, 2, and 3 ಅಂತ ಬರ್ದಿಲ್ಲ. ಇಲ್ಲ volume 1 ಅಂತ ಇದೆ. Put up sir. ಇಲ್ಲಿ ಬರ್ಬೇಕು volume.
Substitute paper book ಅಂತ ಇದೆ.
Yes.
Now, I would like to mention that the trial court basically did several things. They questioned the expert opinion of the court commissioner, engineer commissioner was appointed. The trial court also questioned the independent engineer that I had hired to check the quantities. The trial court overlooked the fact that there was a third technical committee in the form of the Council of Architecture, New Delhi, where I had complained against the architect regarding his conduct during the construction. And disciplinary.
Basic facts. Did you allege that there was defect in construction or?
There was defect in construction. I will come to straight away to the.
Tell us the basic facts.
The basic facts, Your Lordship. Kindly, if you would kindly come to the updated synopsis that I have provided. There's a table of contents, and that will.
Not necessary. You can submit. What is your case? What was your case?
There were claims and counterclaims. The components of my claim.
On what basis you claimed?
The excess unjustified billing was the first component. Second component was unfinished deficient works. Third was discrepancy in the amount that I have paid and what he claimed was received. Fourth was rental costs, avoidable rental costs. These are 4 components of my claim. And whereas the components of the counterclaim was, there was some money yet to be paid. And there was another amount which was billed to me after the fact, after the contractor, the respondent received legal notice regarding the claim that I had made. Now, he claimed that additional amount after a legal notice was issued to him. So these are the 2 components of the counterclaim. Now, what I would like to do is quickly go through on page 5 of my updated synopsis.
Which one?
Synopsis is right at the top here.
Yes.
The synopsis is a very small,
Yes, yes. Updated
on page number 5.
page number 5 is.
I've broken up the components of the claim. Underneath that, I've said who are the witnesses examined in chronological order. Very quickly, the court appointed an engineer commissioner, Professor Emeritus from the Indian Institute of Science and Civil Engineering consultant. Specifically, his report states the means and the methods he used to submit his report. An expert's technical opinion, as noted in the trial court judgment on page 114. The trial court itself, on page 114, numbered page 114, acknowledges that the work of the engineer commissioner was a technical specialized subject. It is very important to note. And in accordance, and the commissioner, EC, I will refer to him as, he did his work in accordance with the memo of instructions issued by the two litigants. The means and methods used by the engineer commissioner is stated in his report as consisting of memo of instructions, MOI, tender documents, since tender documents was the reference point, working drawings. Working drawings means exactly how the contractor is supposed to carry out his work, the respondent. Field book, that is where all the information about construction is entered by the architect and by the contractor. Physical measurements, discussion with litigants and their advocates, etc. Excess billing as determined in his report on disputed items of civil work only. Now, there were disputed and undisputed. Undisputed, naturally, how did the undisputed quantities come up? Because I had already hired Ranganath and Associates, a consultant civil engineering.
In person, you are to take us to the fundamental principles of your case factors. Please take us through. Don't assume that we know your case. We do not know your case.
Okay.
Don't start with the argument of your assumption. Please take us through ABCD of your case.
On page 8, Your Lordship, I have the chronology.
Please read your plaint.
Chronology on page number 9.
Please go to plaint, read the plaint, read that written statement,
We were
then take us.
asking you, what are the basic facts? What was the contract between you? How your claim arises?
Take us to the plaint and written statement.
Your Lordship, yes. Your Lordship, my plaint on page 19. On page 19 of paper book, volume number 1, volume 1.
See how this cropped up. What was your case? What was the contract? What was the terms of the contract? How your claims have cropped up? You have to show us that.
Page number?
Page number 19, numbered page 19.
Yes.
That, I was the full and the owner of that property on which a building was constructed. Next page, I hired an architect. The architect floated tenders.
Where's the contract?
The contract, Your Lordship, it is easier if we come to the synopsis where the chronology of all the events.
Any written contract?
Yes, yes.
The respondent is the builder.
Is the contractor, is the contractor.
Building contractor.
Yes.
Was there any written contract between you?
There was a written contract.
Which is that? What was the date of that contract?
Your Lordship, that is why I prepared the synopsis. If we may just go to page number 8 of the synopsis, everything, the whole story will be explained. Whole story will be explained.
Page number 8.
Page number 8.
Dates and events, this is?
Yes. Dates, particulars, exhibit numbers, etc. Next page number 9. On 12/12/98, architect gave me an estimate of 42.4 lakhs for a completed residence.
What is this 12/12/98? Was it a quotation or what was that?
It's a written estimate. It is part of the exhibit. The exhibit is P28A, page 481, volume 3.
Yes.
Number 2, 3 tenders were floated. That is exhibit P27. Third, defendant's tender and timeline chart for civil construction only for completion of only civil construction works. Excluding woodwork, excluding electrical, excluding plumbing, excluding flooring, excluding painting. since these were all part of the tender. It is admitted that timeline chart work schedule plan was prepared by defendant. It is not disputed that defendant executed only civil works A to E and about 50% in J category. Now, next on 25/1/99, advance mobilization of 4 lakhs was paid. E32 exhibit. Then there was a Gudli Puja. After that, work commenced in 3rd week of February 1999 as per construction chart. That is serial number 3 above. Now, the next point is the building setbacks in the sanction plan versus the ground floor working drawings versus the as constructed building when complete were identical. That is what I gave to the Yelahanka TMC, what was given as the working plan, what was finally constructed, the setbacks. For example, if this was the site, the setbacks is from the compound wall to the building, north, south, east, west. All the setbacks were identical. There was no deviation whatsoever. This may become relevant when the opponent argues. This one, I'm talking about only the ground floor. Some 450 square feet was added to the first floor, undisputed. Next, on 23/4/99, first bill was submitted to architect and the plaintiff by defendant for work below and above ground. That is exhibit P31, right column. Now, this was on a contract certificate, very official looking. On 23/4/99, the same bill, first bill contained costs for alterations, removals, and modifications. I mentioned this because there is a counterclaim. 15/6/99, allegedly validly certified by architect for 4.81 lakhs, my architect. November 1999, work came to a standstill in November 1990 after casting of first floor slope roofs. In every plan, starting from the sanction plan at the very inception, sloped roofs were very much in existence. And there was also a schematic for a pond, a big pond, which was either going to be a harvesting pond or it could be converted into anything else, like a swimming pool or a garden. Next, on 10/1/20, during the course of the construction, R&A's Rangnath and Associates, consulting engineers provided design for a seismic beam on the terrace. Why the seismic beam? As I mentioned, there were sloped roofs. And there was some thought that if there was some earthquake, even a mild one, it would slide. Potentially to connect one sloping roof to the other sloping roof. There was a huge lengthy beam like the one you see on top. R&A was represented by D. Rangnath, Masters in Structural Engineering, IIT Madras, Masters USA, MIE, FIC, FAC, CFI, Chartered Engineer and Registered Valuer, who was also an engineer commissioner at one point in time, Secretary of the Association of Consulting Civil Engineers, India, Bangalore Center. Next, the seismic beam was cast by the defendant. This next page, number 10. Second bill was submitted on 28/3/20. After 11 months, second bill was submitted by architect and plaintiff. Submitted to architect and plaintiff by defendant for the amount of 29.71 lakhs. Nowhere in the tender document, and I will lead you to that, says that only limited number of bills should be given. The tender document refers to running bills and deductions, withholding deductions for running bills till the final bill is approved, subject to warranty period. The next point, second bill contained costs for alterations, repairs, removals, and modifications. Here also, the EC, that is the engineer commissioner appointed by this court, by the trial court, report offers its observations, opinion regarding the defendant's bills containing alterations, repairs, removal, modification, and demolition. Next, the architect states that he certified only first and second bills for the total amount of 32.7 lakhs, 3.37 lakhs, is in exhibit P66. Now, P66 was a reply to a legal notice which I sent to him for his alleged collusion and professional misconduct, which is what I complained about to the Council of Architecture, New Delhi, and I was successful. Second bill was allegedly validly certified by architect for 27.56 lakhs and 0.40 paisa. Even paisa they mentioned. Next, list of unfinished work prepared by architect. Architect himself during the course of the project prepared some unfinished work. Then final bill was submitted, third bill, final. Submitted only to me, only to the plaintiff by defendant for the amount of 14.21 lakhs. I realized that something was amiss. So anyway, final third bill contained cost for repairs, breaking, etc. So in June 2000, the work commenced in February 1999. In June, he was supposed to complete the work, his part of the work, by September the same year, 1999. Now we are talking about 2000. R&A consulting engineers consulted by the plaintiff to estimate quantities and verify first, second, and final bill. R&A conducted site visits and measurements, and plaintiff handed over construction drawings and site logbook, because by then he had left the site, the respondent contractor, saying that he needed more money, without which the work came to a standstill. Next, a defendant left the construction site, leaving behind incomplete civil construction, which he had only partially completed. Defendant vacated with men and materials, changing that he needs to be paid money owed to him. Now, I have photos of that P26, number of photos showing how incomplete that work was, his work was. And it can be verified because his bills do not make a claim for anything beyond that. Plaintiff collected construction drawings and site logbook from the office of the defendant. R&A, there may be a little bit of chronology mismatch in a month or two, but this is to maintain the flow of the activity. R&A prepared preliminary estimate revealing excess billing with certain items of work marked as unknown, UK, unknown. Therefore, we had to contact the architect and we found it appropriate to contact both architect as well as the contractor. Plaintiff contacted architect regarding excess billing and seeking a meeting at his office along with R&A, with my engineer. That's page 34A, exhibit. Architect did not come to his office at the time given by him and refused to cooperate with R&A and the plaintiff. Then plaintiff wrote to defendant regarding excess billing, and this to the defendant, contractor, and confirming termination of the contract. Plaintiff sought meeting with R&A at latter's office. Actually, that should be defendant. Defendant sought meeting with R&A office, for which we have records, P30 office records of the consultant. Defendant visited R&A's office but did not cooperate to clarify excess billing. This is the deposition not only by R&A as PW2, but also it's on his office records. He visited, but he did not cooperate. Next, R&A conducted further site investigations and arrived at his revised estimate of excess billing. Since some of them were unknown, he had to take a guess or educated engineering estimate by the defendant, revised estimate of excess billing by the defendant, along with costs of repairs for defective and incomplete work, which is around 70,500 rupees. For example, there were tanks, underground tanks, there were above ground structures. They were not plastered at all. That was the scope of his work, but he had left, which fell on me, so the cost fell on me. Next, plaintiff sent legal notice to defendant and architect, amongst other things, alleging collusion and sought return of money owed to plaintiff. So after receiving legal notice, architect issued reply notice. Then defendant issued reply notice along with additional bill, making additional claims and showing lower amount than that was paid to him by myself. Next, plaintiff filed recovery suit. After that, defendant filed written statement counterclaim. Then on 30/9/2004, plaintiff filed application and order 2609 for court commissioner appointment for local inspection of unfinished pond, which is frequently referred to as swimming pool. It is an empty concrete structure. There is no semblance of it as a swimming pool. Because there was a mosquito nuisance and there were lots of algae formation, so I wanted that immediately to be looked into. However, subsequently, defendant filed application for appointment of commissioner for local inspection of entire constructed building. I had no problem with it. So In the next step was plaintiff inquired with the Karnataka State Commercial Tax Department regarding defendant's submission to it. Because he is making claims that are unknown to me. And I had to find some place where officially he would have lodged those records. It's got to be his bank records. It's got to be his filing with the Commercial Tax Office. So next page, 11, plaintiff inquired with Commercial Tax Department with CC to Income Tax Department regarding defendant's submissions to the former. That is what submissions they would have made. IT department replied and found 2 bogus checks issued by the defendant in the name of the plaintiff. Exhibits are there. Commercial Tax Department informed plaintiff that defendant had been raided twice in 2004. That is 4 years after he left my site. And that income records were yet to be submitted by the defendant for the work done by his proprietary concern, a business proprietary concern, Puja Construction, for the years 98, 99, 99, 2000, 2000, 2001. So he has not at all submitted anything. Then court appointed an engineering commissioner EC out of 4 nominees. The commissioner was Dr. Srinivasa Murthy, emeritus professor, consultant, Department of Civil Engineering, Indian Institute of Science, Bengaluru. Now, the EC, the engineer commissioner, had site meetings at plaintiff's newly constructed residence with the defendant, the plaintiff, the lawyer, the R&A, the architect refused to attend, structural engineer refused to attend. So this communication was in writing. Exhibits are given. Construction drawing copies, site logbook, copy, etc. were handed over plaintiff to the engineer commissioner to commence his work. Very importantly, the EC communicated the scheduling of the meetings through the plaintiff, through me, in writing for the first 2 meetings, and subsequently communicated in writing to the defendant and plaintiff to the city civil court and by phone to the defendant and plaintiff. Then the EC also in writing dated the exhibit P41 to both defendant and plaintiff, scheduled and visited the new residence to take measurements and for assessment on 14/5/2006. There was no objection to the marking of my document P41, which is the commissioner's communication. All the other documents were objected to by defendant. Next. At least 1 meeting was scheduled by EC at his Indian Institute of Science office, which the plaintiff attended. The EC provided additional opportunity to both litigants to bring any additional points to his attention concerning the case. In his written communication to them, the letter was also addressed to the Registrar City Civil Court before he submitted his report. The EC submitted his report to the trial court. It took him about 11 months. The defendant objected to the EC's report and made defamatory statements against the EC. Next began the deposition and cross-examination of the EC. Continue, ma'am. The plaintiff filed a complaint with the Council of Architecture, New Delhi, against the architect on the basis of reports prepared by R&A, PW2, and the EC. Now, it is like a court of law. I have with me the original of the letter one of several letters I received from the Council of Architecture. If I may be permitted to, I would like to submit it in the form of a memo subsequently.
No, this thing you cannot produce it like this.
IA 4127. Anyway.
Now you have started arguments. Thereafter now what? One after another you can't go on.
Oh, yes, Your Lordship. But I just want to mention the structure of their agency. The council is in receipt of complaint number such and such by Jayant Balakrishna. You are required to file a written statement of defense in 5 sets duly verified in the same manner as the pleading in civil court, etc. Anyway, there's a marked exhibit which shows that he was disciplined, the culmination of the proceedings, where he submitted the deposition of the engineer commissioner. All the deposition proceedings he submitted. All the tender documents he submitted. Despite that, the case went against him. That means in my favor, I have 3 technical reports, all acknowledging, pointing in the direction that there was excess billing. The question of what is the difference between R&A's estimate, engineer commissioner's estimate is something I will come to. The Council of Architecture directed the architect to file his written statement, wide letter dated 10/9/2008. The Council of Architecture's disciplinary committee found prima facie evidence of misfeasance, nonfeasance, malfeasance with the architect and issued its disciplinary finding of professional misconduct. At the COA office at New Delhi, where the architect was represented by the advocate and the complainant represented myself, before the disciplinary committee meeting hearing, the plaintiff requested the architect to cooperate with him to take measurements for which he would pay him the fees. The committee members agreed. However, the architect refused. Next, the plaintiff applied under RTI to the Commissioner Tax Department for the financial records of defendants Puja Construction, which is who did the billing on my project. Next, on page 14, serial number 48, the plaintiff was located overseas from August 2009 to May 2014 with intermittent visits to Bangalore. The EC completed his evidence. Then PW1 to PW5 completed their evidence. P1, PW1 was myself, PW2 was R&A, PW3 was the landlord, I think one of them. Anyway, the other three was carpentry contractor, manager. One was a neighbor living across my residence, and third was the person who rented the property to me. Then DW1 and DW2 completed their evidence. DW2 was a plumber, DW1 was the respondent. Plumber who was there temporarily. Then the architect deposed as PW3. This was after he has been disciplined by the Council of Architecture. Architect deposed against the plaintiff on behalf of the defendant as defendant witness. After disciplinary proceedings were against him by Council of Architecture were completed. Then final arguments were completed by both litigants. Trial court posted the case for judgment on 11/1/2010. The trial court adjourned the matter 17 times and did not pass judgment, and the judge was transferred during the May court holidays. So 17 times, there were no further arguments. It was finished in December. It just got postponed. The new trial judge came. He is completely unaware. He was never a part of the proceedings other than hearing the final arguments. He did not have the benefit of the deposing witnesses and the circumstances surrounding the case. The new trial judge heard the arguments de novo. There were 37 scheduled court hearings in all for over a period of 1 year, 4 months. This would have continued, but I had already filed 2 writ petitions. The first writ petition was during the tenure of the first judge, because the court was dragging the proceedings in terms of deposing, in terms of the delay in depositions to be conducted. The High Court was said that the trial court should finish up in 4 months. That didn't happen. I waited another 1 year and a half, and then there was a second writ petition, and to complete it in 2 months. This is relevant because of the proceeding. The trial court are very critical to the outcome of your adjudication. The plaintiff filed writ petition 41347 under Article 22 of the Constitution before this court, praying disposal of the case by trial court in light of the delays in proceedings. Okay, now here is the important matter. The trial judge called for both plaintiff and defendant to be present at the court. I had just come down for a brief period. In January 2012, 23rd, he pressurized both litigants to appear before him. To be present at the court, we attempted to pressure the plaintiff for settlement and suggested a settlement amount of 5 lakh rupees. The amount was too low, which the plaintiff refused. I said, please continue with the proceedings. Next was at the above open court hearing where the plaintiff's lawyer, my lawyer, N.I. Nyanesh, representing Ravi B. Nayak advocates, the plaintiff informed the judge and the defendant that he was planning on disposing of the suit property shortly. I had holding it for 10 years, out of country, and I had reasons for disposing it and let them know, and therefore could you please take measurements, give another opportunity for measurements. He informed the judge and the defendant that both defendant and plaintiff could take measurements at the site. Defendant refused, and the judge concurred and said it was not necessary to take measurements again. A very valid point in law. The next point, 15, in the above writ petition, number 413, filed by the plaintiff, this court directed trial court dispose matter in 2 months. Now, I get a call when I'm studying my LLB in UK. Infuriated judge made adverse comments about plaintiff in open court after being notified by the High Court in writ petition number dash to expedite the adjudication. Under such circumstances, advocate for plaintiff, he did not want to be part of it. I have submitted, this honorable court can take judicial notice of the facts that I sent in alarm, stating this is what I've heard. I sent it to the Chief Justice with a copy to administrative judge saying this has happened in the court. Please take a note of this. What else did I do? Advocate R. Nataraj, who is, by the way, a judge now in this High Court, said you apply for a transfer application. So Section 24, he mailed me immediately a Section 24 application, which I have placed on record under IA number 2 of 2022, which I have filed. And he said, but what happened was the court holidays came about. And the day after the court holidays, when the court resumed operation, the judgment was declared. So I did not have any time to apply for a transfer application to avoid this costly mess. Next, fax registered letter sent from UK by plaintiff to the CJ and Administrative Judge of Karnataka. Plaintiff's new lawyer sought to file application under Section 24 CPC, intervening event that prevented filing the said application for the month of court holidays in April, May 2012. Now, earlier, plaintiff was informed by advocate Sri N.I. Jnanesh that the judge passing the judgment, Sri N.C. Srinivas, I don't think his last name is Srinivasa, I think it's Srinivas, had called late advocate B.N. Prasad, who was appearing for the defendant. He called and Sri Jnanesh, both lawyers for the parties, to the judge chamber, informed them that he was a relative of both litigants and was related to an uncle of the litigants by name late Sri N. Chennegowda at Mysore. The plaintiff did not know that such a relationship existed, nor had he heard of the name Sri N.C. Srinivas prior to that time. Judgment and decree was passed by trial court on the day of reopening of the trial courts. Now, my case before your lordship, and I will go to each and every exhibit and explain with clarity. It will take a lot of time. In the meantime, I would like to just adopt the legal principles, which are 11 in number, unusually high, in contract, quasi-contract, in tort, and in equity. How the judgment of the trial court was exceeded its jurisdiction, and also in two aspects. One, it became the engineer commissioner itself. It became the engineer itself. It acted out of its jurisdiction, and you have an expert opinion, and it's very key to the case. Besides expert opinion, there's one piece of evidence I understand, but what else, what other evidence do you need? I will explain that to prove my case. The citation that I have cited number 1 and 2 on page 16, it is settled law, the nature of work entrusted to the engineering.
Said, what is your case? You have to go one by one. There are issues. In support of those issues, how you laid evidence, how your evidence was acceptable, why rejection of the same is incorrect, that way you have to go.
Okay. So I will not apply the law to the facts.
We are not concerned with all these peripheral things.
Your Lordship, if I may I respectfully submit that why it is important is because I'll have to go to the judgment itself and then come to this. Either I go here and then go to the judgment to verify, because what I'm saying is,
you either you show us your pleadings, your evidence, and then judgment, or you read the judgment and tell us how it is incorrect.
I'm coming to
that. It's only re-appreciation of evidence for us. The other things, peripheral things, we are not concerned here.
Your Lordship, first of all, procedure was not followed. I mean, procedure was followed, sorry, by the engineer commissioner. What the court's trial court, may I say what the trial court said? They said natural justice was denied. to the defendant. Why means because he's not informed. He was kept in the dark. He didn't know anything at all. And we did everything on our own without informing him. Therefore, the case should fail. My case should fail. What I'm saying is Order 26, Rule 16 and 18, what they say and what the facts show are consonant with one another. And I will just come to back to exhibit number. Exhibit number P24 and 24A. That's in volume 3. Should we turn to that, or I would like to go to volume 3. Volume 3, exhibit 24A, page number 436. I am applying the law to the facts very simply. That's all I am doing.
Yes, column 3.
436, Your Honor. Numbered page 436.
Your contract is exhibit number?
Contract is executed number.
It was a tripartite contract between you and architect.
Only between the contractor and myself. That is 468, Your Lordship. 27A. 468. Your Lordship, I don't believe that is the 468, volume 3.
No, in the judgment next year we are saying exhibit is to, what is that exhibit?
Exhibit number 27.
27. 27 is tender document and compare it to tenders.
No, 27A, then page 468.
468 in which volume?
For volume 3.
Schedule of quantities for proposed construction of residential building.
This is the contract signed at the bottom on each page by the contractor. And these are all tender quantities, Your Lordship, only for civil works, as I have mentioned. If you come to page 479, I have accepted the contract. Although the conduct of the parties is sufficient, it need not be in writing, but this relates to the tender.
This was exhibit P27.
27A. Page 468 to 480.
Yes.
I would like to bring to your attention the last page, Appendix A, that is 480. These are very relevant to the litigation. Defects liability period, 6 months or monsoon, whichever is late. Number 2, period of final measurement, 15 days from completion of the work. 3, retention percentage, 3% for all running bills, 2% for final running bill. There's no limit on number of bills that should be given. Basic cost of cement, 155 per bag. And if we go down, all the unit rates are given.
To 480.
480.
480, it's not there, no? Defective liability, yes.
So 480, basically it indicates defects liability and all the unit rates based on which the tender is to be given. If it exceeds, Definitely, you generally around 5 to 10%. Now, this is, by the way, the estimation and costing a lordship is a specialized subject in civil engineering. This book will give you a clue, but this is for the students. But for the practicing engineer, it depends on the number of years you're in practice, and that's how it becomes an expert opinion as well, and your experience in the field. Then the nature of bricks, the make of the cement, the make of the concrete blocks, those are all relevant because these are expensive standardized material, but substandard material was used. Now, there were also non-tendered items. Tender item is not, these are the tender items. In any contract, you are going to come up with variations non-tendered. For example, if you have only ground level construction for the ceiling, it may be in the tender. But if it goes to second floor, third floor, fourth floor, you have to enhance it because materials will be required, extra labor is required, so on and so forth. That is haul time. So sometimes you come up with non-tender. Now, what my claim is, and what the engineer commissioner and R&A, the consultant, said is, even though there were tender quantities, he has made them non-tender quantities, the contractor, and build a higher rate. Now, if you really want to know illustratively, what is my gripe? Why am I fighting? You know, the principle of it. If you take this entire room, he says he has constructed this entire room about 10 feet high, same 2,000 square feet, which doesn't exist, 180 running feet of 9-inch thick wall, which we'll have in our residences, 180 feet, can you imagine, 10 foot high without any openings, he says he has built. I mean, he says he has constructed, which is not there. This is what EC says is not there. This is what R&A say also is not there. Then 1,200 running feet of beam. Can you imagine? This is a typical beam, if I may say so. The beam on top here. He says 1,300 running feet of concrete beam he has put in. How did he do this magic, which is not there? How did he do this magic? By increasing the beam quantity, increase the steel quantity also, because every beam will have a steel through it. And not only that, he has not taken the working drawings. In the working drawings, Your Lordship, that is the exact manner in which the contractor is carrying out his work. If I might say so, I have drawings, for example, here, which is marked as exhibit. Which is this is exhibit P14. For example, there are at least 12 like these different cross-sectional beams because each will have different amount of steel in them. He's supposed to measure the length, the extra amount, etc., wastage and all that, and bill for that. Instead, he takes a rule of thumb. So much concrete, so much amount of steel per concrete, like a magician. So the engineer commissioner and the Rangnath and Associates said at least 13 lakh was in excess. So his steel quantity exceeded by 7 tons, the estimate of these two consultants. The consultants differed by 1-2% in term, and I put that in the synopsis. Same way, he says that I've already mentioned illustratively the 2,000 square feet of ceiling is missing, and he says he constructed it, so he had to demolish it. He doesn't show anything to demolish it other than small repairs here, there, and there, which he included in first, second, and third bills. So now the question is, who am I fighting? I'm fighting the trial court judge because he has made false statement of facts, and I will prove it. He has made not only that, he has not followed the thing. He should have recused himself if he was my relative. And he is so intent on pressurizing me.
That there is no material. You cannot make allegations behind back of some person.
I have complained against him. I have not made anything.
But have you taken to that any logical conclusion?
That is up to the administrative section of the High Court.
Not up to the administrative. See, if you are the complainant, if you do not see that it goes to the logical conclusion, then it shows that you didn't follow it or you are not interested. Now we cannot bring that here in this. You have to argue on the merits of this case.
Yes, I'm arguing based on the conduct. Okay, now as far as the jurisdiction is concerned, I am clearly stating, and as a false statement of facts, please come to page 16 of my synopsis, please. I request you. I've spent years on this.
This.
Can I proceed?
Yes.
The legal principle 1, it's an expert opinion. The EC complied with memo of instruction as well as this order 26, rule 16 and 18. This is refuted by the judge. Order 26, rule 16 of CPC powers of commissioner, any commissioner appointed under this order unless otherwise directed by the order of appointment. Well, what direction he has given? He has not given any directions to the best of my knowledge. Even so, examine the parties themselves and any witness whom they or any of them may produce, any other person whom the commissioner thinks proper to call upon to give evidence in the matter referred to him, call and examine documents and other things relevant to subject to inquiry, at any reasonable time enter upon any land or building mentioned in the order. Order 2618, 1-2. The court shall direct that the parties to the suit shall appear before the commissioner in person or by the agents or pleaders. Where all or any of the parties do not so appear, the commissioner may proceed in their absence. Now, what did the commissioner do? What did the commissioner do is in volume number 2. This is his report, a very comprehensive report. I would like to come to volume number 2, Your Lordship, just to the introductory remarks and the concluding remarks. Page 314. Page 314, number page.
Yes.
Second paragraph. The memo of instructions furnished by the advocates for both plaintiff and defendant have been examined. Dispute is essentially about the quantities, quality of work, and rate of non-tender items in the house constructed by defendant for the plaintiff. Next paragraph. The commissioner studied the details of memo of instructions, tender documents, working drawings, bills, field book. Commissioner also had detailed discussions with plaintiff, defendant, and their respective advocates over several meetings and is unable to offer any comments to the following issues for the reasons cited therein. The assessment of quality of workmanship of the building as requested by the plaintiff has not been addressed because quality of work as seen now cannot reflect the quality of work retrospectively as it existed at the time of termination of the defendant's work. Para 2. The defendant has requested verification and quantification of various items such as foundations, lintels, beams, concealed beams, additional reinforcement, etc. Your Lordship, foundation is the foundation of the building. Lintel is something for the window you provide so that the brick does not fall down. It may be a curved beam. Then concealed beam is nothing but if you cannot see something projecting down, they put additional reinforcement in. Since the building has been completed and occupied by plaintiff, items which require breaking to facilitate quantification has not been addressed. Instead, the most acceptable engineering method has been adopted, which is to quantify based on the supplied working drawings, site notes, etc. Because site notes will show any deviations. Working drawings also will show deviations, if any, marked on by the architect, structural engineer. Comments by the commissioner. In the first meeting held on 13 December 2005, and the two litigants and this commissioner were present, it was unanimously agreed that only items which have significant difference in quantity and or billed amount need to be considered. Not everything, not de novo. That is because I had already hired Rangnath and Associates to tell me which ones he agreed with. So he had given me a list. So in the first meeting, everybody got a list of disputed items only. The enclosures provide the details of the estimate provided by the commissioner for the disputed items only. Next, I will just get to that. The bill preparation by the defendant has not been as per the billing norms for construction practice, such as identification of each sub-item, location of the same, etc. In the absence of clarity in billing of items, it has not been possible for commissioner to completely verify item-wise quantities of the running bills by the defendant. Hence, the commissioner had to prepare and has enclosed with this report at a minimum a detailed estimate of quantities for all the disputed items based on A, actual measurements of all the physically visible items, B, from the working drawings, field notes, tender specification, and discussion with concerned parties, etc. C, all foundation work except 148 bed concrete, which is underground, 136 plinth concrete underground, have been accepted as per the claim of the defendant, as the same cannot be verified.
Do you have any agreement between you and the defendant?
27A.
Who has certified the bills? How many running bills?
Only three running bills.
Who has certified them?
First one, architect certified. In his deposition as.
All the three bills have been certified by architect?
No, only for 1 and 2. He claims, but it's not been. That's why I'm coming to that. He claims he has, we have to go through the commissioner. No, it's a tabulation errors are there. He said he has nothing to do with the contract.
No. Party in person, please listen to our question. Your case is basically excess payment.
Yes.
And defective work.
Yes.
The other two items.
Two, yeah, and rental also.
Correct?
Yeah.
And you having made to stay in rental house.
Yes, and amount difference between.
1 second.
Received and
All right.
given.
So you had engaged the service of architect.
Not for that purpose. Only for the purpose of.
Right. The payment made by you was certified by the architect.
But he was supposed to do it in my presence. He did not do so.
We'll come to that later. You just say, these
Yes.
are the
Yes.
admitted facts. You
Yes,
had
he
engaged,
has to. He has to check it.
you had engaged an architect.
He has to check.
So
with
this
me.
architect has certified the bills. You made the payment based on the bills. certified by the architect.
No. It is not the case. This is where the nebulous nature of the litigation arises. Because I was paying in good faith because I had to leave my other would be evicted. I had to leave my rental place and I had to go and occupy the new house. So in good faith, I was paying him. He said,
Where is the terms of the contract regarding payment of the bills? Please point out that specifically. Come to the clause of the agreement.
Page 480.
Page
480.
Please come to the relevant clause.
480.
480.
Yes.
Volume number
1.
Put him on.
Sorry, volume 3.
Volume 3. Please come to the relevant clause.
480.
This is an agreement between whom?
Between the contractor and myself, the respondent and me, and I.
Respondent, you.
Yes.
Please point out the billing pattern. How is the bill has to paid?
Second, number 3, retention percentage. That is the only reference that is made.
No, sir. How the bills have to be raised? Where is the clause regarding raising of the bill?
There is no such clause.
How the bill has to be paid? How the bill has to be certified?
It has to be the understanding, unwritten.
These are the annexure to the contract. Where is the contract?
This is the contract, sir.
Where?
This one, I've signed at the bottom. The tender document
Which
is
the
the
front page of
contract.
the document.
Says only schedule of quantities proposed in the construction. Exhibit P27.
As and when we require certain quantities, they are going to be used.
There should be a contract.
This is the bill of quantity.
Incorporating the clauses regarding mode of payment, what is the advance to be paid, etc. Generally, there will be a such
That
contract.
is number 3, ma'am. That is the only reference. 3% for all running bills, 2% rate.
Where is the tender document?
That is it. Page 480, 468 to 480.
Sir, this is the bill of quantity.
No, sir.
Not a tender document.
No. It is the tender document. 468 to.
What are the terms of the tender?
It is here. 468, please.
468.
It is a tender document. 468.
Please read the heading of the document.
Schedule of quantities for the proposed construction of residential building.
Therefore, it's a schedule, it's a quantity, bill of quantity. This is not the tender document, not the terms of the contract.
No,
Please
that
check
is
your
not,
facts correctly.
that is not how the engineering.
We are aware of it, how it works. Please answer the question. This is bill of quantity. You don't tell us how it
Yeah,
works.
this is bill of quantity.
Please answer.
But
This is a
this,
bill of quantity,
this is
not
not
a
a final bill. This is not a final bill.
You can't just say whatever you want to gets into your mind.
Yes.
We are asking you, we are aware of it. That's why we are asking. This is the bill of quantity. How the bill of quantity is specified also we are aware. That is what this document all about. You please tell us the terms of the contract, how the bill has to be cleared, who has to certify the bill, how the measurement was taken, where's the contract for that?
There is no contract for that.
Then,
Sir, one thing I can clearly say, even
have
if,
to answer
even
directly.
if there's nothing in
right, beat around the bush.
You said there is a contract. We keep seeing so many contracts. There will be generally, the contract says that if it is a building construction, this is the site, this is the specification, And these are the parties to the contract, what is to be done, what not to be done, and time schedule, everything will be there in that. This schedule of quantities only will be an annexure or schedule for that.
Your Lordship, P64 on page 776. That is the only reference.
Where are the certificates, the bills, please show?
Can I just point to P64, 776?
Where
Volume
is
number,
the certification of bill?
certification of bill.
Where are the certification by your architect?
P31A,
Page?
497
497.
to 416, and then up to 586.
Just a minute.
496 to 586.
497.
496, my lord.
496 is again items of our group lenders.
No,
Subheads and
496
Contract
is
certificate.
contract certificate.
And who has issued this document?
This is the contractor, the respondent,
What is
defendant.
the seal of Town Municipal Council, Yelahanka.
Yes, that is just a secondary other exhibit, Your Lordship. Please ignore that one.
I said 496. 496, there is
The first bill.
contract certificate.
Yeah,
There
that,
is a certification of Town Municipal Council, Yelahanka.
no, Your Lordship, that please ignore 30, but that has nothing to do with it. A copy atara bandide.
Come to page number
Hmm.
499.
Yes, yes, for 499.
See the down
That-
below.
that-
This bill is certified for
Huh.
payment
Yes,
less 75,000.
yes,
Who has certified this?
the architect.
On what basis is he certifying?
He's the basis of measurements, he says. I was not present. I
Who
was
has
not,
given the right to certify this bill?
pardon?
Who has given right to certify this bill?
Nobody.
And you have paid the
Was
payment?
supposed to do it with me, sir. That was the agreement. You please turn to page, just one, I request
Is
you.
there agreement between you and the architect?
Just, yes, 776,
agreement?
P64, 776, P64.
Person, he has to assist us.
For that,
Yes, where is the agreement?
76.
That is all. That is the agreement. The total fee payable, bill checking for the above said project lump sum. He has fixed, you see there in the middle, total fee payable, bill checking for the above said project.
Reading it 776.
Yes,
It is
Or at 769, it starts from
776.
form numbers of compliant.
776,
No.
is it?
No.
No. This is from the Council of Architect format.
No, only your page only.
769.
16.
776.
You come to 769.
Okay. Yes, sir.
768 is the letter issued to the Vinod Kumar Registrar Council of
My lord,
Architect.
No, that is complaint lodged by the
Correct.
plaintiff against his architect.
Correct.
It's a complaint.
1 second. 769 is the form of a complaint.
Yes.
Yes.
All right. Have you enclosed any agreement along with this complaint here?
No, he has, and I have not.
Mr.
There is
Bhagat,
nothing
there
in writing,
agreement
sir.
between him and the architect?
Excuse me.
Is there agreement between you and the architect?
This is the only agreement is page 776.
Indicated in 776, exhibit P44 and 4, but it's a
As we mutually agreed, Professor.
letter.
That's it.
It's not a contract or agreement. 776, exhibit P44, letter dated 23/3/2000, written by Suresh Babu Consultants to you.
Yes.
It is not the contract.
It's a bill, my lord. Bill raised by him after
Has been
completion of the
mutually
contract.
agreed professional charge
Are
for
you
the-
sure you'll be able to conduct your case on your own, or you want a professional help?
No, I'm quite competent. If I'm given the opportunity to go through, traverse my 11 principles of law, you will come to a logical conclusion. That is my hope.
No, please appreciate this. Please appreciate this. We are here to hear you. We'll appreciate your all contentions, but there are certain things you may have to understand basic of it. You can't go over the theoretical aspects. We are asking three fundamental issues. That's why we put your case in perspective.
Yes.
The whole basis of your case is excess payment.
Yes.
Number two, defect in the work.
Yes.
Number three, you paying the rents because
Yes.
of the delay in handing over the work.
Yes.
All right. This is the three principal basis on which you have filed a
A
suit.
difference in amount received and paid.
Correct. Therefore, you need to supply the evidence for these four grounds.
I'm coming.
All that here we are telling in your interest.
Yes, sir. See, excess payment.
Please listen, Mr. Party in person.
Yes.
Please listen, Pa. Now, you have made allegation that there was a collusion between your architect and the contractor defendant.
Yes.
Both of them colluding with each other have certified the bill, making you to make the payment.
Yes.
Correct?
Yes.
That's your other allegation.
Yeah.
Now, if you had engaged the service of an architect,
Huh.
you need to have an agreement with him, some kind of understanding between you that he would be rendering service to you as an architect. Number one.
Yes.
Where is the document? Number two, if he is certifying the bill, you would have agreed to pay the bill. So that clause in the agreement to show that you will be making the payment upon certification made with architect is the second issue. So therefore, that agreement between you and the architect becomes indispensable. Where is that document? Number three, you seem to have engaged services of some Ranganatha and Associates.
Yeah.
He's an independent contractor who has gone and given opinion.
Yes.
Then a court commissioner is appointed.
Yeah.
The court commissioner does not issue notice to the defendant. You have admitted in evidence that you have given all the information to him.
No, no,
Based
no.
on, this is the records. You can get back to us. That is why I'm telling all this to you. You have given information to the court commissioner. Based on your information, court commissioner prepared the report. He has admitted that he has not gone, he has not verified, he has not looked at the nature of the construction done. All that is on record. Please take us through to refute these, your own case. One by one. Don't go with the principles of, we are not going to listen to you about the first principles of contract. Don't tell us that.
Okay.
Tell us the facts of the case.
Okay. As far
Just
as
go to these facts, fundamentally 5 points, except a point from the documents. We are still telling you, if you want an assistant professional, you are open to take it.
excess payment, your lordship, excess payment is through two means. One is Rangnath and Associates. Number two is looking at the bills itself where the tabulation errors. And looking at the bills, you cannot even understand what is handwritten.
If your architect has certified it,
he has not.
There is one more basic question. You make allegations against your architect, saying that he had colluded with this defendant.
Yes.
But he is not the party before the court.
No, he has not taken the money, so I chose not to make him a party because he has not taken the money.
Party, when you say that, when you claim something saying that there was a collusion between these two parties, we do not know why the issue was not raised by the trial court.
I couldn't proceed. I can, Dominus Lightus, I can choose who I want. To simplify my,
A defect.
I am not making any monetary claim against the architect.
Some points were formulated, you heard. You answer on those. You make note down those
Yes.
points. And you argue or reply on those things.
Okay, the excess payment is, I refute this.
Child waiting with just, we have other matters also. We cannot devote the entire time for you only. We have so many cases, but your case is also an older case, we have taken it. But you have to be concise and to the point. Not,
Your lordship, there are several hundreds of lines of measurements, agreed? That I cannot, my word is not good. So I have to have an independent person. So I hired, the court hired one, R&A was the other independent consultant. Now, what more could I have done to show that there was
in person, there are certain fundamentals. You see, if there is a contract, whether it's oral or documentary, the terms of the contract has to be specified, number one. Number two, should there be a breach of those terms of the contract, you must specify what is the breach committed. Number three, because of the breach, what is that loss cost to you? All this has to be with reference to the proof. If there is a document. So you take, that is why we told you initially when you opened your argument.
Yeah.
You need to take us through this first. if these fundamental are not available, primary documents are not available, you relying upon the external evidence of a private entity of Ranganath and Associates and the court commissioners, they are secondary.
All right, I might say inherent in the billing itself.
Objections were filed to the court commissioner's report.
Yes, my lord.
Elaborate process now, he has admitted everything. Nothing else.
And I have,
You read the extracts of the court commissioner.
Yes, my lord.
extract.
Read the extract of the court commissioner judgment.
Para 15 onwards, my lord.
Para 15.
Can ask him, we are withdrawn with not,
Okay, now I will walk you through court commissioner.
How much time you require?
See.
Considering the level of detail, I need another hour.
No. Yes, within 1 hour you are going to complete.
Yes, ma'am.
Because here we have to listen, hear all the parties and all the cases. Everything we can allot some time for you. You have to complete within that time. Because now we are hearing you since I think soon after 2:30, 1 or 2 matters, just small matters were over. If you want another 1 hour, then we'll fix it on some other day. You have to complete within that 1 hour.
If I may, even before that, just another 5 minutes, if I might take court's time, I will just bring to the attention what the judge had to say.
See, you are not going in a correct, in a channelized manner. Once you go to the evidence, once you go to whatever you have written, and now you come to the judgment, you only said first, either you will read the judgment and show what are the defects there, or you said you will read your present your pleadings, what is your case, then what is the related evidence, then how that is incorrectly applied by the trial court.
Yes.
Either way you have to go. You cannot go here once and here to another point again. It is a procedure. That's why
in my synopsis,
professional for that, you can take the service.
No. In my synopsis, I have clearly stated what are the facts that are a false statement of facts.
That. The shows from the judgment, what is that?
Please go to.
No, we'll continue on some other day. You said you will complete within 1 hour, you have to complete within that 1 hour.
Yes, but I am going to use my synopsis to answer all the questions because it refers to the exhibits, the judgment and everything else.
Whatever
That is why I've got a skeleton and from that.
Or go to the judgment, whatever is. We'll allot you certain time, you have to finish. The 1 hour is too much because we have given you a lot of time now.
Your Lordship, it's difficult.
45 minutes, 45 minutes. This ನಿಮಗೆ ಎಷ್ಟು ಬೇಕಾಗಬಹುದು Mr.
Half an hour, my lord. That's half an hour maximum.
I require 1 hour, Lordship, because I'm
already given you more than 1 hour.
I need simply because I've struggled for 22 years on this, where it's a very obvious prima facie.
You are thorough, you will not struggle.
No, page 23, if I might go to principal number 7.
Other day, yeah, others are waiting.
My lord, even he sold the. My lord, he sold the property, building is demolished, subject matter is not existing.
Right, whatever it may be, if there
Yes.
was some contract, there was breach
Yes,
of terms
yes,
of the contract.
yes, my lord.
And
Yes,
because of such breach, he has suffered certain loss, he has to
Yes, ma'am.
establish that.
Yes, ma'am.
But
Let
they
him
are
argue, my
showing
lord.
this,
41 rule 24 of CPC gives the finality can be done by this court depending on what it finds.
right, see, the appellant, you have to confine yourself. You should churn it in such a way that you should be able to present it in a time-bound manner. In an examination to write a 100 marks question, how much time they will give you?
If I am given uninterrupted time, I can finish in 1 hour, Your Lordship.
Because we have to find out what you are submitting, because we should follow that. That's why we'll interrupt. Not, you cannot say that court cannot ask you anything.
No, I'm not saying that. I need that additional time.
Date fix For the
What are you
party
doing
in
now?
person.
What are you doing now?
I'm an empaneled arbitrator. I write legal articles on judicial review and I fight the courts in different forums, PILs, for specific performance, contract like this, and also partition suits.
For the appellant party in person in part,
I've addressed the
party in person,
National Judicial Academy.
part for quite a long time. As the court time is getting over. The matter is adjourned, assigning, asking the party in person to submit his case in a nutshell, within a specified time. He submits that he requires 1 hour. He shall complete his, next hearing date, he shall complete his arguments within 45 minutes. Yes, next on? 2-4.
Much obliged.
2-4.
Much obliged, my lord.
At 2:30. I really believe no one At 2:30 we'll fix it, final hearing.
Yes, my lord. Yes, my lord.
G&W ಇತ್ತು ಅದೇನಾ
Cell number 54. Chandan Govindraj K.
ಅದು ಆ ಮಗು ಅಲ್ಲ ಅಂತ ಕಾಣಿಸುತ್ತೆ ಅದು. ಇವ್ರು ಯಾರೋ ಒಂದ್ ಮಗು ಕರ್ಕೊಂಡು ಕುತ್ಕೊಂಡಿರಲ್ಲ, ಅದು ಆ ಕೇಸ್ ಅಲ್ಲ ಅಂತ ಕಾಣಿಸುತ್ತೆ. ಅವ್ರು ಯಾವ ಕೇಸಲ್ಲಿ ವೇಟ್ ಮಾಡ್ತಾ ಇದ್ರಲ್ಲ, ಯಾರೋ ಮಗುನ್ ಕರ್ಕೊಂಡು ಕುತ್ಕೊಂಡಿದಾರಲ್ಲ. ಅಲ್ಲ ಅವ್ರಲ್ಲ ಅದು. ಯಾವ ಕೇಸು? ನಿಮ್ ಪಾರ್ಟಿ ಹೆಸರೇನು? ನಿಮ್ದು ಪಾರ್ಟಿ ಹೆಸರೇನು?
Lord, 54, my lord. Serial number 54.
ನಿಮ್ಮದಲ್ಲ,
I am appearing for the respondent.
ನಿಮ್ದಲ್ಲ ಇದು. ನಿಮ್ದು ಹಿಂದೇನೋ ಅವ್ರು ಟೈಮ್ ಕೇಳ್ತಾ ಇದ್ರು. ಯಾರು ವೇಟಿಂಗ್ ವಿತ್ ಚೈಲ್ಡ್ ರಿಲೀವ್ ಮಾಡೋಣ ಅಂತ ಕೇಳ್ತಾ ಇದ್ವಿ, ಯಾವ್ದು ಅಂತ.
Please.
ಅವ್ರಿಗೆ ಹೇಳಕ್ಕೂ ಬರ್ತಾ ಇಲ್ಲ, ಅವ್ರ ಅಡ್ವೊಕೇಟ್ ಯಾರಂತ ಗೊತ್ತು. ಸರಿ ಆಯ್ತು, ಇವ್ರು ತಗೋ.
Number
54. 54 ಬಿಟ್ಟು ಉಳಿದಿದ್ದು ಮೊದಲು ಅಡ್ಜಸ್ಟ್ ಮಾಡೋಣ.
Cell number 46. M. Vinay Kirti.
ಇದು
P. Ravi
ಬೆಳಿಗ್ಗೆ ಏನಾದ್ರು
Prakash.
ಟೈಮ್ ಕೇಳ್ತಾ ಇದ್ರ? ವಿನಯ್ ಕೀರ್ತಿನೇ ಇಲ್ಲ.
madam.
ಅಲ್ಲ, ವಿನಯ್ ಕೀರ್ತಿ ಅಪೋಸ್ಟ್ ಆರ್ ಸಂಬಡಿ ಸಾ ಟೈಮ್ ಏನೋ ಆಯ್ತಲ್ಲ ಇದ್ರಲ್ಲಿ.
Vinay Kirti.
ಅಜೆಂಡ್ ಮಾಡಿದೀರಾ ಅಥವಾ
46 this is Vinay Kirti. Today it will not happen. Due to adjournment.
3-4.
ಇಷ್ಟಿಷ್ಟುದ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದ್ರೆ ನಾವ್ ಯಾರು ಕೇಸ್ ಮುಗ್ಸಕ್ಕಾಗತ್ತೆ? ಎಸ್.
Cell number 48. Abhinavar. B. Pradeep.
We'll have it on some other day, Abhinav. I think they were opposing or you were opposing. ಯಾರೋ ಅರ್ಜೆಂಟ್ 2016 ಅಂತ ಇರ್ಬೇಕು. You want any particular date or ಏನ್ after vacation? ಅದಕ್ಕೆ ಯಾರೋ ಒಬ್ರು ಪ್ರೆಸ್ ಮಾಡ್ತಿದ್ರು ಅಂತ.
15-4. 21-4.
ಎಲ್ಲಿ ಆಮೇಲೆ 21st ಆದ್ಮೇಲೆ ಎಷ್ಟು ದಿವಸ ಇರುತ್ತೆ? ಅದಕ್ಕೆ ಅಡ್ಜೆಂಟ್ ಅಂತ ಹೇಳಿ ಬರೆಯೋಣ. ಹಾಗಾದ್ರೆ ಇಲ್ಲ ಅಂದ್ರೆ ಓಲ್ಡರ್ ಮ್ಯಾಥ್ಸ್ ಮೊದಲು ಲಿಸ್ಟ್ ಮಾಡ್ತೀವಿ, ಬಂದ್ರೆ ಬರುತ್ತೆ. ಅಡ್ಜೆಂಟ್ ಡ್ಯೂ ಟು ಫಸ್ಟ್ ಕೇಸ್. ಡಿಸ್ಟರ್ಬೆನ್ಸ್ ಆಗ್ತಾ ಇದೆ, ಯೂಸ್ ಮಾಡಿ.
Cell number 50. Adjourned, sir. Purna Bhodara or respondent, madam, R2. Sir, adjourned at request of appellant counsel.
ಯೂಸ್ ಮಾಡಿ, ಇಲ್ಲಾಂದ್ರೆ ಹೇಳಿದ್ರೆ ಅವ್ರು ಅಡ್ಜೆಂಟ್ ಆಗಿದ್ರೆ.
Mahesh ಅವ್ರದ್ದು madam. Cell number 53. Rudrappa P.
assign a date.
ಎಷ್ಟು ಸೀರಿಯಲ್ ನಂಬರ್?
53.
53.
Kulkarni Jayashree Muralidhar.
Stay on the-
I appear for respondent.
No
They have
represent-
filed an application for stay.
How do you
Appellant
call-
have filed. I am a respondent. I am for a respondent.
So you will not be affected even if it is adjourned. He is not there. No representation for the appellant adjourned. Yes.
Cell number 54, Chandan Govindraj K.
Yes, after this matter, we will not be able to take up other matters because it already 4-9. Yes. Here we are, Gurudev.
My lord, on the last date, he filed an affidavit.
55 ಒಂದೇ ಇರೋದು ಈಗ 55
Cell number 55, Somnath H. Srinivas Murthy.
In this case,
uh,
divorce has been refused.
will not be able to take up the matter.
Yes, may I request Lordships to direct the petitioner to be present before this court because my clients are before this court. Right from 2015, they have not seen the children, right from day.
He has not seen. He has not seen the children.
Yes, the petitioner has not seen the children right from 2015 December. He has not paid the maintenance.
Right, have you filed any other cases for maintenance, etc.?
No, my lords.
Any other cases are maintenance?
Only DV case is one pending, but apart from that, there is nothing.
Correct. See,
Two times.
If you want him to meet for giving maintenance, you can file application either, you said already it is pending. Pending,
Yes.
disposed of.
The disposal, ಏನಾಗಿದೆ, they have not considered this.
Award,
4,500 rupees.
you can.
Even after the Supreme Court judgment, man, he has not filed the affidavit as.
Have you filed any application here for interim alimony?
ಇಲ್ಲಿ ಹಾಕಿಲ್ಲ, ಅಲ್ಲಿ ಹಾಕಿಲ್ಲ,
ಹಾಕಿದ್ದೀರಾ?
ಇಲ್ಲಿ ಹಾಕಿಲ್ಲ.
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಏನಾದ್ರು ಅವಾರ್ಡ್ ಆಗಿತ್ತಾ?
ಅವಾರ್ಡ್ ಆಗಿತ್ತು, 4,500 rupees ಕೊಟ್ಟಿದ್ದಾರೆ.
ಕೇಸಲ್ಲಿ ಅವಾರ್ಡ್ ಆಗಿತ್ತಾ?
ನಾಟ್ ಮೆಟ್ರಿಮೋನಿಯಲ್, DV ಕೇಸ್.
ಕೇಳ್ತಿರೋದು ಮೆಟ್ರಿಮೋನಿಯಲ್ ಕೇಸ್.
ಮೆಟ್ರಿಮೋನಿಯಲ್ ಏನಾಗಿದೆ, the practice in the official courts ಅಲ್ಲಿ, they don't file necessary applications in the proper court. That is the problem. In fact,
you have to educate your counterpart.
in fact, I had told them to refer to the Rajesh Neha case. They have not even bothered to submit to the court, and court is.
See, if you are keen about that, you file at least application here under section 24.
Yes, ma'am. Next time I'll make an application.
No representation for the appellant.
And unfortunately, even cost pay ಮಾಡಿ ಅಂತ ತಮಗೆ ಸ್ಟೇ ಕೇಳಿದ್ದಾರೆ ಸರ್. The cost has been awarded 25,000 rupees. ಒಬ್ಬ ಮಗುಗೆ 25,000 ರೂಪಾಯಿ ಫೀಸ್ ಕಟ್ಟಬೇಕಾಗಿ.
It's granted. No.
No, stay is not granted. This is the why.
Execute that. You can execute that if.
Since senior counsel was appearing and then they said, we will hear this court, the previous bench said, we will hear the matter finally. Of course, we are also responsible for the delay.
Is it not that? What is the order? Or such 25,000.
25,000 rupees cost has been imposed.
They have
Two
not-
times he has
they
filed
have
it.
not deposited.
Deposit ಮಾಡಿಲ್ಲ.
Learn consent for the respondent opposes adjournment on the ground that the petition is dismissed. Appellant's petition is dismissed with cause and he has not even deposited the cause. He further submits that the appellant has not met his children. There are two children.
Two children.
Children since when?
Since 14th August 2015. 14th August.
2015 and he has not paid maintenance.
Maintenance
except-
also. Maintenance.
That is recovered 4,000.
He has paid maintenance for some time. Not for COVID period ಅಲ್ಲಿ ಏನು ಕೊಟ್ಟಿಲ್ಲ. Even now he is not paying.
ನೀವು ಅಲ್ಲಿ ಅದನ್ನ ರಿಕವರಿಗೆ ಹಾಕೋಬೇಕು ತಾನೆ?
ಹಾಕೋಬೇಕು. ಅದು ಏನಾಗಿದೆ ಸು?
Last sentence. And he has not even paid. He has not even paid the maintenance awarded in the proceedings under the DV Act.
Yes.
If that is the case, the respondent is at liberty to execute the said order. The appellant shall deposit the cost imposed by litigation cost of rupees 25,000 awarded by the trial court.
Before this.
And litigation, plus additional sum of rupees 25,000 towards the litigation expense of this case before next hearing date.
Which,
List on? That's a list after 2 weeks. List after 2 weeks.
which,
Correct.
Bill number 54.
Lord, with Lordship's permission. My Lord, on the last date, my Lord, he filed an affidavit. My Lord, I am filing my contra affidavit. I may be permitted.
What is that affidavit? There is no direction. You are directed to file the affidavit?
No, there was no direction, but there were certain allegations against me in the affidavit.
In the affidavit filed by him?
Yes.
You are newly appearing in this case. What is that affidavit earlier filed? All right, now let him argue on the main merits.
No, my Lord, kindly see the order dated 28/2/25. For the present, that is relevant, my Lord.
28 to
28/2/25.
28.
My Lord, considering his conduct, my Lord, your Lordship wanted to refer the matter for initiation of contempt. At that moment, my Lord, he sought for an opportunity of hearing before initiation of contempt. My Lord, appellant's counsel submits that an opportunity be given to the appellant to explain his conduct.
Now he filed the affidavit.
Now he has filed affidavit, my Lord, stating as to why he was absent on a particular day. In the affidavit, he has also made certain allegations against me.
It is filed on 12/3/2025. When he filed affidavit?
My Lord, he's filed on 12th of March.
12/3/20. So you are filing counter to that affidavit?
Yes. My Lord, it was not only against me, my Lord, there are certain allegations against the member secretary of the. No, no,
Or what?
no, my Lord, there are allegations in the affidavit.
See, matter has to be finally decided.
Yes.
And if at all we find something wrong, because you were not there, but we have seen how this man conducted.
Lord, I apologize.
You need, why should you apologize for that? Why should you apologize for that?
Lord, the narration that he made, not what happened, because I would only say, Lord, on that particular day, when the child was not.
Here he has said it is spur of moment, natural for any father, etc. We'll consider that if we still find that there are grounds to recommend for contempt, we'll recommend. Now argue on the main matter. And let your client be aware that after examining all these things, if we find that there is a case to recommend for contempt, we'll recommend for contempt.
And my Lord, there is a specific direction for the appellant to be present. He is not present.
Last time last
ಅಲ್ಲ,
time we appeared.
Cost rate, sorry.
ಒಂದ್ ನಿಮಿಷ ನೋಡಿ.
Cost list ಅಲ್ಲೂ ಅದನ್ನೇ ತೋರಿಸಿ.
ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿದೀರಾ ಅವ್ರ ಮೇಲೆ?
ಮಾಡಿದ್ವಿ. ಮುಂದಿನ
ಕೊಟ್ಟಿದ್ದಾರೆ ತಾನೆ? ಆಯ್ತು. ಎಲ್ಲರೂ ಕನ್ಸಿಡರ್ ರೆಸ್ಪಾಂಡ್ ಸಬ್ಮಿಟ್ಸ್ the counter affidavit of whose affidavit is this?
Respondent.
The respondent to the affidavit filed by the appellant on 12/3/2025. Argument ಮಾಡುವಾಗ ಹೇಳೋರಂತದ ಈಗ ಮೇನ್ ಮ್ಯಾಟರ್ ಮೇಲೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ಲಿ ಅವ್ರು.
Filed by the respondent. And Lord, this is an ex parte judgment and has been passed by the trial court. Holding services sufficient, not with respect to that, I would like to take your lordship to page 71 of the appeal compilation. Page
71 is affidavit.
I'm sorry, 78. 78 is the dates on which the appearance has been, or rather, the order sheet of the court below. Lord, on 19/4, the notice is withheld saying that the respondent is not in station at the time of service. Again, on 26/5,
not found, door lock is what they have written. To say the same thing on 19/7, Sadari notice your lordship has it on page 81, my lord. Page 81. On the date of 19/7/22.
Yes, yes.
It is
Yes.
mentioned that Sadari notice Dinanka 18/7/2022 ಬಂದಲ್ಲಿ
ಇತ್ತು.
3 ದಿನಗಳ ಹಿಂದೆ ರಾತ್ರಿ ವೇಳೆಯಲ್ಲಿ ಮನೆ ಖಾಲಿ ಮಾಡಿ ಬೇರೆ ಕಡೆಗೆ ಹೋಗಿರುತ್ತಾರೆ ಅಂತ ವರದಿ ಬರೀತಾರೆ. Surprisingly, my lord, after that the execution petition, this is a house which the appellant's own house, he is residing there from his childhood and is still continuing to reside there in that. And after this, the appellant hearing is placed ex parte, and the matter is proceeded with, and an ex parte judgment and decree has been passed. An execution petition is filed on the same address, which is after filing of the execution petition, which is served on me on the same address, I come to know and I file this. And my only submission, my lord, because I have not said anything before the trial court. It is all based on the allegations made by the respondents that the trial court has passed the judgment and decree, except for the allegations in the petition that the respondent has filed. And one witness of an uncle, no other material has been produced before the trial court, for the trial court to come to a conclusion that this is a fit case to allow the petition that has been filed. My only submission before your lordships is, I have not been heard. The address to which.
Then why did you not file an application under Order 9 Rule 13? Why did you come here? Now here you have to satisfy only on the merits of the case.
Lord, there are two aspects. One, the notice has not been served on me properly. One aspect.
That's what we said. If you are on the point that notice was not served, your remedy was to go under Order 9 Rule 13. Now you have come in appeal. You have to argue on merits.
Aspects I will argue. One aspect is this, that to the address they say, ಮನೆ ಖಾಲಿ ಮಾಡ್ಕೊಂಡು ಹೋಗಿದ್ದಾರೆ ಅಂತ ಏನ್ ವರದಿ ಬರೆಸ್ತಾರೆ, ಅದೇ ಅಡ್ರೆಸ್ಗೆ they file an execution petition. The very aspect that when they know that this person is not there, they file an execution petition on the same address, if at all it was true, is itself speaks more than what meets the eye. They file execution petition on the same address, it is served on me, and I come and file this appeal thereafter. Now, my lord, I would like to take your lordship to the impugned judgment. Lord, the first pages, I go to the reasons at page 90, point number 1.
Yes.
The only thing that they have said is, PW1, the oral evidence has reiterated in terms of the petition and this is supported by witness PW2. PW2 is the uncle of PW1 and therefore his evidence is within the purview of section 50 of the Indian Evidence Act. The petitioner, in order to show that the marriage of the petitioner has taken place with the respondent on 14/7/2017 at so-and-so Chowdhury at Mysore, has produced the marriage photograph exhibit P1. The true copy of the birth certificate of the child, exhibit P2, states the date of birth. The true copy of the Aadhaar card in the petition is exhibit P3 and it shows the resident of Mysore. The marriage invitation card is exhibit P4 and acknowledgement P5 issued by Women's Police Station in regard to the husband and wife problem. The copy of the FIR is exhibit P6 of trial 43 of 2021. Offences alleged are 498, 323, 504, 506, 342, with 34 IPC and section 4 of the. Now, it's very important to note that after filing of this petition, this FIR has been filed, crime 43 of 2021 has been registered. On 27/11/21, this petition has been filed on this petition has been filed on 19/11/2021 before the trial court date of filing. And after that, on 27/11, after more than a week, 10 days, they go ahead and register this FIR, alleging dowry harassment. Nothing before that, which I would only say it is an afterthought, to make the case of the respondent look as if it is denied. none of the allegations that the petitioner has made in the petition for her claim for custody of the child has been proved. No document, the document that has been furnished is Aadhaar card, marriage certificate, birth certificate, apart from that. No evidence or material on record. It is only based on this. Just because the appellant was expired, the petition has been allowed. Nothing else has been produced. No material has been produced before the trial, except for an uncle's witness, PW. With this, I would say the trial court could not have proceeded to allow the petition based on marriage certificate, birth certificate, and Aadhaar card. That is my submission. Not one more aspect. The child is born H. Ganesh.
Child is Runal Rajantan.
Yes. Custody of the child. The child is born on 28/1/2019. The mother abandons the child with the family of the father. She leaves. Nothing has been done till the date of filing of the petition. No attempt. No material to that effect.
Then she abandoned from the date of birth itself.
Within 3 months of birth, she has abandoned and left. And till the date of filing of the petition, nothing has been done. And even after filing of the petition, her concern is to file an FIR on dowry harassment, which is an afterthought. The only aspect here which I could see from the material placed on record by the respondent before the trial court is only to harass the appellant, nothing much. Now the child is 7 years old. In the 7th year, the child can be asked as to what is his interest. At the end of the day, Lord, I am also aware, I am an officer of the court. The child's interest is paramount. Nor the mother, nor the father. In the child's interest, it is paramount. Based on the child's interest, I would most humbly request.
How the child's interest will be served
And
in the company of such an unruly person?
My Lord, one incident, it might have happened. I again apologize on behalf of the appellant. I would only say that my Lord, one submission, my Lord, if your Lordship permits me to make the submission. My Lord, what happened on that particular day when that event happened there? It is, my Lord, quite obvious, my Lord, when he sees itself who was supposed to come from that
Not only there, even
property where he had left the child, he is in next building, hiding near a lift, unattended, and he has gone twice. My Lord, the issue here is, first he has run out of, that is what I have mentioned in the affidavit. First he has run out of the building. Then they somehow go and
we
pick
have
the
all
child.
given, see, even during the conciliation before the court also is not, his conduct was not good.
Lord,
See, whatever kind of conduct they develop or habits they develop, that becomes their character.
My Lord, what I would say is your Lordship might have found him conduct.
If
because I have-
it is his, such conduct is in the court, in the,
Lord, I would
then
only
how
say
he may behave with the outsiders?
He has seen more such things than me in experience. I am aware of that. But I would only humbly request that an opportunity be given to him, put forth his case. That is what I would say. Let him put forth his case. Let him say what he has to say. Let him not be condemned without being heard. It is anyhow an ex parte judgment and decree. That is what I would say.
Last time performed by clearly. Perform ಬೆಳಿಗ್ಗೆಯಿಂದ ಇದೆ ಅಂತ ಹೇಳ್ತಾರೆ, but he was not there since morning. ಅಲ್ಲಿ child was coughing, ಅದನ್ನ ಕರ್ಕೊಂಡು ಬಂದು ಮುಂದೆ ನಿಲ್ಲಿಸ್ಕೊಂಡು ನಿಂತಾರೆ.
Where's the child now?
Child is in Mysore.
Despite court ordering for
Who's taking care of the child?
visitation of
Child is with the father.
What is he doing?
He is the business manager.
In his absence, who takes care of the child?
Lord,
In his absence, who takes care of the child?
Lord, his mother is there.
Whose mother?
The appellant's mother is there. She is there.
but she had not come here, it seems.
Last time ಬಂದಿದ್ರು but ಆಚೆ ಕೂತಿದ್ರು ಅವರು. Was a bit nervous to come inside the court ಪಾಪ ಆಚೆ ಕೂತಿದ್ರು.
But at least visitation should be provided to the child.
Lord,
I mean, mother, sorry.
Lord,
Now, if you say it has to go back, we see whether it has to go back, because our apprehension is that whether child will be safe in the company of such person.
Lord, I make a good submission to God. The child, he might have behaved unruly before your lordship. I will not have any challenge on that. I will accept your lordship, whatever you have to say on that. Lord, I would only say that I have instructed him to be humble. I will again instruct him to be humble. And one more thing, Lord, what I will say,
Old habits die hard.
Lord, it might not be a habit which has developed, Lord. It may be a circumstance he would have done like that. I am not aware of that, Lord. I will not watch on that. Also,
Like the
because I
last
have-
time, where we had directed him to come with a child. He keeps doing all these tricks.
Oh my Lord, it was me. I'm sorry, Lord. It is not me that I asked him to get the child, Lord. It is not his discretion.
And if they come, they should mention.
No, my Lord.
If
What
they
happened?
come, it was being submitted last time that he is here since morning.
Yes, my
If
Lord.
he had come, he could have mentioned it.
My Lord, I was not aware that I could mention that, my Lord. If I was aware, I would have definitely done that. My Lord, what
Okay.
had happened? What had transpired on the prior
Now
day?
here, so this is all your submission.
Lord, one submission on this particular aspect that the Lord just mentioned. My Lord, what had transpired on the prior dates of hearing with respect to child's health, there was an apprehension and all this stuff. So I instructed him specifically saying that, please bring the child also. If the court would want to like to speak with the child, it would be useful. I instructed him, it is not he that he did that. And my Lord, my Lord, in my 30 years of practice, I have never late to a court, my Lord. He was here on 10:30, I was there, I instructed him. That is not my kind of practice, my Lord. I will not lie to the court just because of the client. Never, my Lord, I have not done that in my practice.
Yes, that's all. Oh.
That's all.
Lord, first regarding the service of notice, Lord, kindly come to page 83.
1 second.
Petitioner present, respondent called out absent, held, notice sufficiently served as steps taken out, paper publication. The respondent placed ex parte, then posted for evidence. Lord, this is regarding the service of notice. My Lord, he contends that notice is not served and the shara is erroneous, not true. That is his submission. My Lord, even after the shara, my Lord, steps were taken to serve notice through paper publication.
Filed execution petition.
Yes.
What is the address given execution petition?
My Lord, that was the address known to me.
How did you serve the execution petition summons?
Lord.
Which address did you
Lord,
take the summons?
regarding the stage of,
How, when
No.
he has vacated that house,
no, my Lord,
one second, come to page 81. Come to page 81 of the order sheet, what you just read.
yes, I have read, my Lord. I have read.
So therefore, according to the endorsement, he had left the house.
ಅವ್ರು ಹೇಳ್ತಿರೋದೇನಂದ್ರೆ he evaded notice ಅಂತ that's what
Yes,
I think
yes.
he's saying.
ಇಲ್ಲಿ
ಅಲ್ಲಿ ಬಿಟ್ಟು ಹೋಗಿದ್ದಾರೆ ಪ್ರೊಸೆಸ್ ಸರ್ವರ್ಸ್ ಹತ್ರ ಮ್ಯಾನೇಜ್ ಐಮ್ ಸಾರಿ ಟು ಸೇ ದಿಸ್ ಮ್ಯಾನೇಜ್ ಮಾಡಿ ಹಾಗಾದ್ರೆ ಅವ್ರು ಹೇಗ್ ಬಂದ್ರು ಎಕ್ಸಿಕ್ಯೂಷನ್ ಕೇಸ್ ಅಲ್ಲಿ ಕೋರ್ಟ್ ಮುಂದೆ ಹೇಗೆ ಅಪಿಯರ್ ಆದ್ರು he appeared in execution case no
That I am,
appeared in execution case ಅಲ್ಲಿ ಅಪಿಯರ್ ಆಗ್ತಾರೆ ಹೇಗೆ ಹಾಗಾದ್ರೆ ಬಿಟ್ಟು
Because it was served on mail, ಅದಕ್ಕೆ ಮುಂಚೆ ಏನಾಗಿದೆ? 80
ಕರೆಕ್ಟ್ ರೀ ಅಲ್ಲಿ ಇಫ್ ಹ್ಯಾಡ್ ವೆಕೇಟೆಡ್
ಹೋಗಿದ್ದಾರೆ ಅಂತ endorsement ಕೊಟ್ಟಿದ್ದಾರೆ.
ಕರೆಕ್ಟ್ ಅಲ್ಲಿ this petitioner is not liable, I mean responsible for that. Even if somebody comes with such notice, then she took notice in the execution to the same address, you appeared.
Yes, Lord, because earlier ನಮಗೆ ಸರ್ವೆ ಮಾಡಿಲ್ಲ. The endorsement is at first door lock, ಆಮೇಲೆ not available. Then the endorsement is ಮನೆ ಬಿಟ್ಟು ಹೋಗಿದ್ದಾರೆ 3 ದಿನ ಹಿಂದೆನೆ.
ಅವ್ರು ಹಂಗಂದ್ರೆ ಅಲ್ಲೇ ಹೋಗಿ ಆರ್ಡರ್ 913 ಎಲ್ಲ ಕೊಟ್ಟಿದ್ರಲ್ಲ ಇಲ್ಲಿ ಯಾಕೆ ಬರ್ತಿದ್ರು
When they say that
Prolong
I have to go with the where is the person of the serving on me, my lord? Their report is.
Correct. How were you served on the same address in the execution?
It is for them to answer, my lord.
It is not for them, for you to answer. Bus notice was returned saying that he has vacated.
Yes.
Then second time you were served on the same address. How is that you had vacated earlier?
He
That
was
shows
saying
that
never vacated.
you had evaded. You had not vacated, you had evaded.
Lord, if I had evaded, I would not write that I have vacated.
You will not write that. Process server will write that.
My lord, I would say that that was not my doing.
No, no.
Lord, that was the doing of the respondent, not mine. If that was the case, why will I appear in the execution?
All right. If that is the case, if you say that they have managed to get this,
Yes.
then you are going under Order 9 Rule 13 because there an inquiry will be held whether the service was proper or not. Anta.
My lord, that is.
Why did you not go under Order 9 Rule 13? Because you try to avoid that.
Lord, I will do one thing, my lord. Your lordship may give me liberty. Even now I will go. It is not that case, my lord. The
Correct.
appellant
How
was
many-
wrongly advised.
how many
He was
days-
wrongly- In fact, when the file came to me, I told him, why did you not
Correct.
file an order 9 rule 13?
How many days will prolong it? Because child is in your custody. You are not,
It's not my
permitting.
intent. That is not.
Yeah,
my intent.
he is not permitting the visitation. He goes on making allegations against the judicial officers.
Lord, that is neither my intention, my lord, not my. I'm only saying, Lord, because your lordship said that, I could have as well gone under the file of miscellaneous petition. I
Then
said,
you do one thing. We'll permit that.
that.
You hand over the child till all those proceedings are over. Then you can.
As good as allowing the miscellaneous petition.
Same thing. What happens now if the appeal is dismissed?
Lord, after all, I am the mother, not a stranger.
I will leave to your lordship. The lordship is free to pass any order. I will not come in way of that. But
See,
my lord, what I am only saying is.
the attempt
let me
seems to be
given an
to
opportunity
prolong
of
these matters. Attempt seems to be to prolong the matters.
Lord, I would only say, my lord, that is not the intention of either me as an advocate.
Because this party is in custody of the child, ಇದು ಹೀಗೆ ಹೋಗ್ತಾ ಇರ್ಲಿ ಹಾಗೆ ಮೇಜರ್ ಆಗುತ್ತೆ ಮಗು ಅಂತ.
Lord,
ಇಲ್ಲ ಅವನಿಗೆ ಕಂಟೆಂಟ್ ಮಾಡಬೇಕಾಗುತ್ತೆ ಅಫಿಡವಿಟ್ ಕೌಂಟರ್ ಅಫಿಡವಿಟ್ ಮಾಡೋದು ಲಾಸ್ಟ್ ಟೈಮ್ ರಿಸೀಟ್ ಹ್ಯಾಸ್ ಟು ಎಕ್ಸ್ಪ್ಲೈನ್ ಮಾಡ್ಬೇಕು ಅನ್ನೋದ್ರಲ್ಲೇನು ಮತ್ತೇನು ಹೇಳ್ತಾರೆ ನೋಡಿ ಅಫಿಡವಿಟ್ ಅಲ್ಲಿ ಕಂಟೆಂಟ್ ಮಾಡಿದ್ರೆ ಎಲ್ಲ ತಾನೇ ಇದು ಸರಿ ಹೋಗುತ್ತೆ ಅಷ್ಟೇ. Is affidavit dated 12/3/2000?
No.
Because we had deferred that. Affidavit dated 12/3/2015 ಅಲ್ಲ 2020.
25, ಮೊನ್ನೆ ಹಾಕಿ.
ಎಲ್ಲಿದೆ ಅದು? ಆಮೇಲೆ ಅವ್ರ ಮೆಂಬರ್ ಸೆಕ್ರೆಟರಿ ರಿಪೋರ್ಟ್ ಬಂದಿದೆ ನೋಡಿ ನೋಡಿದ್ರೆ ಅದನ್ನ ಹೌ ಹಿ ಕಂಡಕ್ಟೆಡ್ ದೇರ್ ಅಂತ ಎಷ್ಟು ಪಬ್ಲಿಕ್ ಬಿಹೇವ್ ಮಾಡ್ತಾರೆ ಅಂತಂದ್ರೆ ಅವ್ರ ಜೊತೆಗೆ ಮಕ್ಕಳಿಗೆ ಏನ್ ಸೇಫ್ ಆಗಿರ್ತಾರೆ. ಕೋರ್ಟ್ ಆಫೀಸರ್ ಆಗಿ ನೀವು ಈ ರೀತಿ ಸಬ್ಮಿಷನ್ ಮಾಡ್ಬಾರ್ದು ಅಂತ ಈಗ ಅವ್ರು ರಿಟೈರ್ ಆಗಿ ಅಷ್ಟೇ. ಹಾಸ್ಪಿಟಲೈಸ್ ಆಗಿದ್ದಾರೆ ಕರ್ಕೊಂಡ್ಬಂದಿಲ್ಲ ಅಂತ ಹೇಳಿದೆ. ಹಾಸ್ಪಿಟಲ್ ರೆಕಾರ್ಡ್ ಕೊಡಿ ಅಂದರೆ ಒಂದೇನೋ ಪ್ರಿಸ್ಕ್ರಿಪ್ಷನ್ ಇಷ್ಟೇ ತಂದು ಕೊಟ್ಟರು. ಆಮೇಲೆ ಇದನ್ನ ರೆಕಾರ್ಡ್ ಏನೋ ಹಾಸ್ಪಿಟಲೈಸೇಷನ್ ರೆಕಾರ್ಡ್ ತಗೊಂಡು ಬಂದಿದ್ದಾರೆ ಅಂತ ಕನ್ಸೆಪ್ಷನ್ ಇಲ್ಲಿ ಮತ್ತೆ ಮೆಂಬರ್ ಇದೆ. ಇಲ್ಲಿ ಒಂದು ಅವರ ಡೈರೆಕ್ಟ್ ನಾಲೆಜ್ ಅಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ. ಇಲ್ಲಿ without interrupting the child, it is clear that the member secretary district secretary has submitted a report. Issues. Again, in the affidavit also, some remarks against member secretary
Yes,
legal
yes.
service authority.
Yes.
The secretary has spoken to an assistant, have not spoken to the child per se and has given the report.
No, it is strange, etc. ಅಂತ ಹೇಳಿದ್ದಾರೆ. Report ಹೇಳಿದೆ.
But this is nothing but imputation of falsehood on the judicial officer.
Report as submitted upon inquiry of staff member Naveen reported that on 7/25, the respondent mother informed him that during visitation the child. ಅವ್ರಿಗೂ respondent inform ಮಾಡಿದ್ರು. It is not that even the staff member was aware. Paragraph.
Your client made allegations before us in the chamber that the officer keeps calling him. Visitation right is at 2 o'clock. Officer starts calling him at 1:45 only. We told him he has to make arrangement. He will be other work. Whether you are coming or not, how does he know? So, what is wrong in if he calls you?
I do not disagree at all. Your lordship was right in reprimanding him on that. It is true that 2 ಗಂಟೆಗೆ ಇರುವ 1:45 ಕಾಲ್ ಮಾಡಿದ್ರೆ ಇನ್ಯಾವ ಕಾಲ್ ಮಾಡ್ತಾರೆ. Your lordship was absolutely right on.
ಅವ್ರ ಹೆಸರು ಹೇಳಿದ್ದಾರೆ, ಯಾರ್ ಸ್ಟಾಫ್ ಅಂತ ಹೇಳಿ. ಸುಮ್ನೆ ಒಂದ್ಯಾವ್ದೋ ವೇಗಾಗಿ ಹೇಳಿಲ್ಲ. ಯಾರ್ ಸ್ಟಾಫ್ ಹೇಳಿ. ನವೀನ್ KS ಅವರ್ ರಿಪೋರ್ಟೆಡ್ ಅಂತ ಹೇಳಿದ್ದಾರೆ.
The respondent mother informed him during visitation. It is not that Naveen knows it.
Upon inquiry, our staff member Naveen reported that on 7/2/2025, respondent child disclosed to her that he has instructed not to converse with her and not to accept any food items, etc. ಇದಿಲ್ಲಾಯ್ತು.
If the respondent's mother was informed that Naveen, it is not that Naveen has seen nor the child has been inquired.
ಮುಂದಿನ ನೆಕ್ಸ್ಟ್ ರಿಪೋರ್ಟ್ ನೋಡಿ. ಇಲ್ಲಿ ಓಪನ್ ಕೋರ್ಟ್ ಅಲ್ಲೇ ಹೇಳ್ತಾರಲ್ರಿ ಅವರು, ದಟ್ ಲೇಡಿ ಇಸ್ ಕ್ಲೋಸ್ ವಿತ್ ದಟ್ ಆಫೀಸರ್ ಅಂತ ಹೇಳಿ. ನೀವ್ ಇರ್ಲಿಲ್ಲ ಅವರು, ಬಿಕಾಸ್ ಹಿ ವಾಸ್ ನಾಟ್ ಏಬಲ್ ಟು ಫೇಸ್ ದಿಸ್.
Lord, I was not there on that day, and I will not even involve in that, Lord, because I am not a person who will endorse.
What kind of, dirty mindset this man has?
Extremely sorry, my lord. If he has said that, I am extremely sorry, my lord. I will not come in the way of your lordships. I will not say anything.
Merely because High Court has asked them to do something, is it fair to do that? And they are the deputy of the court.
I am sorry, my lord.
And
I
that
will
is
not- I will-
virtually making allegations against court, which is contempt.
I will not say anything on that, my lord. If you have said that before your lordship, I am extremely sorry for that. And I would leave it to your lordship, my lord. I will not come in the way of that kind of behavior.
ಇಲ್ಲಿ ಅವ್ರದ್ದಿದೆ ನೋಡಿ, ನೀವು ಹೇಳಿದ್ರಲ್ಲ, it is next report. I think you have seen this, 22/2/2025.
ಹೌದು.
Officer, I further humbly submit that on 21/2/2025 at 1:45 PM, appellant accompanied by his advocate came to my chambers raising voice and shouting. He alleged that following the previous visit, his son wandered off to new court complex entrance, and that we had failed to ensure child safety during visitation, demonstrating negligence. However, upon inquiring the matter, etc. But why should he go and shout at the officer?
Not with respect to that, my submission. But when the father finds his son not in the place, wandering in a next building, my lord, ನಾನು
You should search the son and
ಅಲ್ಲ
sit.
ಅವ್ರ ಮಗ ಇವ್ರು ಕಾರ್ ನಿಂತಿದ್ ನೋಡಿ ಓಡ್ಕೊಂಡ್ ಬಂದಂತೆ ಎಲ್ಲಿ ಹೋಗಿ ಅಂತ ಕೇಳಿದ್ರೆ
ನೀವು
ಪಕ್ಕದ
ಏನಾದ್ರೂ
building
ಮೈಸೂರ್
ಅಲ್ಲೇ ಅಂತ fight
ಮೈಸೂರ್
ಮಾಡ್ಕೊಂಡು
ಕೋರ್ಟ್
my lord,
ನೋಡಿದೀರಾ ನೀವು?
my lord,
ಮೈಸೂರ್ ಕೋರ್ಟ್ ನೋಡಿದೀರಾ?
ನಾನು ಮೈಸೂರಲ್ಲೇ ಓದಿದ್ದು my lord.
ಮೈಸೂರಲ್ಲಿ ನೋಡಿದೀರಾ?
ಅಲ್ಲೇ
ಅಲ್ಲಿ
cases ಅಲ್ಲಿ ಓದಿದ್ದು my lord.
ಫ್ಯಾಮಿಲಿ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಇದ್ರಲ್ಲಿದೆ, ಮಳಲ್ವಾಡಿ ಕಾಂಪ್ಲೆಕ್ಸ್ ಅಲ್ಲಿ ಇದೆ.
ನೋಡಿದ್ದೀನಿ.
ಅಲ್ಲಿ ಹೆದರ್ಕೊಳ್ಳುವಂತ ಸೇಫ್ಟಿ ಆಸ್ಪೆಕ್ಟ್ ಏನು ಇಲ್ಲ. If
ಅಲ್ಲ.
child is, there is a park in front of that, and
The
ಅಲ್ಲಿ ಮಗು
serious-
ಅಲ್ಲಿ ಓಡಾಡ್ತಾ ಇದೆ ಅಂದ್ರೆ ಅಷ್ಟು ಹೆದರ್ಕೊಳ್ಳುವಂತದ್ದು ಏನಿದೆ ಅದ್ರಲ್ಲಿ? ಆಮೇಲೆ ಭಯ ಆದ್ರೆ ಫಸ್ಟ್ ಕನ್ಸರ್ನ್ ವಿಲ್ ಪ್ರೊಟೆಕ್ಟ್ ದ ಚಿಲ್ಡ್ರನ್. ಹೋಗಿ ಅವ್ರ ಹತ್ರ ಕೂಗಾಡೋದು ಯಾಕೆ?
ಅಲ್ಲ ಯಾಕೆಂದ್ರೆ my lord, the issue.
How is he responsible for that?
My lord, the
He was not given the custody of the child.
I agree that-
Member Secretary Legal.
What has happened is he leaves his son at 2 o'clock and comes back by 4 o'clock. The normal thing was 4 ಗಂಟೆಗೆ ಹೋಗೋ ಮಗು ಇರೋದು ರಿಜಿಸ್ಟರ್ ಸೈನ್ ಮಾಡಿ ಮಗುನ್ ಕರ್ಕೊಂಡ್ ಬರ್ತಾ ಇದ್ರು. On that particular day, he is not seeing his son there, and his son seeing his son running from a next building.
Education is it should be smooth,
What is he doing?
He is doing business.
How business? What kind of business is
What I
it?
know is he is doing some travel related business. Travel related business. Mysore is basically a tourist state. Doing some travel related. That is what I heard, my lord. I am.
Now after that, no visitation has taken place.
No, now there is no visitation. Because interim order is
What has
vacated.
happened in the criminal case?
It is pending, ma'am.
Well,
Against that proceedings also a petition is pending before.
petition is filed
Yes.
there.
Yes,
ಏನಾಗಿದೆ ಅದ್ರಲ್ಲಿ ಏನಾದ್ರು
ಅದು pending ಇದೆ, pending ಇದೆ.
interim stay ಏನಾದ್ರು?
ಹೌದು.
ನಮ್ಗ್ ಕನ್ಸರ್ನ್ ಇಷ್ಟೇ.
ಅಲ್ಲ, ನಾನು
ಈ ತರ
I am aware of this. I totally agree with your lordship. ನನಗೂ but ಅದ್ರಲ್ಲಿ ನಾನು appear ಆಗ್ತಾ ಇಲ್ಲ ಅಷ್ಟೇ ಹೇಳಿ.
other day when we were holding because brother was not there, Justice Ponacha was with us. Now ಈ ತರದ್ ಏನಾರು ಕ್ವಶನ್ಸ್ ಅವ್ರಿಗೆ ಕನ್ಫರ್ಮ್ ಮಾಡಿದ್ರೆ the way he was staring at us, ಅವ್ರಿಗೆ ಅಷ್ಟು ಭಯ ಇಲ್ಲ. ಕೋರ್ಟಲ್ಲಿ ಹೈಕೋರ್ಟ್ ಅಲ್ಲಿ ಬಂದು ಹೈಕೋರ್ಟ್ ಜಡ್ಜ್ ಚೇಂಬರ್ ಗಳಲ್ಲಿ ಈ ರೀತಿ ಮಾಡ್ತಾರೆ ಅಂದ್ರೆ ಹೌ ಇಟ್ ವುಡ್ ಬಿ ಸೇಫ್ ಟು ಲೀವ್ ದ ಚೈಲ್ಡ್ ಇನ್ ಹಿಸ್ ಕಸ್ಟಡಿ? ಅದೇ ಕಲ್ಕೊಂಡ್ರೆ ಮಕ್ಕಳು ಏನ್ ಮಾಡೋದು?
Grateful to your lordship's concern, but I would say that ಮಗನ್ ಮೇಲಂತೂ ತುಂಬಾ ಪ್ರೀತಿ ಇದೆ, what I can see from him. With whatever little 2-3 occasions I met.
ಪ್ರೀತಿನೋ ಪೊಸೆಸಿವ್ನೆಸ್
ಇಲ್ಲಿ ಅವ್ರದ್ದೇನು ಕಾಂಟ್ಯಾಕ್ಟ್ ಇತ್ತು my lord, I will.
ಬೇರೆ ಯಾವ್ದೋ ಮೆಟ್ರಿಮೋನಿಯಲ್ ಕೇಸಸ್ ಯಾವ್ದು ಪೆಂಡಿಂಗ್ ಇಲ್ವಾ? ಏನಾದ್ರೂ ಮೆಟ್ರಿಮೋನಿಯಲ್ ಕೇಸಸ್ ಪೆಂಡಿಂಗ್ ಇದೆಯಾ?
ಇಲ್ಲ.
ಆಯ್ತು, ಇಲ್ಲ ಅಂದ್ರೆ ಒಂದ್ ಕೆಲಸ ಮಾಡಿ, ಕರೆಸಿ ಅವ್ರನ್ನ ಇಬ್ಬರನ್ನು ಕರೆಸಿ ಅದನ್ನ ಅಂದ್ರೆ ರಿಯಲೈಸ್ ಮಾಡ್ಕೊಂಡು ಏನಾದ್ರೂ ಇಬ್ರು ಶೇರ್ಡ್ ಪೇರೆಂಟಿಂಗೋ ಅಥವಾ ಏನು ಸಮಥಿಂಗ್ ದಟ್ ಲೇಡಿ ಹ್ಯಾಡ್ ಟೋಲ್ಡ್ ವಿ ಡೋಂಟ್ ರಿಮೆಂಬರ್ ಕನ್ಸಿಲೇಷನ್ ಅಲ್ಲಿ ಏನ್ ಹೇಳಿದ್ರು ಅಂತ ಹೇಳಿ ವೈ ದೇರ್ ಇಸ್ ನೋ ಚಾನ್ಸ್ ಆಫ್ ರಿಯೂನಿಯನ್ ಈಗ ಒಂದು ಕ್ರಿಮಿನಲ್ ಕೇಸ್ ಬೇರೆ ಆಗಿದೆ.
Yes. My lord, if I may be permitted to say, my lord,
Yes.
when your lordship met him in the chambers, she said, my lord, he is having some relationship.
Some
Yes,
extra
yes, yes.
These cases, my lord, taking on submissions of parties with the face value, I personally, my lord, if I was not there, I will not take the submissions on face value, my lord, at this stage, my lord.
ಎಷ್ಟೋ ಹಿಂದಾಗಿದ್ದಲ್ಲ ನೆನಪಿಲ್ಲ.
Face value, ಅವ್ರೊಂದು allegation ಮಾಡ್ತಾರೆ, ಈ family matrimony dispute, you are
Correct.
not much more.
ಈಗ
this kind of
client,
allegation of face
your
value.
client neither has applied for divorce nor for restitution. Only he wants to hold on.
What discussions I had with him, immediately after ಒಂದು ಮದುವೆ ಆದ್ಮೇಲೂ there was some disputes between them, she had gone, he had brought her back and all that. Then after that ಮಗು ಆಯ್ತು, ಮಗು ಆದ್ಮೇಲೂ 3 ತಿಂಗಳು ಆದ್ಮೇಲೆ ಬಿಟ್ಟು ಹೋಗಿದ್ದಾರೆ. What he told me, I am not sure, this is only
What is
submission
her
that he
qualification?
had made a couple of attempts, then
What
there
is
is
her
some.
qualification? ಅವ್ರು ಆಕೆದ qualification
Qualification may be, my lord, PUC or degree.
ಬಂದಿದ್ರು ಅವಾಗೆಲ್ಲ ಕೇಳಿದ್ವಿ, we don't
Yes.
remember now at this point of time. Is he qualified?
I'm not sure.
My lord, my information is that, my lord, his mother is a retired employee. He is depending on her income. My lord, he has stated, my lord, he is in a travel business, not even the name of the travel business is meant, travel company. He simply says travel business.
Not make any allegations.
What is
ಯಾರು ಗೊತ್ತಿದೆ, we are
what is the source of his income? Travels ಅಂದ್ರಲ್ಲ, correct, any GST, any this thing, is it there with him?
not, well, I can ask him to produce.
Nothing.
ಇನ್ನೊಂದೇನಂದ್ರೆ ಮೈಸೂರಿನಲ್ಲಿ, ಮೈಸೂರು being a tourist hub, my lord, you are aware. Even ಹೇಗೆ ಅಂದ್ರೆ, because I studied in Mysore, my brother-in-law has a hotel in Mysore, has a lodge in Mysore, as well as a restaurant in Mysore. I will say, my lord, there are people who earn money more than thousands in a day. How? 4 ಜನನ್ನ ರೂಮ್ ಕರ್ಕೊಂಡ್ ಬರ್ತಾರೆ, ₹1,000. There are many ways of earning money legally also.
Many ways of beda, he should have some
Legally is what I'm
legitimate source of income.
That is what I am saying, and with whatever I know, that is a own house that they have. He says, I am not sure, he says that he is having a travel business and he is doing well. That is what he says. ಮಗುನ್ ಒಳ್ಳೆ ಸ್ಕೂಲಿಗೆ ಸೇರ್ತಿದ್ದಾರೆ, ಒಳ್ಳೆ ಸ್ಕೂಲಲ್ಲಿ ಓದಿಸ್ತಾ ಇದ್ದಾರೆ. That is not an issue.
ಏನ್ ಕೊಡೋರು ಮೈಸೂರು, ಇಬ್ರು ಮೈಸೂರಲ್ಲಿ. Because of these are unusual things ಅಲ್ಲ, ಅದಕ್ಕೆ ಅಷ್ಟು ನೆನಪಿತ್ತು. She is from ಪಿರಿಯಾಪಟ್ಟಣ, ಬೆಟ್ಟದ ಪ್ರಾಂತ್ಯ. ಕಾಸು ಬೇರೆ ಮೇಡಮ್. ಎಲ್ಲ ಇಷ್ಟು ಡೆಪಾಸಿಟ್ ಮಾಡಬೇಕು. ಡೆಪಾಸಿಟ್ ಮಾಡಲಿಲ್ಲ ಅಂತಂದ್ರೆ ಹೆಲ್ತ್ ರೈಟ್ ಆಫ್ ಇಂಟ್ರೆಸ್ಟ್ ಅಂತ ಮುಗಿಸ್ತೀವಿ.
What is the distance? ಈಗ ಅಲ್ಲಿಂದ ಅಲ್ಲಿ ಖರ್ಚು ಎಷ್ಟಾಗುತ್ತೆ? ಪಿರಿಯಾಪಟ್ಟಣ ಟು ಮೈಸೂರು?
Tirupatna to Mysore.
Mysore 45 minutes, 45 minutes.
Distant place. It is a distant place only from Mysore, we remember. ಅದೇ ನಿಮ್ Google ಅಲ್ಲಿ ಹಾಕಿ ಗೊತ್ತಾಗುತ್ತೆ ಎಷ್ಟು ಕಿಲೋಮೀಟರ್ ದೂರ
Not
ಇದೆ.
too far, man. Maybe 30-35 kilometers.
35 ಜಾಸ್ತಿ ಇದೆ.
ಹುಣಸೂರು ಆದ್ಮೇಲೆ ಪಿರಿಯಾಪಟ್ಟಣ ರೀ.
ಅವ್ರಿಗೆ ಗೊತ್ತಿರುತ್ತೆ, ಅವ್ರಿಗೆ
45 kilometers ಹುಣಸೂರಿಂದ ಪಿರಿಯಾಪಟ್ಟಣ. Hunsur is about 45 minutes, ಅಲ್ಲಿಂದ 1.5 hour ಆಗುತ್ತೆ.
ಲಾಸ್ಟ್ ಇದೆಲ್ಲ ಬರುತ್ತಲ್ಲ ಬೈಲ್
ಪಿರಿಯಾಪಟ್ಟಣ ಮತ್ತೆ ಕುಶಾಲನಗರ. So 1.5 hour ಆಗುತ್ತೆ, 1.5 hour ಆಗುತ್ತೆ ಮೈಸೂರಿಂದ.
if at all we have to take any lenient view for
1 hour 30 minutes are.
yes, we are aware because we worked there twice. 2 times we have worked there. ಅಲ್ಲಿ ಬರ್ತಿತ್ತು.
I'm aware of it.
ಅದು ಏನು ದೂರ ಇದೆ ಪಿರಿಯಾಪಟ್ಟಣ.
School the child is going now? ಯಾವ ಸ್ಕೂಲ್ ಹೋಗಿ ಮಗು?
Maisooralli hospital.
ಈ ಕೇಸ್ ಮುಗಿಯೋವರೆಗೂ ವಿಸಿಟೇಷನ್ ನಾವು ಅರೇಂಜ್ಮೆಂಟ್ ಮಾಡ್ಬೇಕು ಅಂದ್ರೆ she has to come from ಪಿರಿಯಾಪಟ್ಟಣ. He has to pay the cost of this litigation and next litigation, and every time she comes for visitation he has to provide for her whether your client is ready, and the application will be should be disposed of within a time bound manner.
That I am aware, my lord, because ಅವರೇ petition file ಮಾಡಿರೋದು ಮೈಸೂರಲ್ಲಿ. It is not that I have filed.
ಹೌದು, ಯಾಕಂದ್ರೆ ಮಗು ಅಲ್ಲಿತ್ತು. Are you aware where the G&W case has to be filed, where the child is there she has to file there.
ಅವರು ಮೈಸೂರಲ್ಲೇ ರಿಸೈಡ್ ಆಗಿದ್ದಾರೆ, ಪಿರಿಯಾಪಟ್ಟಣದಲ್ಲಿ ಇದ್ದಾರೆ ಗೊತ್ತಿಲ್ಲ. As of now ರಿಸೈಡ್ ಆಗಿ.
Council, this is, we are tentatively considering this, notwithstanding his unruly behavior.
And we keep this question open.
We do not want
If
this
we conduct
unruly
C-
behavior to come in the way of dispensation justice, but then that's a matter to be considered.
Grateful.
In case if he repeats this behavior,
This will be open,
this matter will be reconsidered again. If he behaves in the same manner with the officers whose matter, handling the matter,
Yes,
no mercy will be shown to him.
yes.
We do not want that issue to, that's what we discussed, that issue should not come in the way of dispensation of justice.
Yes.
But then that is not closed, number one. Number two, he stays in Mysore, she stays in Pirapatna.
ಅಲ್ಲ ಅದು ಗೊತ್ತಿಲ್ಲ ಕರೆಕ್ಟ್ ಆಗಿ ಕನ್ಫರ್ಮ್.
Address.
ಅಲ್ಲ
Yes.
Address ಇದೆ ಇಲ್ಲಿ.
But I think she is staying in some of relatives place in
All right,
Mysore.
wherever it is.
ರಿಲೇಟಿವ್ಸ್ ಮನೆಯಲ್ಲಿ ಇದ್ರು ಮತ್ತೆ ಅದು ಯಾರ್ದಪ್ಪ
Now,
ಬೇರೆಯವ್ರ ಮನೆ
No, Lord, that is the address I have furnished in my affidavit
all right,
also.
now, we will take the.
ಇಲ್ಲ ಒಂದ್ ನಿಮಿಷ ಡಿಪೋಸಿಷನ್ ಇದೆ ನೋಡ್ತೀವಿ ರೀ.
Not to
Only
dispute, I am only asking to inquire.
ಅಲ್ಲ, asking ಅಲ್ಲ. ನೀವು-
Okay.
When you have come and record, you should look into the deposition and record.
Information ಕೇಳಿದ್ರು ಮೈಸೂರಲ್ಲೇ
ಅದೇ,
ಅವ್ರು ಇದ್ದಾರೆ.
ಡಿಪೋಸಿಷನ್ ಅಲ್ಲಿ ಈ ಕೇಸಿಗೆ ಬಂದಾಗ ಯಾರ್ದಾರ ಮನೆಯಲ್ಲಿದ್ರೆ, ಈಗ ನೀವು ಹೋಗಿ ನಿಮ್ ರಿಲೇಟಿವ್ಸ್ ಮನೆಯಲ್ಲಿದ್ರೆ ಇಸ್ ಇಟ್ ಅ ಮ್ಯಾಟರ್ ಆಫ್ ರೈಟ್?
Lord, not to dispute, Lord, what I am saying is, what information I got was.
ಇಲ್ಲಿ
staying
ಡಿಪೋಸಿಷನ್ ಅಲ್ಲಿ
ಅವ್ರ ಅಂಕಲ್ ಮನೆಯಲ್ಲ ಮೈಸೂರಲ್ಲೇ ಪರ್ಮನೆಂಟ್ ಆಗಿದ್ದಾರೆ ಅಂತ
Irrespective, cost,
ಮನುಷ್ಯ ಅಂತ ಮತ್ತದು ಹೇಳೋ ಆಗಿಲ್ಲ ಕಂಡೀಷನ್. ಆ ಕಾಸ್ಟ್ ಕೊಡ್ಬೇಕಾಗತ್ತೆ
a cost, and then you will have to file objections, finish your evidence,
On
tender
the
against
date
the
of
cross
appearance
examination.
only, we fix a date, you have to appear with the objection statement. And we'll make arrangements for visitation also in the same premises. ಹೇಗಿದ್ರು ಫ್ಯಾಮಿಲಿ ಕೋರ್ಟ್ ಅಲ್ಲೇ ಇದೆ ಅದು. ಫ್ಯಾಮಿಲಿ ಕೋರ್ಟ್ ತಾನೆ. Anyway, there will be supervision of the officer also, if that is. Even a complaint exhibit P5 kuda, her address is shown in 2021 as Bettadapura only.
ಅಲ್ಲ ನಾನು ಏನಕ್ಕೆ that I am not disputing, Lord, what I am saying is, what I heard was she is residing with her uncle in Mysore ಅಂತ ಅಷ್ಟೇ ಕೇಳಿದ್ನ, ಅದಕ್ಕೆ ಕೇಳೋದು. If he is coming from Piriyapatna, whatever is the expenses that I will speak to my convent instructions on that. There is nothing like that.
ನಾಳೆ ಹಾಕೊಂಡು ಮಾಡ್ಬೋದಾ? Tomorrow.
So you get instructions.
All possible indulgence we are showing.
I am grateful to your lordship, Lord. I will just to recollect what your lordship wanted. One, her expenses for travel from Piriyapatna to Mysore, whenever the case is listed.
No, visitations.
Hello, whenever the case is listed and whenever the visitation has to be done on both occasions. Two, your lordship said that he has to pay her the cost of this litigation.
Because just visitation ಮತ್ತು ಕೇಸು ಒಂದೇ ದಿವಸ ಆಗೋದಿಲ್ಲ. Generally, a child is studying, no?
That is why I said both. That is why.
Child is studying. ಬಹುಶಃ Saturdays ಇಂಥ day.
That is why I said both times.
Yes.
And then cost of this litigation and cost of the litigation for the trial.
Trial
court.
court.
These are the 4 things I will get instructions on that.
And that has to be deposited in advance.
On the day he appears, he has to deposit the cost of this case and cost of the trial court.
That's what I will get his instructions.
25,000 each.
I will get his instructions.
ಅದು ನೋಟ್ಸ್ ಇರ್ಲಿ ನಿಮ್ ಕೇಸಿಂದ ತಾನೆ ಅದಕ್ಕೆ ಸೇರಿಸ್ಲಿಲ್ವಾ? ಇಲ್ಲ ಇದಿದ್ರದೇನೆ ಡೇಟ್ ಆಫ್ ಬರ್ತ್ ಅದೆಲ್ಲ ಬರ್ಕೊಂಡಿದ್ದೀನಿ ನೋಡಿ. 14% ಏನೂ ಮಾಡಿಲ್ಲ. They should buy piece, why they do it?
And I will also suggest that.
ಇಲ್ಲ hard in part ನಾಳೆನೇ ಹಾಕೊಂಡು ಡಿಕ್ಟೇಷನ್ ಮಾಡಿಬಿಡ ನಾಳೆ tomorrow will dictate the order subject to I mean you should take instruction not subject to this is our I mean tentative this thing this
Tomorrow at 2:30 we will
2:30 we have already ನಾಳೆ ಯಾವ್ದೋ 2:30 ಗೆ ಹಾಕಿದ್ವಲ್ಲ ಅದನ್ನ ಇವತ್ತಿನ ಪಾಠ ಅದು ಇನ್ನೊಂದು 2:30 ನಾ 2:30 ನಾಳೆ ಯಾವ್ದು ಇಲ್ಲಲ್ಲ 2:30